Mention tomorrow, not tomorrow. Mention tomorrow.
Yes.
Yes.
Yes, sir. Yes, sir.
Tomorrow you mention.
Supplemental list, item number 1.
And
Be the counsel here. Oh, in the English to engage कर दो. ना देखो तो as per the order dated 2/9/2025, another report has been submitted by the officer in charge, Jamda Police Station, District Malvan, which is dated 10/9/2025, to show that the appellant is alive. And is staying in village Sunapassi, under Rairangpur Police Station in the district of Malvan. None appears of Paragodland. None appears for the appellant, who also is enlisted as the counsel for the appellant. Copy of the paper book be supplied to him, matter be listed. Yes.
Item 2.
Appellant.
My second, it has not moved. It has about not. But and it has not moved with the. Yes, but I should not. The chapter for this one. I do. And but those who are this of this one. I'm not very off preserving. Not to the feelings for
So, Mr. Nayak, the second item, Criminal Appeal 44 of 2002. One report we received from IIC Udola Police Station. We are not satisfied. Again, we call for another report. And in the first report also, it is stated that whereabouts is not known.
it IG administration to me.
Gradually, report would have gone until
Always you seek it from IG administration. That is the right way.
We passed the order on 2/9/2025. After perusing the report dated 7/8/2025, IIC Udola Police Station to submit a press report. As in the earlier report, it was mentioned that the whereabouts of the appellant, Shirot Kumar Raut, is not known. In the press report dated 10/9/2025, IIC Udola Police Station has also repeated the same thing, that the present whereabouts of the appellant is not known. We are not satisfied with such a report. Let the Guardian Council for the state obtain instruction about the whereabouts of the appellant to the IG administration and produce it on the next date, which is fixed after vacation first.
Item 3.
Pardon.
Item 3.
That's it.
I'll leave. Just put it in 99. Bill contractor and a director of Holland.
I looked at inquiry regarding the building of Swan for the inquiry for the second that they are planned. Swan so that doesn't stay in Swan.
Not a cell number.
Is maintaining livelihood of John is a single apply.
Single.
Telephone. As for order dated 2/9/2025. This report has been submitted by IAC Bir Maharajpur Police Station, which is at Flaggy, so that the petitioner is alive. Yes, anybody is appearing for
Yes,
Swan?
Lord. I'm appealing for the update.
You're a bit.
Yes, Lord.
All right. Have you received the paper book?
Yes, Lord.
The land council. What is your good name?
Vishwaranjan
Vishwaranjan?
Sahoo.
You have no power in this case?
Your Lordship, on behalf of Mr. Vishnu Prasad Pradhan.
Acha. Not I. Honestly, again, urgent sleep is and I'll appeal it. So on so appearing for Mr. BP Pradhan submits that the paper book has been received and the matter may be taken up after ensuing to job vacation for hearing. Because this matter is good. Okay. Yes.
Item 4.
Some formal against the order. The NHA is filed review. The review has already also been listed today in item number 17 and 18.
Okay, we hear together. All
Thorough.
the sub matter review petition file is.
Right.
So here the review and if it is come to the review then.
Thank you.
Yes.
Madam, my lord friend has sought the clear the objections in the review petition. In the review application, my lord, short delay is there. In some
Review
cases,
petition?
4 to 5 days, in other cases.
Just a minute. Let us see. Review petition, okay, there is a application for condonation of this.
Yes.
How much delay is there?
17 days in fast method.
Lordship, there are different days of delay in different.
Different method.
petition.
So we are condoning.
9 days, yes. Lordship, condone the delay.
Just a
Fix it for hearing, yes.
IA number so and so, there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 17 days in filing the review petition. Land counsel for the opposite parties submit that they have no objections if the delay is condoned.
Yeah.
After hearing the land counsel for both the parties, the delay as pointed out by the stamp reporter in filing the review petition is condoned. IA is disposed of. So review petition copy all of you have got.
Madam.
You have also got.
Your Lordship, I filed objection to the limitation petition, Your Lordship. Because,
Unless it will delay the matter, ma'am.
Yes,
So-
Your Lordship, but it's compensation matter and the matter has been lingered, Your
No,
Lordship.
we are hearing the review petition. We just want that, have you received the copy of the law?
Yes,
So
Your
if you have
Lordship.
received the copy, is सब गुड़ाकर matter condonation of delay अछि. Time समान की ना
ना,
अलग
अलग
अलग. अच्छा ठीक है लिखी देबो. Then have you given the copy to the of the respect this review petition to all the planning council?
Madam.
So anything you want to file or will directly hear this matter? Any objection you want to file to the review petition?
We'll file. We can, Your Lordship
We
can
can
hear the
proceed it.
matter, Your Lordship. Any submission can be.
Objection has been filed to the delay
Limited.
condonation application, so,
Yes, Your Lordship.
but লিখি দেবে ওটা অবজেকশন ফাইল ইসি ডিলে কন্ডেনশন ইনভেস্টিগেশন না কিন্তু এইসব ফাইল গেছি মানে লিমিটেশন এটা yes you can argue the matter if you have given a copy and they have no objection to the hearing you can argue the matter. What is this review for?
Lordship. What I beg bring to my
Which order you are seeking for review? 24/9/2024.
minor.
You come to that order.
Order said 26/9/2024.
It is annexed as annexure,
One minor.
annexure 1.
Relevant portion minor, the page 24 minor.
Yes. Please read it out. See that.
Lordship, I clarify my lord before I'm placing the
When you
input.
place the order,
Read it.
first
First you-
read it
just
and then
recollect.
make your submission.
My lord, Lordship has recorded the petition you Satyanarayan and so filed this writ petition seeking to direction to the opposite party 1 and 2 to pay the compensation to the petitioner toward the structural cost cover plot number so and so a Moja Kalapan in all district Vargad which has been acquired for the purpose of four laning of Sambalpur, Vargad, Orissa, Chhattisgarh, so and so. On perusal of the letter of the collector Vargad of P number 3 at 18/6/2019 addressed to the General Manager Technical NHA order number under Annexure 3, it appears that the occupiers who have constructed the structures shall not vacate the structures by any means without payment of compensation of the structure, which have been assessed by the executive engineer R&B Vargad, Opil number 5. In the said letter, the NHA authorities were asked to take decision for providing compensation toward the structure situated over the acquired land to the persons who have constructed and are in physical possession before vacation of the acquired property immediately for enabling the NHA authorities for construction and widening of NH6 road without any problem in course of taking possession. And counsel for the petitioner drew the attention of the court to Annexure 4, which is the valuation report submitted by the opposition of 5, in which the name of the petitioner finds place at a serial number 11, the khata number so and so, and the structure value has been assessed at rupees 20,26,627. On counsel further submitted that in spite of valuation made by the OP number 5 and submitted before the NHI authorities, till date the petitioner has not received any compensation. Rather, the authorities are taking steps for vacating the petitioner from his plot. In view of the letter of the collector Vargad under Annexure 3 and the valuation report furnished by the executive engineer and the Vargad of 3 under Annexure 4, and after hearing the counsel for the Union of India, we direct the NHI authorities to take immediate steps for payment of compensation to the petitioner as per the valuation report. Within a period of 1 month from the date of production of certified copy of this order, before taking any steps for vacating the premises, the NHA authorities shall also communicate the order to the concerned authorities for compliance with this observation and direction the institutional disposal.
So what is the scope of review?
My lord, what I beg to submit, my lord, also you can see the notification at page Annexure 2. The original compensation assessed by the Kala Vargad has already been paid to the original landowners. As per
Is
the
this not the letter which has been mentioned that they are the structural value is this 20 lakhs so and so?
Not that
Have we stated anything further? It is the letter of the authorities and it is the collector has stated that this is the thing which what
my
we
lord,
have done.
my what I beg to submit, my lord, as per this scheme of the NH Act, my
I don't
lord.
know, whatever it may be there, the scope of review is what?
So regarding because the compensation has already been paid.
No, it has not been paid. That
No,
was
regarding-
that was your case before this court. When the matter was submitted, the admitted fact is that the counsel for the petitioner submitted it has not been paid. The other side also said it has not been paid.
No,
As
nobody
per
has-
the evaluation
My
report.
lord, nobody has brought to my lord's notice regarding the payment of compensation already, my lord, to the original landowners. That is, I have annexed that.
No, no.
This
No, with
document-
regard to the structural,
It's a question
you
of structure.
kindly see structural, against
Structure-
structure.
This structure compensation,
Hmm.
after this is lordship can for moment, my lord, the payment was made
So
on
was that
18
this
2014.
20 lakhs 26,000 and 627 has been paid.
Where
But
is that?
No, only the land compensation assessed by the land acquisition officer under Annexure 2 has paid page 43 under Annexure 3, my lord, to the original landowners. they have made the consciously the original landlords a party before my lord. Now the compensation as recommended by the collector, that is not as per the permission under the statutory provisions, my lord.
No. Have you challenged that collector's order?
The collector order is the only recommended, my lord. That is no. The collector has
No,
no
why
power.
why the recommendation then?
My lord, the collector has so far the provision is concerned with 3G5.
Yes.
Collector has power to adjudicate the matter and giving opportunity to the all parties and decide the same under section 3G5 whether any person is entitled to compensation or not. That has not been ever done.
So there is an assessment. According to you, you have not been given an opportunity of being heard. If that is so, have you challenged it?
Collector has specifically stated in the letter dated 18/6/2019 that we have mentioned in the second paragraph, which is addressed to you, that the occupiers have constructed
Yes.
structures
Yes.
and they shall not value these, they shall not vacate the structures without payment of compensation of the structure.
Structures.
Then the structures were valued. It came to 20,26,627. So we just passed the order.
This
You
is-
pay the
Madam,
amount
this-
of structural value so that they will. That
Madam,
is
what I
simple and
say-
simple order.
My lord, by
You are not challenging the order of the collector.
The
You
collector-
are not challenging that the valuation report is of the higher side.
The collector order is not a quantification or the recommendation was as per section 3G5. Collector only said the steps were taken compliant to direction of the Supreme Court to take steps who has the unauthorized occupation.
Yes.
These petitioners are unauthorized occupant
All right.
over the NS land, which
There-
has already been.
Collector is not giving anything for the compensation against the land, only for the structures.
Well, structure, my lord,
Tahsildar is-
well, what I beg to submit, my lord, the collector had lordship and page 57.
Are the land counsel for the petition and counsel for the state? This
Lordship, page
review
49,
petition has been
59
filed
kinds
by
similar.
the petitioners for review of the order dated so and so.
My lord, page 59 for a moment.
59
ଆଜ୍ଞା
କଣ ଅଛି
ଯୋଉ
59?
କଲେକ୍ଟର କଣ ଲେଖିଛନ୍ତି ତାଙ୍କ ଅର୍ଡର ଦେଖନ୍ତୁ
ଆପଣ ଚ୍ୟାଲେଞ୍ଜ ତ କରୁନାହାନ୍ତି ଆଉ ଯାହା
When
କଲେ
the-
କଣ ହବ?
when the
You
matter
should have
was-
challenged it.
This matter was disposed of on 24/9 2024, and the following order was passed, Pura Court for the Grant Avenue. Admittedly, the letter of the collector Burgard, opposite party number 3, dated 18/6/2019, which has been addressed to General Manager Technical NHI, was not challenged by the review petitioners. Similarly, it has not been challenged that the structural value which has been assessed to be so and so is on the higher side. Therefore, the order which has been passed after perusing the letter of Collector Burgard, so also the valuation report furnished by the executive engineer R&B Burgard, cannot be said to be erroneous. The review jurisdiction is like this. We do not find it also dismissed.
lordship regarding payment regarding lordship observe that now the original landowners have already received their compensation.
All the review petitions stand dismissed. So separate for them. And contempt petition.
But I may wait, my lord, lordship opposing grant more time to my lord to
Contempt petition heard the land counsel for the petitioner. The ground has been taken that the review petition has been filed. However, today we have dismissed the review petition. Issue notice to the so and so. Requisites for issuance of notice be filed within a week. Matters be placed. Date fixed up.
This is my lord the
Lordship, contempt.
where they say look the person is not there, lordship has already deleted his name, Sunil Kumar Te.
Nahi.
We have to add a new person as party member.
It has been
Item 4.
amended, your lordship.
Amended ହେଇନି ସେଇଟା ଏଇଟା
Consolidated first title पर file କରିଛନ୍ତି.
4 ରେ ଫାଇଲ
ହଁ
4 ରେ ସୁନିଲ କୁମାର ଗୁପ୍ତା
ସେପଟେ ଯାଇକିନି କଣ ଅଟ୍ଟା କୁମାରୀ
एकटा कुमार ସେମିତି କି ଲୋକ ନା ମାର ଯିଏ
କୋଉଟା
Lordship, that is the instruction we got.
ଇନଷ୍ଟ୍ରକ୍ସନ ହେଲା ସେ ଲୋକ ନାହାନ୍ତି ନାଇଁ ସିଏ ବୁଝିବେ ଆପଣ ତ ବର୍ତ୍ତମାନ ଆପିୟର କରିନାହାନ୍ତି କଣ୍ଟେମ୍ନର ପାଇଁ ନା ନୋଟିସ କରିଦିଅନ୍ତୁ ସରି
नहीं ये लॉर्डशिप has issued and my lord friend Mr. Senior Counsel Amitabh Das Sapiran the item number 4.
So,
You are directed for serving copy on Mr. Amitabh Das. Item 4. In other matter, I will file so called matter.
file show করে তাহলে নোটিস করবেন সব ম্যাটার এই ଯୋଉ ଏଗୁଡାକ ସମସ୍ତେ ଆପଣ କୋଉଟାରେ ଫାଇଲ କରିଛନ୍ତି ଫାର୍ଷ୍ଟ ମ୍ୟାଟରରେ ସେକେଣ୍ଡ ଆଇଟମ ନମ୍ବର 5 ରେ କି ଫାଇଲ କରିଛନ୍ତି
Item number 5.
Item 5 ରେ my lord name.
5 is not one of those contempts.
This is a different matter.
Item 5.
Item 4 is connected to 17 and 18.
Lordship, item 4 and 18. There are two contempts.
4 and
18.
আচ্ছা এটা করে দেবে 4 and 18
18.
Again, offensive type.
just a minute তো ଆପଣ ଅଲରେଡି appear କରିଗଲେଣି
Yeah, file show called in that.
ସୋ ଆଜିରେ କହିବେ ଆଚ୍ଛା ଆଜିରେ ଲେଖି ଦିଅନ୍ତୁ ଇସ୍ୟୁ ନୋଟିସ୍ କରିଦେଇକି ତାପରେ ଲେଖନ୍ତୁ ଉମେଶ ଚନ୍ଦ୍ର ମହାନ୍ତି ଲ୍ୟାଣ୍ଡ କାଉନସିଲ submit that he has instruction to appear for the contempt put item number 4 recorded
The 4 Mr. Amitabh, the my lord friend is.
4 ରେ Amitabh, ଆପଣ 18 ରେ
18
अमिताभ दास अच्छा
4 ରେ।
और अच्छा ऑलरेडी एंटर्ड अप नहीं एंटर्ड अपीयरेंस
नहीं,
करछन
दे-
से आप पाई से जो सुनील कुमार पाई
सुनील कुमार नाहाती से
अरे वर्तमान पाई से कोन अपीयर करिवे से इंस्ट्रक्शन लेबे ना नोटिस जीवो हां
इंस्ट्रक्शन नहीं.
Instruction.
अच्छा लिखंदु मिस्टर अमिताभ दास लैंड सीनियर एडवोकेट shall obtain instruction issue notice कला पर एथिकल whether he intends to appear for the contemptor कोनता ना धाउची अट्टा अट्टा कुमार है ना और नॉट मैटर लिस्टेड से कर देबे शो ऑप्शन এটা হচ্ছে 4 নম্বর আর তারপরে 18 নম্বরে লিখি দেবে যে ইস্যু নোটিস করে দেবে আদের অলরেডি অ্যাপিয়ার করছেন টাইম মাগুছেন টু ফাইল দি শো কজ এটা ছুটি করে রইব হলা বাকি তারপরে ইয়েস আইটেম নম্বর 5 यार जो कंटेंट पिटिशन रो डब्ल्यूपीसी ट्रिपल ए जो 4/2/8/2024 रो को रिव्यू पिटिशन अराइज करथिला
Then item 17.
Item 5 is not review.
जस्ट अ मिनट वी आर आस्किंग यू समथिंग नो डोंट अच्छा एटा होची ए देखो
और जब तुम्हारा रिव्यू करता 293/24 आइटम 4.
এটা হচ্ছে 293 রিভিউ পিটিশনটা এই যে 4 নম্বর সহিত कनेक्टेड होची रिव्यू
293
पिटिशन हैला 293 ऑफ 2024 हैला पाइले ना तापर हैला नेक्स्ट क्वेश्चन कंटेंट पिटिशन हैला 1073 ऑफ 25 यारो
First time we allow some time to take instruction.
173.
and the review petition 8/25
अगर रिव्यू पिटिशन ना कितने नंबर
8/25 कोमल गुप्ता
8/25
That is of item 18, Your Lordship, contempt.
About 18 item.
नहीं नहीं कंटेंट पिटिशन को देखो यार से कौन कंटेंट पिटिशन नंबर होची 1073 ऑफ 25 that arises out of 22414
That is a state related to state, man.
जहां भी हो
The way
तार
from
रिव्यू
last time
पिटिशन
it-
फाइल हिची की
No, man,
No,
no.
no.
और रिव्यू पिटिशन फाइल हेनी ताले एटा कर दियंतु स्टेट टू ऑब्टेन फाइल दिस शो कर है ना तापर नेक्स्ट ऊपर आसुन
6 of the
कंटेंट
state.
पिटिशन 1074
Same.
तार हला
Same.
सेम
Same.
आज रिव्यू पिटिशन फाइल हेनी अच्छा छाड़ दियन तापर नेक्स्ट को आसुन कंटेंट पिटिशन 2085 ऑफ 25 तार कनेक्टेड हला
20 complaint. 2085 complaint.
दियन डॉक्यूमेंट में 7th of October.
But item 5 and 6 notice is
Wait. 5 and 6 कौन कूद रहा
दिया हला पूरा instruction पे
वो हला पूरा इंस्ट्रक्शन पे छुट्टी पड़ रहेगा
Aaron or a
एटा लिखंदु आइटम नंबर 7 लिखंदु This writ petition the content petition arises out of non-compliance of the order dated 16/12/2024 passed by this court in WPC number 31407 of 2024. The Learned Counsel, what is your good name? Nando. Appearing for the contemner has produced the letter dated 12/9/2024. Sorry, 12/9/2025. Take addition on the representation made by the so pass appropriate order. Eta kahar nata so in the to state that toward the decretal amount in favor of issuer. এটা হচ্ছে এলএ কেস নম্বর কেতে কন্টেম্প্ট না 2085 হ্যাঁ এটা 2085 ঠিক আছে হলো produce the compliance report which is taken on record. Accordingly, the content petition is disposed of. Yes, 8 number tahala WPC 27903 of 24. नहीं compliance है नहीं तादरे
notice proof of submission file करे last date रे
हाँ
जो communicate है इस order टा
file 8 number file करछि
documentary proof has been
copy हमको दे दें
Yes, the order was passed that you are to produce the documentary proof relating to the communication of the order. कारण से order टा थिला to take a decision within a period of 3 months. It also we dispose of the writ petition. Once you take a decision, So you have stated in your petition in paragraph number 3 that the certified copy of the order has been communicated to the opposite party contender on 3/1/2025. So तार document
टोटल रिसिप्ट तो देई था
नहीं
फिर मेमोरी देई 8 नंबर
अच्छा इटा दे
हमको टा copy दे
all right लिखो the as per the order dated 2/9/2025 the Learned Counsel for the petitioner has produced the postal receipt dated the postal receipt dated 3/1/2025 with a memo to show that the order dated 14/11/2024 passed in WPC number 27903 of 2024 has been communicated to the opposite party contender. Stop. The Learned Counsel for the state seeks some time to obtain instruction put of this matter on Chutti Bhargava. Now next person.
Item 9.
This is
more time to comply with our custom.
ଏଗୁଡ଼ା ତ ସବୁ ଆପଣଙ୍କର
ସବୁ ବୁଝିବ
କେବେ କେବେ ରଖିବା କୁହନ୍ତୁ
आफ्टर पूजा
ହଁ ଆଫ୍ଟର ପୂଜା ରଖିବୁ ଯେ ଆପଣ କୁହନ୍ତୁ ଆପଣ ଆଣିକି ଅର୍ଡର କମ୍ପ୍ଲାଏନ୍ସ ଅର୍ଡରଟି ଦେଇଦେବେ ବାସ୍
मैडम
ୱିଲ୍ ନଟ୍ ସେକେଣ୍ଡ କଣ୍ଟେମ୍ପ ଥାର୍ଡ କଣ୍ଟେମ୍ପ ଏସବୁ ନୁହେଁ
that is the
ଗୋଟେ କାମ ଛିଣ୍ଡିବ
14th
14th
14th of it.
so this is 9 to 15
9 to 15
9 to 15 the Learned Counsel for the state.
गला था अभी तो
Hmm?
22 2850 गोटे नंबर रहल
କୋଉଟା
जो लॉर्डशिप से अछन
ହଁ
2850
ଆଜି ଆସିନି
ना
ଆସିନି ତ ମେମୋ ଫାଇଲ ତ ଦେବ ଆସିବ କଣ ଆସିନି ଆମେ କଣ ଅର୍ଡରଟା ଦେଖିଦେବୁ ନା କଣ ଦେଖନ୍ତୁ the Learned Counsel for the state seeks some more time for compliance of the order dated so and so passed in WPC number. Other सब WPC उड़ा अलगा सी order भी अलगा थे पारे है ना this matter on 14th of October. Mr. Naik, 14 तारीख रखुଛି
14-10
अच्छा 14-10-2025 ହେଲା 9 ଠୁ 15 ପର୍ଯ୍ୟନ୍ତ ଖାଲି WPC ଦେଖିବେ order କେବେ ଦେଖିବେ date କିନ୍ତୁ ସମାନ ରହିବ ହେଲା yes next
Item 16.
Defect remove କରିଥିଲା remove କଲା
କୋଉଟା
ଏଇ ଯୋଉ 16 ରେ ଇଏ ବି ଅର୍ଡର କରିଛି ଆଉ ଅଫିସ ନୋଟ ନଟ୍ ରିମୁଭ୍
who is appearing Mr. Subhankar Raut.
Lordship, on behalf of Mr. Sahoo.
Yeah, why have you not removed the defect? The some defects were perhaps pointed out by the what is the defect? Acha, it likha hai synopsis and date chart in alphabetical so and so unnecessarily not described in the petition notice. So these are the defects. On other achi remove kariya.
Synopsis that touch. Synopsis date for touch.
ଅଛି ଆଉ ତାହେଲେ କାହିଁକି ଦେଲେ
Page A and B.
Originated lexical alphabetical
Next
chart.
seven
Annexure 3 not described in the petition. All right, the defects as pointed out by the stamp reporter are ignored. Tapare, this content petition has been filed for non-compliance of the order dated 10/4/2025 passed by this court in WPC number 7791 of 2025. While disposing of the writ petition, we pass the following order. You in view of such received TPA up to such application.
page 17
Say page 17. अच्छा ये आपको कहला जे if such application is filed before the appellate authority shall dispose of so on. तो आपण content petition averment कोट नहीं चंती application file कले बेली अच्छा procedure certified copy अच्छा ठीक है
Request unnecessary.
हाँ in the content petition specific averment has been taken in paragraph number 4 as follows. So in paragraph 4 तक quote कर दे. Land Council अपना instruction लेवल Land Council for the state seeks some time to obtain instruction regarding the compliance of the order of this court dated so on so on. Put of this matter से 14 तारीख को 14th as well.
Okay.
ଏଇଟା ଗୋଟେ ଥିଲା ଆପଣଙ୍କର ଏ ଯୋଉ କଣ୍ଟେମ୍ପଟା ଲାଷ୍ଟ କଣ୍ଟେମ୍ପଟା ଥିଲା 909 ଆପଣଙ୍କର ଏ ଯୋଉ ଆଇଟମ ନମ୍ବର 17 ର ଲାଷ୍ଟ ଦିଟା କଣ୍ଟେଣ୍ଟ ବାକି ତା ପୂର୍ବର ଯେତିକ ସେଗୁଡାକୁ ରିଭ୍ୟୁ ପିଟିସନ ସେଗୁଡା କିଛି କହିଲେନି ଆପଣ ଠିକ ଅଛି ସେ ରିଭ୍ୟୁ ଆମେ ରିଭ୍ୟୁ ପିଟିସନ ଅର୍ଡରଟା ଡାକିଦେଲୁ ସେଇଟା ଆଇଡେଣ୍ଟିକାଲ ହେଇଯିବ କିନ୍ତୁ ଏଇ ଯୋଉ କଣ୍ଟେଣ୍ଟ ଦିଟା ଫାଇଲ ହେଇଛି ନା 879 of 25 तार WPC 23390 of 24 ता अगेंस्ट किसी रिव्यू फाइल ही क्या कितना नंबर देखना थी रिव्यू पिटिशन वाला था ऊपर अच्छी ना 2339024 हाँ इटा फाइल ही 295 बेटा अच्छा अच्छा ताले सेटा को लिखी देवे यार ऑर्डरटा जो देखंतु ए जो पेज नंबर 4 रे कॉज रजिस्टर 879 of 2025 है ना ता ऑर्डरटा हबो आइटम नंबर 4 भलिया साहू बाबू को दे डकाइतला से टाइप रो ऑर्डर था कारण ता रिव्यू पिटिशन ता dismiss ହେଲା ହେଲା ସେମିତି ଏଇଟା ଯୋଉଟା ଅଛି ଏଇଟା ଆରାଇଜ କରିଛି କଣ୍ଟେମ୍ପ୍ଟ ପିଟିସନ 909 WPC ଆଚ୍ଛା ଏଇଟା ହେଲା ରିଭ୍ୟୁ ପିଟିସନ ନମ୍ବରଟା ଲେଖିଦେଲେ ଏଠି ସୁବିଧା ହବ। ରିଭ୍ୟୁ ପିଟିସନ ନମ୍ବର ହେଲା 23390 ହେଲା 23390 ହେଲା 295/2024 2024 ଆରଟା ହେଲା ଏଇଟା ହେଲା 22974
Petition 298, asking 79.
498 22974 ঠিক আছে এটা হচ্ছে রিভিউ
298.
petition 298 of 2024
WPC 22974.
হ্যাঁ সেটা তো ঠিক আছে খালি রিভিউ করছেন প্রথমটা হলো 295 of 2024 আছে খালি এই যে লাস্ট দুইটা এটা সব করে দেবে কন্টেন্ট পিটিশন 879 of 25 তার রিভিউ পিটিশন নম্বরটা হচ্ছে 295/2024 এটা সেই সপ্তাহ নম্বর আইটেমটা সেটা আছে আর বাকি কন্টেন্ট পিটিশন 909 of 25 তার কানেক্টেড রিভিউটা হচ্ছে 298/2024 है ना जिससे ऑर्डरটা হবে আইটেম নম্বর 4 হয়ে যাবে है ना इंस्ट्रक्शन में दो यस नेक्स्ट
Item 18 আছে
18 তো আইলা 18টা পরা 18টা আমি ডাকি দিয়েছি আপনার রিভিউ পিটিশন নম্বর 22798 কইলে পুরা সেতবে
review petition 8 of 2025.
হ্যাঁ সেটা তো কই সেটা অলরেডি সে
It is covered by them.
এই দুইটা তার ভিতরে পসি যাইছিল সেইপাই यस नेक्स्ट 22 का 20 वो पैटर्न में अच्छा मिस्टर दास करो यस मिस्टर
23.
19 item 19
19. 19 টা কার?
affidavit fill up file करबे I have already filed that affidavit
कोड फोन
जो 19 में तो वो इन्फॉर्मेशन थी
information
हाँ।
fill up
फाइली थी
affidavit file করছো
एफिडेविट फाइली थी हाँ से जो जामुझरी
জাম ধরে
कौन आसिला देखो
কালি affidavit file ହେଇଛି ବୋଧେ
कौन
ले,
होना दी
ऑर्डर कर दिया उनको।
जेड़ा मगी दियो मनी कौन था कौन कौन फाइल को कौन सेटा नहीं था एक का सेट तो
ହଁ ଏକା ସେ ଦିଟା
कौन कौन लेक्चर पढ़ो
that as per the order dated 2925 this affidavit in filed that the petitioner applicant C Annu Laguri Naresh Laguri village Tondagura PS Jagannathpur district West Bengal was admitted in the Biju Patnaik open air ashram on 25/12/2009 being a transfer from district jail Keonjhar. As per his application, the said convict was released on furlough leave from 25/10 to 3/4/2010 for a period of 10 days. He was supposed to be returned from such and such dated 4/2010. Unfortunately, he has not surrendered himself till date before the ashram authority after the availing the said. The copy of the application of that Nannu Laguri is filed here with Anisha. That as regard the applicant 2, namely Jamudhar Laguri is submitted that the name of the applicant 2 is mentioned in the sealed bond of the Naresh Laguri is responsible if the issue of the order. It is further humbly submitted that as per the jail register and record, the applicant 2 name Jamudhar Joypal Laguri never been admitted in the Biju Patnaik arrest. That there are two persons. One is the admitted he is transferred to the Biju Patnaik arrest, but so far the Joyprakash Laguri has not been transferred to the. A copy of the sealed bond and agreement copy of the
सिक्योरिटी चल केम छिड़ाला
ये
अपने सिक्योरिटी केम करो यदि सेठी नाही सिक्योरिटी केमती रहला को बेसिस रे ताको सिक्योरिटी करले गोटे जने अक्यूज्ड को केमती आपण अन्य जन पई सिक्योरिटी करिवे सिक्योरिटी किए हुए से सॉल्वेंट पर्सन जे रिलेटेड हबो बा जा जे कि अटेंडेंस सिक्योर करि पाथो गोटे को अक्यूज्ड को सिक्योरिटी करिवे आपण
से भी मध्य ता सिग्नेचर भी देनी से जो सबमिट द
अच्छा तापर कोन
डॉक्यूमेंट
जहाँ
इलेक्शन हां
that as per the available record of register the address mentioned in the agreement paper of the leave application that village Konka Kankajodi PS Champua district Keonjhar. But the security report they are mentioning that I belong to the district Keonjhar and my village is such and such. That as per the appellant number 3 did not return to the ashram after expiry of the furlough leave. The message was sent to the officer in charge of Jagannathpur police station, posting him by message number such and such. Dated bar 4/2010 and the superintendent of BPO Jamujari take necessary arrangement to return the said convict to this ashram. Further, a letter was issued to the IIC Champua by letter number such and such dated 23/2010 of the ashram regarding the non-surrender of the said life convict. In response to the above letter, the IIC Champua intimated the superintendent of Bujupatna open air ashram that as per the leave address of the said convict, the village Kankajodi has now come under the Jhumpura police station jurisdiction. Accordingly, several intimations through the message were sent to the IIC Jhumpura by wireless message number such and such, such and such. In spite of above correspondence, not single intimation was received from the IIC Jhumpura. Some copy of the wireless message was filed here with as a answer CC. That as per the letter dated sunset dated 16/7/25, and that message was sent up to 2021, and the last 8/4/2021. That as per the letter dated letter such and dated 16/7/2025 of the IIC Champua addressed to the Advocate General Orissa, the convict Naresh Laguri was in good health condition and staying in his house in the village Tondan Ghattu. Accordingly, IIC Champua has been requested to double to message number such and 16/8/25 of the ashram to take necessary step to recapture the said live convict. In response to the above double to message, IIC Champua had his double to message number dated 16/8/25 stated that the village of Naresh Laguri does not come under the Champua police station jurisdiction. Hence, SOG IIC Jagannathpur PS may be requested to recapture the said convict. Accordingly, the IIC Jagannathpur PS has been requested through Superintendent of Bujupatna Open Air Ashram wireless message number dated 18/8/25 to recapture the said live convict, but no reply has been received yet from the IIC Jagannathpur.
We are asking the Home Secretary to file an affidavit. 6 loss negligence.
Nobody is hearing to anyone.
So may I
Take down. This criminal appeal has been filed by 6 persons, namely so and so, challenging the judgment and order dated 23/6/1998 passed by the 11th Session Judge Keonjhar in Sessions Trial number 153 of 1997. In holding them guilty under section 148, 302 by 149, 307 by 149 and 120B by 149 of the IPC, and sentencing each of them to undergo imprisonment for life. Stop. During pendency of the appeal, by order dated 21/4/2000, the appellants number 1, 5, and 6, namely so and so, were directed to be released on bail by this court in miscase number 154/2000. When the matter was taken off on 18/4/2024 and nobody appeared for the appellants, this court directed the Learned Counsel for the state to obtain instruction regarding the whereabouts and well-being of the aforesaid appellants number 1, 5, and 6, who were directed to be released on bail by order dated 21/4/2000. A report was also called for from the London Trial Court regarding the other appellants, that is appellant number 2/TO24, relating to their placements. When the matter was taken off next on 28/8/2024, London Counsel for the state produced the written instruction received from IIC Champua Police Station, which showed that appellant number 1 and 6, namely so and so, were dead since long. And since this court found that the near relations had not taken any step to pursue the appeal on their behalf, therefore, the appeals to dismissed as to have abated against them. And it was specifically mentioned in the order dated 28/8/2024 that the appeal survives only for appellant number 2 to 5. The matter was then taken off on 15/7/2025 and we made a query to the London Counsel for the state regarding the well-being of appellants number 2, 3, 4, and 5. Who took time to obtain instruction in that respect. On 31/7/2025, when the matter was taken off, and the London Counsel for the state produced the written instruction dated 16/7/2025 received from Inspector in charge of Champua Police Station. to the effect that the appellants number 234 are of village Tondaghotu, PS, Jagannathpur District, West Singhbhum, Bihar, are in good health condition and staying in their houses comma, on verification of the records, since we found that no bail order has been passed in favor of appellant number 2 and 3, we pass the following order. 31/7/2025 order quote करिवे आपण out of the 3 appellants से जो सब paragraph अछि सेठू quote कर देवे up to let the learn and count
Yes,
last paragraph
Baraja.
पर्यंत है ना बस the matter was then taken off on 12/8/2025 and the following order was passed. पूरा quote कर दिया प्रथम paragraph Mr. Jateshwar Naik to up to list this matter on 14/8/2025. When the matter was taken off on 2/9/2025, the following order was passed. As per the order dated 12/8/2025 till list this matter on 16/9/2025. है ना से पर्यंत कोर्ट करी Today, the Learning Council for the state has filed an affidavit dated 12/9/2025 of Miss Smita Mahanti, Superintendent Biju Patnaik Open Air Ashram, Jamujhari, District Khurda, wherein it is specifically mentioned that appellant number 3 Nanu alias Naresh Laguri
Yes, Genda.
alias Genda was admitted at Biju Patnaik Open Air Ashram on 25/12/2009, being transferred from District Jail Keonjhar, and he was released on follow leave from 25/3/2010 to 3/4/2010 for a period of 10 days. And he was supposed to return from follow leave on 4/4/2010. But till date, he has not surrendered before the ashram authorities. Stop. Most peculiarly, the appellant number 2 was allowed to be a surety for appellant number 3, and the surety bond and agreement copy has also been annexed to the affidavit. However, it is mentioned in the affidavit that appellant number 2 was never admitted in Biju Patnaik Open Air Ashram, Jamujari. If the appellant number 2 was never admitted in the ashram, how he could be allowed to be a surety, particularly when he was an accused in the case.
Convict.
You see, he was a convict in the case. No explanation has been forthcoming in the affidavit.
Appellate study है appellant number 3 of contrajury PS Champua. Just like the same one.
The
Further
Huh?
affidavit further reveals.
The affidavit further reveals that
In the bond.
in the bond, the address of the appellant number 3 has been given as Village Konkajodi, Konkodajodi, PS Champua, District Keonjhar.
While he is a man from
Though he was a man from
West Sing.
West Singhbhum in the state of Bihar. Huh?
In the state of Jharkhand.
In the state of Jharkhand. In the state of Satyavrtila, Bihar.
Jharkhand.
Now it is Jharkhand. Huh? In paragraph number 5, it is mentioned that messages were sent to IIC Jhumpura on different dates.
From 2012 to 2020.
That is from
The year.
the year 2010 to 2021. To make necessary arrangement of appellant number 3 to the ashram, since he has not surrendered after the period of prologue leave was over. The intimation letters, the WT messages as well as the letters have been annexed to the affidavit. In the affidavit, it is further stated that one letter has been sent by the IIC Champua police station, which is addressed to Advocate General and Advocate General, that appellant number 3 is in good health and staying in his house at village Tadangatu,
Tadangatu. This is in response to the direction issued by this court.
which is obviously in response to the order passed by this court. And accordingly, it seems that the ashram authorities requested IIC Champua to take necessary step to recapture the appellant number 3.
But he avoided saying.
However, since the IIC Champua, in response to such letter, indicated that village of the appellant number 3 does not come under Champua police station, comma, and it comes under Jagannathpur Police Station, comma, the jail authority seems to have requested the IIC Jagannathpur Police Station to recapture the appellant number 3, but no response has been received. On perusal of the affidavit and the orders passed by this court, it appears that everything has been done in a very casual way, even though the appellants number 2 and 3 were the live convicts, and one live convict was allowed to go on furlough leave
Because others have not been granted with.
on the surety bond of the other, that is appellant number 2. And even though the appellant number 2 was not staying in the ashram as per the affidavit filed.
They live the day. Okay.
No. Another peculiar feature is that how appellant number 2 is now staying in his village, even though he was neither granted bail by this court, nor any record has been produced before this court that he was either released prematurely or by way of leave
Or otherwise.
or otherwise. If the release orders of 2 and 3, if the release order of 2 is not available on record, and number 3, appellant number 3, he has flouted the terms and condition of furlough leave, and they are now available in their respective villages. It is not understood as to how no steps have been taken for recapturing them in accordance with law, and only later correspondence have been made right from 2010 till date. The negligence of the jail authorities
With the IAC.
oblique IICs are apparent on the face of records. What about this appellant number 4? We are
मतलब two
Premature.
people,
There is premature.
premature.
अच्छा
I ordered it.
premature लिखा है जी
कोर्ट का नाम है।
Yes, yes.
लिखा है जी नहीं appellant number 4 हाँ तार बेल टा तो रिजेक्ट ହେଇଥିଲା premature କେବେ ହେଲା କୋଉ order ଲେଖା ହେଇଛି
And that is ordered at 15/7/25.
15/7
There,
just a minute 15/7 okay 2 to 5 में confine करूँ କାହିଁକି ତ ଲେଖା ହେଇନି? ଆମେ କହିଲୁ ଯେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବା ପାଇଁ ଆପଣଙ୍କୁ
ଇନଷ୍ଟ୍ରକ୍ସନ ଫାଇଲ
ଗୋଟେ କିନ୍ତୁ ଆସିଛି
ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି।
ହଁ
ସେଗୁଡାକ କୋଉ ଅର୍ଡରରେ ମେନସନ ହେଇ ଯଦି ନହେଲେ ଲେଖିଦବା କାମ ଛିଣ୍ଡିଯିବ ଏକାଥରେ। ଆପଣଙ୍କ ପାଖରେ ଯଦି ଅଛି ତାର ଡକୁମେଣ୍ଟାରୀ ପ୍ରୁଫ, କାରଣ ତାପରେ ଅର୍ଡର ଗୁଡାକ ଖାଲି କନଫାଇନ କରୁଛି
2 and 3
2 ଆଉ 3 କୁ, କୌଣସି ଜାଗାରେ ଲେଖା ହେଇନି 4 ପ୍ରିମ୍ୟାଚୁର ରିଲିଜ ହେଇଛି ବୋଲି। କୋଉ ଅର୍ଡରରେ କହୁନାହାନ୍ତି ଆପଣ, ନଚେତ ଯଦି ଅଛି ଦିଅନ୍ତୁ ଆଉ ଗୋଟେ ଲାଇନ ଲେଖିଦବା। ଏତେ କଥା କଣ? ତାର ନା 4 ନମ୍ବର ନାଁ କଣ?
କଣ୍ଡା ଲାଗୁରି
ଆଚ୍ଛା ଆଚ୍ଛା, ଲେଖା ହେଇଯିବ ଏଇଟା ଅଛି ଯେ କିନ୍ତୁ ଲେଖା ହେଇନି। ଏଇ ଯୋଉ ଇନଫର୍ମେସନ ଅଛି ସେ ଯୋଉ ଲେଖିଲେ ନା 2, 3, 4 ଯୋଉ ପ୍ରଥମ ଲେକ୍ଚର ରିଜେକ୍ଟ ହେଲା ବେଳେ ସେଇଠି ଲେଖିଲି on perusal of the letter dated 25/7/2025 of the Superintendent District Jail Keonjhar, it reveals that appellant number 4, Konda Deuri, appellant number 4 to? Konda Deuri has been released prematurely on 1/6/2017 as per the order of DG of Prisons and DCS Orissa.
Number 12572.
हाँ?
Order
ଅଛି ତ ଏଥିର ହେଲା। ବାକି ତାପରଠୁ ତ ଚାଲିବ ଇଏଟା ଆଉ ହେଲା। ବାକି ସେ ଅର୍ଡର ଗୁଡା ଠିକ ଅଛି। ଏଇଟା ଜଷ୍ଟ ସେଠୁ ପରେ ଯୋଉ ରିଜେକ୍ଟ ହେଲା ତାପରେ ଏଇଟା ଲେଖିନି, ତାପରେ ଏମିତି ସିଷ୍ଟମାଟିକ ମାନରରେ ଲେଖି ଦେଇଛି। କଣ ଲାଷ୍ଟ କୁ କଣ ଲେଖିଲେ ବର୍ତ୍ତମାନ? Let the Secretary Home Department file an affidavit as to what steps have been taken to ascertain as to how appellant number 2, in spite of not being released on bail by this court, is now moving freely in his village, how appellant number 2 was allowed to be a surety for appellant number 3, why sincere steps to recapture appellant number 3 was not taken, even though he had not returned to ashram after availing the furlough leave for 10 days. And what actions has been taken against the erring officials? Put up this matter
and misleading information to this court.
And giving misleading information to this court. Put up this matter on 14th of October 2025. Free copy of the order we handed over to the Land Council for this day. Police and for 8 of this.
Make it.
Yes, 23 ton first. Where is Mr. Das?
My lord, pass over Mr. Das.
No question of pass.
Mr. Das is on the way.
On the way.
We mentioned in that last order that this should be our first item, I think. This matter on the top of the list. Obviously, they have not listed, but the noting has been given that it would be. ଲେଖା ହେଇଛି ବୋଧେ first. The top of the
Noting
list
that.
ଲେଖା ହେଇଛି.
Noting that, I will be taken
Noting
up.
ଅଛି, ଲେଖା ହେଇଛି item number 23 will be taken up first in the hearing list. That is there.
Financial condition and the criminal antecedent of the applicant. Have issued letter, but that
legal letter.
will not.
Counsel किए.
Mr. Mala.
You are there.
About counsel does financial
Nine,
jama kahin magitile? If he is appearing through lawyer,
legal aid through.
you have come through legal aid.
Initially, my lord, Ms. Dipali Mahapatra.
She had no brief educated.
As per direction of this honorable court, I don't know.
Right.
Thereafter, I will.
He's staying with his blood land counsel. Financial पढ़ा वो अच्छा से जो वो है तला बोले मैं period यदि reduce करा जाए ताले से बड़ा just by way of not that जेमती हमें
Sentence
dates जेमती death sentence रे हमें बड़ा format रे मगी लूच as per the Supreme Court से ही type रे मगी तो no it's all right. This appeal would do मैं जोटा पाठाड़ करथिलु ମାନେ ପାଠାଟମେଣ୍ଟଟା ପ୍ରାୟ ସରି ଯାଇଥିଲା ସେ କଣ ସେଇ ଯେ ଏଇଟା ସେଇ ଯୋଉ ଘର ଭିତରଟାରେ ମର୍ଡର ହେଇଛି ତ ଏମାନେ ରହିଛନ୍ତି ସେଇ ଘରେ ସିଏ ଆଉ ଗୋଟେ ରୁମ ରେ
ଜଙ୍ଗଲ ସେଟା
No, not yours.
Item 23.
Item 23.
ସେ
4 person were staying in the house.
one of them has been acquitted. That lady has been acquitted.
Means separate trial.
ସେପାରେଟ
trial.
ଇଏ ହଉଛି ତାଙ୍କର କଣ ମାନେ ପୋଷ୍ୟ ପୁତ୍ର ପୋଷ୍ୟ ପୁତ୍ର ଇଏ ଡବଲ ମର୍ଡର
ଆଗଟା ବି ମର୍ଡର ହେଇଥିଲା ପରେ ବି ତା ଭାଇକୁ ଗୋଟେ ମର୍ଡର ହେଇଥିଲା
ଫାର୍ଷ୍ଟ ପୋଷ୍ୟପୁତ୍ର ଯିଏ ହେଇଥିଲା ସିଏ ମର୍ଡର ହେଇଗଲା ଇଏ ପୋଷ୍ୟପୁତ୍ର ହେଲା ଇଏ ମାରିଦେଲା
ଇଏ ମାରିଦେଲା
ଠିକ ସେ ଘରେ ହଉଛି ଦିଟା ବାଟ
ଗୋଟେ
ଇଏ ଦେଖଉଛି
ସ୍ପଟ ମ୍ୟାପ ରେ
स्पॉट मैप रे देखुची आपनकर गोटे एंट्रांस रूम जोटा 1 नंबर
फ्रंट बारंडा गोटे अछि
फ्रंट बारंडा गोटे बाट अछि आ गोटे 14 नंबर देखुची आउटलेट डोर ए दीटा अच्छा ए जो अक्यूज्ड आउ तार स्त्री ए माने रहू 10 नंबर रे आउ से जो डिसीज दीटा को रहू 3 नंबर एया तो बाकी तो बारंडा सबुथिर अटैच अछि 10 ରୁ 3 के आराम से जाई 10 ରୁ 3 कारण खाली गोटे सीडी इंटरनल 7 नंबर रे
माने ये होते टिके तळको हिकरी अछि
सीडी टा वॉल को लागि के हितिबो से साइड रे जो लैंडिंग जो पर्सन ता तारि तळे जिबा पे सेपट बारंडा को रास्ता ता अछि
किंतु बाटो अछि नॉट दैट बाटो नाही बेली
बाटो अछि सीडी अछि 8 नंबर जो बारंडा रे सीडी अछि 8 नंबर बारंडा
8 नंबर बारंडा रे 7 नंबर टा होजी सीडी होबो
7 नंबर सीडी से लैंडिंग जो स्पेस टा तारी तळे से 5 नंबर बारंडा को जाई होछि
क्लियर अछि ये एक्चुअली कोन है ना एठी गोटे माने पूरा 11टा पड़ी दैट इज क्रिएटिंग
एक्चुअली से 11 सेठी नाही
11 एक्चुअल सेठी नाही कारण एविडेंस आछि जे फ्रीली पैसेज
दिस लाइन हैज बीन स्ट्रेट एटा न काटी दितले
जे लैंडिंग जो पोर्शन टा अछि से सेटा को दबा कथा ऊपर पुनी आ गोटे स्टेप
माने सेटा न करी से कोन करछ ता लाइन टा को पूरा कर दै छै
किंतु एविडेंस अछि ना माने 10 नंबर रू 3 नंबर को आराम से जाई हो बारंडा रे अछि आई थिंक दैट वाज बेस्ड ऑन दैट
यस
अदर आर्गुमेंट नोट देइथिले की
ନା
ଆସି କହିଥିଲେ ବୋଧେ
ସେ କହିଥିଲେ
ଆପଣଙ୍କୁ?
ଚାର୍ଜସିଟ୍ କହିଥିଲେ ଯେ ଚାର୍ଜସିଟ୍ ଟା ମୁଁ ଟିକେ ଦେଖିବି
ନାଇଁ ସେ
ନେଇ
ତ ଦେଇ
ଦିଆହେଇଥିଲା।
ସବୁ ଯାହା ଦରକାର ତାଙ୍କୁ ଦେଇ ଦେଇଥିଲେ।
ଆର୍ଗୁମେଣ୍ଟ କେତେ
ନା ସେ କହିଲେ ମୋ ନୋଟ୍ ରେଡି କରିଛି କିନ୍ତୁ ରେଡି ଆସିନି।
ହଁ ତିନିଶହ 13 ନମ୍ବର ପୃଷ୍ଠାରେ ଅଛି written note of argument submitted in the trial court.
କୋଡ଼ିଏ
313 ମିଷ୍ଟର ନାୟକ
ମାନେ
313 पेज बाहर करो सी पड़ेगा ଆସିନି ଆଜି ଛୁଟି ବାହାର କର 313 पेज। Let your
the
senior
prosecution story is like that on the night of incident, the accused Prashant Sahu and his wife were present in the house of the deceased Jadu and Pitei. So, charge under section 302 IPC has become made against them. Undisputed fact. Deceased Jadu and Pitei have been murdered. On the date of the occurrence, the accused Prashant Sahu and his wife Shanti were present in the house of the deceased Jadu and Pitei. Accused Prashant is the son of the deceased Pitei's sister. Prashant is the adopted son of deceased Jadu and Pitei. Accused wife Shanti has been acquitted from the case, but no appeal preferred by the prosecution. The main reason of the prosecution to connect the accused in this case, as he was present in the fateful night. So the main issue is to be of the accused was present, then whether he was committed the offense or any other else. The accused wants to prove his innocence on the following grounds. Though the accused and deceased were staying in one house, but they were in separate room which was not interconnected. The deceased was staying in the portion where, as the accused Prashant and his wife Shanti were staying in asbestos portion of the house. It would be revealed from the spot map and from the deposition of IO, Mr. T.H.K. Murthy. It would reveals that there is a reasonable distance from the bedroom of the deceased to that of the accused. That the room were not interconnected. That there was distance between the bedroom of the deceased and that of the accused. The incident have not come to the knowledge of the accused. That there was a staircase near the bedroom of the deceased. The staircase is open one. That the house of the deceased in such a situation that there is a
no
obstacle to come to the house of the deceased. Anyone could come to the house of the
ମାନେ
deceased.
staircase ମାନେ ସେ ଭାବୁଛନ୍ତି ଯେ ଉପରୁ ଛାତ ଉପରୁ ପଳେଇ
ସେ ଭାବୁଛି ସେଇଆ ଛାତଟେ ପକେଇଛି
ଛାତ
ତେଣୁକି ତାକୁ ଇଣ୍ଟରକନେକ୍ଟେଡ ମନା କରୁଛି କିନ୍ତୁ ଉପରୁ ଖୋଲା ଅଛି ବୋଲି
ଖୋଲା
so
ଅଛି।
anybody else can enter but not the
Accused.
ମାନେ ନଟ୍ ଦ୍ୟାଟ୍ ସେ ଯୋଉ କୌଣସି ମାନେ କବାଟ ଦେଇ ପଶିବ ସେ କହୁନି
ନା,
ସେ କହୁଛି
ଛାତରୁ
ଛାତ
ଆସିପାରିବ।
ଉପରୁ ପଶି ଆସିବ ଦ୍ୟାଟ୍ ଇଜ ଦି ସବମିଶନ ଆଚ୍ଛା ଓକେ
ସେ accused ଯୋଉ ପର୍ସନ ରହୁଥିଲେ ସେଟା asbestos
ହଁ ସେଇଟା
ଆଉ
ହଉଛି
ସେଟା ରହିଲା ଆରସି ମାନେ ସେ ରହିଲା
ହଁ
ଯୋଉ ଷ୍ଟାର ଟା ହେଇଥିବ asbestos ସାଇଟ୍ ରୁ ହିଁ ହେଇଥିବ ଆରସିକି।
ନାଇଁ ସିଏ ସବମିଶନ ହଉଛି ଯେ ସେ ଯେହେତୁ ଏଟା ଇଏ ଷ୍ଟେୟାର କେସ୍ ଅଛି ତେଣୁ ଷ୍ଟେୟାର କେସ୍ ଧରିକି ଜଣେ ପଶି ଆସିବ ଆରାମସେ ତା ପାଇଁ କିଛି ନା ବାହାର ଲୋକ ଆଇଲା କମିଟ କରି ମର୍ଡର
ତ ୟାର ଯିବା ଆସିବାର କିଛି ସ୍କୋପ
ହଁ ୟେସ୍ ନେକ୍ସଟ
The house of the deceased in such a situation that there is no obstacle to come to the house of the deceased. Anyone could come to the house of the deceased. That the prosecution has not stated or proved that no one could come to the house of the deceased or there was no possibility to coming anyone to the house of the deceased at that night. The house of the deceased was fully secured or closed is not established by the prosecutor. Probability that from the aforesaid circumstance, it is established that the crime has been done by three persons. One is either by the accused Prashanta and Santi, or by the outsider, or by the deceased themselves.
जो ground जोटा नहीं था
Ground.
मारपीट ही
Marpite.
हाँ
On conclusion, the crime done by the outsider cannot be avoided. So it is humbly submitted that it is well settled that the circumstance from which the conclusion of the guilty is to be drawn should be fully established. The circumstance concerned must, should, and not may be established. The fact so established should be consistent with the hypothesis of the guilty of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The case of
तानिबेन पंकज कुमार
Pankaj Kumar
हाँ, दाविद किया हाँ,
versus
David
State of
Kerr.
Gujarat, no evidence was available as to whether on the fateful night the door leading to bedroom of the deceased was fully secured. The accused acquitted. The said case is reported in AR 1997 Supreme Court page 2198 para 9. Strong suspicion can be
Cannot.
to place of proof. Accused acquitted. AR 1996
Accused
Supreme Court 2868. AR 1997 Supreme Court 2193 page 2213 para 46. AR 1996 Supreme Court 66. In as much as the circumstance of the presence of the appellant near the scene of occurrence at the midnight and injury on his finger at too weak
to form chain.
form chain in such a great offense. The relationship between accused and the deceased, no ill feeling. That the accused is the son of the deceased Pitei's sister, and he was adopted by the deceased Jadu and Pitei. There was good relation between the deceased and the accused. Schedule 1. He stated there was good feeling between the accused and the Jadu and Pitei.
जद्दू हाँ,
This is Jaddu brought Santi as his daughter-in-law, and thereafter they all were staying together in one mess. Schedule 9. As deposed, there was no ill feeling between the accused and his wife, this is Jaddu and Pitei. On the other hand, Schedule 9 has stated one on
आंसर कटी है
Amavasya.
Amavasya,
हाँ, ये जो बीते
Chitalai Amavasya, in 1996 at about 8:30 p.m. while I was sitting in my house, this is Jaddu
Jaddu.
came and inquired about my father. He informed me that there was a quarrel between him and his wife Pitei. Motive. Accused is the adopted son of the deceased. Deceased was a retired central government employee, so he was getting family pension. There was no benefit to the accused on the death of the deceased. Accused.
Fully.
There was no ill feeling between the accused and the deceased. On the other hand, there was ill feeling between the deceased.
This is man जो दी जाना कविता
हाँ.
दीटा disease. हाँ.
It is humbly submitted in the case of circumstantial evidence, motive assume greater importance than in the case where direct evidence from the for murder are allied. In the instant case, no motive has been ascribed as to why the accused would cause the murder of her adopted father and mother. AR 1993 Supreme Court 2193 page 2211. AR 2000 Supreme Court 369. So far as the motive is concerned, the prosecution case is rather hazy, and the High Court itself has brushed aside the same on the ground that motive is not an essential ingredient of offense. Child. Conduct of the accused. That finding the death of the deceased Jadu and a serious condition of the deceased Pitei, the accused immediately informed the neighbor and to the police. Police registered case by PS case number 15096. Accused assisted in the case of the investigation of the case. For no reason, it can be held that the conduct of the accused in any way as unnatural. Injury mark on the accused. If accused committed the crime, there was the possibility of injury mark on the accused, but no such injury mark. Nothing of the accused recovered. Nothing, either the blood of the deceased in the accused, any wearing apparels of the accused has been recovered. The deceased were two. When attempt were taken on the deceased, they must have protected itself. They would have tried to save their lives. They would have exchanged the fight. So naturally, either the injury mark on the accused or any articles of the accused would have been found from the room of the deceased. Broken Sankha has been seized, which was of deceased Pitei. 7. Statement under section 161 CRPC recorded after 5 months and 21 days. The PW has stated there was ill feeling between the deceased and accused on 11/2/97, that is after 5 months and 21 days of the court. PW
Court.
of the
Record of
court.
release.
PW 2 and 9 have stated there was good feeling.
ନାଇଁ ନାଇଁ ଯୋଉମାନେ ଇଲ୍ ଫିଲିଂ ବିଷୟରେ କହିଲେ ସେଇ prosecution witnesses ଗୁଡାକ 5 ମାସ ପରେ ଏକ୍ସାମିନ ହେଇଛନ୍ତି ବୋଲି
Right.
ମେ ବି ଦ୍ୟାଟ୍ସ ଯୋଉ ସେକେଣ୍ଡ, କାରଣ ପ୍ରଥମଟା ତ ଆକ୍ୟୁଜ ନିଜେ ଇନଫର୍ମାଣ୍ଟ ଥିଲା ନା,
ତାପରେ ପୋଲିସ when during investigation police found that
Obviously, after 5 months, yes.
on 14/8/96 PW1 was present. He was a witness to the inquest report, but he had not disclosed the fact of ill feeling between the accused and deceased. Had PW1 stated this fact before just after the incident, and the accused
would have been arrested.
Yeah. Why he disclosed this fact have not been expired also.
Transferred करे तो माने एक तो सी कहया कथा जे 5 मास परे हैला आउ सी इनक्वेस्ट रो भी साक्षी थिला नै जो साक्षी माने कहिले जे इल फीलिंग थिला से माने 5 मास पर एग्जामिन हेले आ एक नंबर साक्षी जे भी मध्य से रेस्पेक्ट रे कहूची से इनक्वेस्ट बेले साक्षी थिला कि सेतोळे किछि कहला नै तेणु तार बिलेटेड जो डिस्क्लोजर टाको एडमिट माने एक्सेप्ट न करा जाऊ से दैट इज द आर्गुमेंट व्हिच वाज आर्गुमेंट. Yes.
So his statement should have been believed. Year 19
should not be believed.
Should not be believed. Year 1997 Supreme Court 1614. The main reason for discarding their evidence is that their statement under section 161 of CRPC came to be recorded after about 4.5 months. No explanation given by IO. Chemical report. From chemical report, no evidence of involvement of the accused is clear. 9. Absence of accused. The accused was doing business outside of the date. Was out. He came to know that his wife has been arrested. He approached his counsel and Honorable High Court for anti-suitable. The Honorable High Court called for case diary in PS case number 15096, but IO did not produce. After rejection of his anti-suitable, he was not arrested by police. Year 1997, 2 Supreme Court 329. Year 1997.
Conduct absconding.
Absconding is the weak link in the chain of circumstances. Informant is the IO in this case. Intentionally, for ill intention, the IO became the informant himself and investigated the matter to connect the accused in this case. Murder of the brother of the accused. As the deceased, Jadu and Pitei were issueless, they adopted fast Prashanta Sahu, brother of the accused, but he was murdered in that village.
प्रभात
Prabhat
ये
Sahu.
तो प्रशांत
Prabhat Sahu.
Hmm.
PW9 has deposed Jadu had earlier adopted Prabhat, the elder brother of the accused Prashant. I do not know if some of our villagers have
had
murdered
murdered Prabhat.
Who accused acquitted that on the night of the incident, the accused Prashant and his wife were present in the house of the deceased. His wife Shanti has been acquitted from this case, but no appeal preferred by the prosecution. For the ends of justice, as both the husband and wife are innocent, wife has been acquitted. The accused should be acquitted. In the similar case reported in the year 1990, acquitted as he is an innocent and falsely implicated in this case.
And that's a different.
Such a meticulous examination of every aspect of the evidence.
Discussing the see that the preparation the trial court counsel has made on every aspect he has tossed and given the citation also. That is not also coming before this court by some of the counsel. That sort of the result is immaterial.
Yes.
What would be the result, but the preparation should be like that.
Bit by bit in every evidence there is a argument.
माने एतिटा circumstance नहीं ची absconding को challenge कला जे नहीं ताकू trial जो anticipatory bail हला anticipatory bail एक court records call करला ये हला anticipatory bail दिया हला तापरे ताकू ये कला पर तापरे से
absconding is a link.
motive ताकू दी ची जे adopted some किसी feeling नहीं जीवी feeling दो ची 5 मास परे आसी कोची ସେତେବେଳେ କିଛି ଇଏ ତେଣୁ ଏଇଟା ଗୋଟେ ଆଫ୍ଟର ଥଟ୍ ଷ୍ଟୋରି ତାକୁ ପ୍ରୋଜେକ୍ଟ କରୁଛି ବାକି ଏଭିଡେନ୍ସ ନାହିଁ ଯେ ଉପର ପଟୁ ଆସିବାକୁ କିଛି ବାଟ ନାହିଁ and it's a fact also have you brought out any evidence ମାନେ ଦେଖ ବେଳେ ବେଳେ ସିଡି ଘର ହେଇଯାଇଥାଏ ମାନେ 5 ଷ୍ଟେୟାର କେସ୍
Landing ପର୍ଯ୍ୟନ୍ତ
ଥାଏ ଓପନ୍ ଥାଏ ତେଣୁ ତାକୁ ହବାକୁ ହେଲେ ଉପରେ ଗୋଟେ ସେ ଯୋଉ ସିଟ୍ ଘର ପଡିବ ତାପରେ ଗୋଟେ କବାଟ ଲାଗିବ କବାଟ ଲାଗି ଚାବି ପଡିବ ତାହେଲେ ବାହାର ଲୋକ ଯିଏ ସିଡି ଉପରେ ଚଢିବ
ସିଏ ଚଢିଲା ସିଡି ବାଟେ
ଆସିପାରିବ ନାହିଁ ତ ଏଠି ଆପଣ ଲେଟେଷ୍ଟ ସେ ଯେ ଦିଟା ଡୋର ବନ୍ଦ ଥିଲା ସିଏ ଗୋଟେ ପଏଣ୍ଟ ମେକ୍ ଆଉଟ୍ କରୁଛନ୍ତି ଆକ୍ସେପ୍ଟେବଲ ଅର୍ ନଟ୍
intelligent way, yes.
So somebody suppose he comes to the on the top of the roof. So if he had access, then आपन को एगुड़ा सबू prosecution से कहउछन्ती जे prosecution ର ड्यूटी होची जे आनिबा पई
Rule out हवा
रूल आउट करिया कथा जे ए घर को पसिबार आउ किछि बाट
नहीं
नाही
exactly.
तेणु ताहले इट इज द ओनली पर्सन हु हैज कमिटेड दी तेणु ए दीटा घर मनकर आपन कबाट बंद कर देले किंतु सीडी घरटा हेइनी सीडी घर देकिन स्टेयर केस देकिन आराम से जणे जदी आसी परियो
So he has shown the probability.
हां प्रोबेबिलिटी ସେଇଥିପାଇଁ ତ କହୁଛନ୍ତି ନା ସେ ଯୋଉ 5ଟା ଯୋଉ ପଞ୍ଚଶୀଳରେ କହିଲା ଯେ the court has to come to the finding that the accused and none else ଆଉ କୌଣସି circumstance କୁ explain କରି ହବନି ଏଠି ଆପଣ ଯଦି ରୁଲ ଆଉଟ୍ କରିଦେବେ ଲାଇକ୍ ଆମର ଯୋଉ କେସ୍ ହୁଏ ଯେ ବେଡରୁମ ଭିତରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଶୋଇଛନ୍ତି
ସେ ରୁଲ ଆଉଟ୍ ହେଇଗଲା
ରୁଲ ଆଉଟ୍ ହେଇଗଲା ସକାଳୁ ଦେଖିଲା ବେଳକୁ ହୋମିସାଇଡାଲ ଡେଥ୍ ହେଇଛି ଇଏ ଫେରାର ତେଣୁ
Here there is a scope.
Here there is a scope से कहूँ आपन को एविडेंस आनिया दरकार ये सीडी बाट देगिनी गोटे लोक पसिबार ये नाही से एविडेंस ए पॉइंट टाकू एथि पई नै चंदी मोस्ट लाइकली देयर इज नो एविडेंस दैट देयर वाज एनी सीडी घर सेठी किछि माने सीडी टा हेई गला माने नै जे सीडी घर अछि एवं गाउँलिया गाँरे तांगर वे तो फाइनेंशियल डिफिकल्टी थिबो परे से माने
लिंटल पर्यंत नै जाइछन्ती आ सीडी कंप्लीट करि
हां सीडी वे सेम दिस इवन इफ से ये मध्ये उठी जाए किंतु एस्बेस्टस पकेई किनी कि जोड़ा हुए सीडी घर रे ଆଉ କବାଟ ଲାଗିବା କଥା ଏଗୁଡାକ ପରେ ହୁଏ।
Means evidence was inevitable to that aspect.
Yeah.
Otherwise, there is a probability that you are giving scope, not unerringly pointing it on this.
There is access of the third person.
Hmm.
Apart from these two persons, जोटा कौन कहले accused of the स्त्री, third person ना entry रो से भीतर को possibility अच्छी।
ସେ
ସେ ବି ଆସିପାରିବ।
ମଧ୍ୟ ଆଉ ଗୋଟେ ଆଣୁଛନ୍ତି ଯେ ଯେହେତୁ ପ୍ରିଭିୟସଲି ଭାଇ କି ମର୍ଡର କରାହେଇଥିଲା
ହଁ।
ତ ଆଉ କାହାର ମଧ୍ୟ
That is also the accused plea at the beginning.
ହଁ।
That ଯିଏ ମାରିଥିଲା ତାକୁ ସେ ମାରିଛି ୟାକୁ.
ହୁଁ।
That is also the plea.
ତାପରେ କଣ୍ଡକ୍ଟଟା ଯୋଉ ଆଣିଛନ୍ତି ପ୍ରେଜେଣ୍ଟ କରିଛନ୍ତି ଯଦି ଇଏ ହେଲା ଇଏ ତ ଫେରାର ହେଇଯାଇଥାନ୍ତା ମର୍ଡର କରିକି he was very much available.
Yes.
He is giving information to the police. Police is coming, finding that one is dead, the other is being shifted to this one. So only one weapon is there also. ଆଉ ଆଙ୍କର କିଛି weapons ରେ କିଛି
ସେଇ conduct ରେ ମୋର the first conduct should be intimation. He should have intimate the neighbor and should
କହିଛି ପରା କାଉ ଗୋଟେ କହିଛି
ତାପରେ shift କରିବା କଥା ହସ୍ପିଟାଲ କୁ
ସେ ଯାଇ ପୋଲିସ କୁ ଜଣେଇଛି
Yes.
ଶୁଣ ତୁ ମାନେ
It's from their point of view, his point of view. Yeah.
ଆପଣ ସିଏ ପ୍ରିଫର କଲା ଯେ ଆଗେ ମୁଁ ଯଦି ଥାନା ବାବୁ ତା ମୁଣ୍ଡରେ ହୁଏତ ପଶିଥିବ କି କହିଥିବ ଏ ତୁ ଘରେ ମର୍ଡର ହେଇଗଲେ ଆଗେ ଥାନାକୁ ଜଣେଇଲି ତେଣୁ ହୁଏତ ସିଏ ଭାବି ନଥିବ ଆଚ୍ଛା ଯୋଉ ହସ୍ପିଟାଲ କଥା କହୁଛନ୍ତି ହ୍ୱାଟ ଇଜ ଦି ଡିଷ୍ଟାନ୍ସ ଫ୍ରମ ଦ୍ୟାଟ ପ୍ଲେସ ଟୁ ଦି ହସ୍ପିଟାଲ କୋଉ ଟାଇପ ର
ମାନେ ଆପଣଟା ହେଇନ
କୋଉ ଟାଇପ ର ଫ୍ୟାସିଲିଟି ଅଛି ତେଣୁ ପୋଲିସକୁ ନ ଜଣେଇକିନି ଯଦି ହସ୍ପିଟାଲ ଆରେଞ୍ଜମେଣ୍ଟ ବି ଜଣେ କରିବ ସେଇ ସର୍କମଷ୍ଟାନ୍ସେସ୍ whether it is possible that ତାକୁ ସିଫ୍ଟ କରିହବ ଇଏ କରି ଏସବୁ ଜିନିଷ ରହୁଛି ତେଣୁ କାହା ମାଇଣ୍ଡରେ କୋଉ ଟାଇପ ର ଜିନିଷ ପଶିବ ଦ୍ୟାଟ ଇଜ ଅଲସୋ another factor. That is thing is that in a very sequence wise se point ଗୁଡାକ touch କରିବାକୁ ଚେଷ୍ଟା
Given a
କରେ
very good fight.
important
It's a good fight.
Well, they're just one
to say that I'm sorry because I was just in last minute preparing my lord's last week's judgment on circumstantial evidence, and due to some electrical problem, and I could not complete my written submission, but prepared something which will be helpful, and if required, I will file the 1-2 pages citation letter. I prepared the facts, but on the basis of this fact, I can prove that the judgment is erroneous, and that part I could not reproduce in pen and paper at the time.
Make your submission.
My lord, from the beginning, that the above appeal is referred on section 374 CRPC against the judgment dated 23/8/2000, arising out of the Jotling PS case number 25 dated 5/2/1997, corresponding to GR case number 370/97 of HDM Bhubaneswar, packing ST number 161 of 1998 by the Lord Sessions of Khurda, wherein the appellant has been found guilty and convicted with the imprisonment for life on the offence of murder on section 302/201 of IPC in the night on 13/14/1996 to one Jadu Sahu and his wife Pitei, those are related and adopted accused appellant as their son. That admittedly, Santalata Sahu, wife of appellant, first seen that Jadu Sahu and his wife Pitei were in a pool of blood, and hearing from her, accused appellant Prashant Kumar Sahu found that Jadu was dead and Pitei was unconscious and a Khanati was laying near them. He had rushed to the police station and filed FIR under Exhibit 14 at 6:10 a.m. on 14/8/1996, which was received by the ISC Jotling and PS case number 150/96 was registered on section 302 IPC, and investigation was entrusted to SI of police THK Murthy. That as stated by the ISC, due to transfer of SI THK Murthy, the ISC Mr. Prafula Chandra Barik took up the investigation himself on 5/11/96. He has deposed that he came to conclusion that the incident did not happen as reported by accused in his FIR, Exhibit 14, but accused himself was the author of the crime for which I lodged FIR, Exhibit 17, on 5/2/97. Whereupon, Jotling PS case number 25 dated 5/2/97 was registered. Immediate after FIR dated 5/2/97, wife of appellant was arrested, and though appellant was going to police station pursuing his anticipated bail and looking after his wife's trial, showing him absconder, charge sheet was filed against appellant and his wife Santalata, and in ST number 145/97 on 18/1/99, the wife of appellant Santalata was acquitted. That when appellant could not get anticipated bail, surrenders and kept in custody throughout the trial in ST number 161/1998. Though for the same offence in one charge sheet on the same evidence, the co-accused Santalata has been acquitted on 18/1/99 in ST number 145/1997. The conviction of appellant in ST number 161/1998 on 23/8/2000 in the same court, with imprisonment for life under section 302 IPC and a rigorous imprisonment for 5 years under section 201 IPC, needs to be sympathetically viewed by the Sahoo Court. That the prosecution relied upon, and 15 has been typed by as 12. 15 witnesses.
1-5.
Minor. 15 witnesses, 34 exhibits, and 6 MOs to bring home their charges on 2 heads. Charges are here, so I am reading also the charge. That will be convenient to place the matter before. Fact that you on or about the 13th day of August 1996 night at Bachara under Jotling police station, along with your wife, Srimati Sahu, Santalata Sahu, in furtherance of your common intention, committed murder by intentionally causing the death of Jadu Sahu and Pitei Sahu, and thereby committed an offence punishable under section 201 of the Indian Penal Code, and within my cognizance. Secondly, that you on or about the above noted date, time and place, knowing or having reason to believe that certain offence to which the commission of the offence of murder punishable with death has been committed in furtherance of your common intention, did cause certain evidence of the said offence to disappear you
on 14/8/1996 knowingly gave false information to the police to which Jadu and Pitei were quarreling each other in the night of occurrence, and in the morning they were found dead, with the intention to screen yourself from legal punishment and thereby committed an offence punishable under section 201(34) of the Indian Penal Code and within my knowledge, my convenience. That in the accused statement, it was clearly answered as false statement to question number 5 that it further transfers from the evidence of Jagdeshwar Sahu, PW1, that there was strained relationship between you and your second wife Santilata with Jadu and Pitei as you deserted your first wife and brought Santilata. Similarly, in the accused statement to question number 27 regarding PW13 inspector's evidence, the accused has replied that it is false statement that he is the author of the crime for which police inspector has lodged the affair. That in this accused statement, in his accused statement to question number 29, accused has stated that deceased have been murdered by them who have murdered the elder brother of accused in 1978. That before discussing the material discrepancies in evidence available on records, to arrive in a conclusion that the prosecution has failed to bring home the charges and appellant is innocent and the IAC has implicated him and his wife with an ulterior motive after 4.5 months of occurrence by filing another affair, as they did not fulfill his illegal demand for rupees 50,000, which was suggested to IAC by the accused Santilata in investigation of 145/97. Here also in this case also, there was amount announcement, but that was not sufficient. The appellant submits the following legal issues for determination by this honorable court. A. Whether after registration of the affair of appellant as a Jotney PS case number 150/1996 on 14/8/1996, a second affair for same offence filed by the Inspector of Police on 5/2/97 and registered as Jotney PS case number 25/97 is permissible under law. B. Whether being the complainant in Jotney PS case number 25/1997, when there were so many officers available in police station, Inspector of Police himself is taking up investigation of his own complaint, smacks an ulterior motive and not free from bias. C. Whether in a case of murder based on only circumstantial evidence, when charge is you on or about the 30th day of August 1996 night at Bachala under Jotney police station along with your wife, Srimati Santilata Sahu, in furtherance of your common intention, committed murder in a common charge sheet after acquittal of co-accused Srimati Santilata Sahu, who had first seen the deceased and injured and informed her husband in absence of any specific allegation against appellant, the prosecution is a miscarriage of justice. That regarding the affair, the doctrine of shameless dictates that once a affair is registered concerning a particular occurrence, no subsequent affair should be registered for the same incident unless there are distinct and separate facts or circumstances justifying it. These principles aim to prevent the abuse of legal process and to avoid multiplicity of proceedings for the same occurrence. In the case of Titi Antony, my lord, I am giving the judgment.
Yes, that is there.
My lord, I am having the
But
copy.
that is not your fault here.
My lord, I am giving copy.
Is it not a distinct and separate fact?
No, my lord, no, my lord, same.
How do you say?
My lord, I am saying.
In the first case, the accused stated that somebody else has committed the murder. In the second case, the second affair, it is the accused himself committed the murder. So these are the two separate things which has come during course of
No, my lord,
investigation.
fact remains that if she was murder, evidence with
Murder,
offense is one.
two different story has been projected in the both the affair.
No, my lord. Story is based on accused statement of witnesses. Witnesses were already examined.
Yeah, that
And
is what-
subsequently 3-5 witnesses examined. So, and those were subsequently examined, their statement is not in this case. They have not been deposed in court. Therefore,
Question
only
is, another thing is, let us say that the FIR, in the same case also where the accused himself is the informant, the case could have been also proceeded against him. And the charge sheet would have, there was no,
yes, my lord.
also
No,
the occasion for filing. But
no, my
that
lord,
has-
not necessary.
But that has been done. But we are to see that what are the evidence that has
Yes.
come during.
I'm saying, my lord.
So,
but
really
if you have
because-
to, basing on this thing, Honorable Supreme Court held that it is erroneous, my lord. My lord, I am giving that was Mohanlal versus State of Odisha. That Titi Antony. Titi Anthony, as a state of Kerala and others. My lord, it is better if I also in this paragraph, this subpara, other subpara, because that is related to
What
that.
is citation reference?
My cited with that second FIR is
टीटी एंटोनी नो फुल रेफरेंस अपन देई ना थी खाली 2001 लिख दी जन
well, I have given the original.
Yes,
judgment.
yes. We have, probably Mr. Das, we have not gone through. We have passed a judgment very recently with
Exactly.
regard to second FIR,
Yes, that was
referring to Anthony.
yes. One by one,
This
I have
was
just
fine.
time ready. Titi Anthony, but what happened? I could not complete my reading.
it's all right.
Well.
Have you the citation? You know that's TT
No, my
Anthony case, but you should have given the complete citation, not the bracket with the 2001 लिख दी जाए.
नहीं मैं कंप्यूटर दे देली हजूर मान देख बोली बाबू देली
पढ़िए।
समिंग अप कर पाइली
और ठीक है, हम पढ़ो.
my lord in fact I'm coming to the facts of that case order this for appeals the relevant paragraph 3 the relevant facts giving right to these appeals which have been from
कौन टा पूछन?
Anthony case
ओहो, एंटोनी केस रो प्रिंसिपल हम
गला से गला था मु तापरे से सबपारा it may also be pointed out here that in his impugned judgment dated 23/8/2000 at paragraph 14 in ST number 161 by 98 the learned session judge himself has mentioned that both the doctors conducting autopsy have opined that at best the handle of Khonati MO1 could have been used to inflict the external injury number 1 on deceased Jadu and the inquiries on deceased Pitai. I therefore discard the MO1 as weapon of offense. So that after discussing the doctor's opinion, he has discarded the weapon of offense MO1. That it is only submitted that when
No, perhaps
that I will come, my lord.
just a minute, because there was no injury which could have been possible by the sharp side of the weapon, but the injuries were such that it was it could have been caused by any blunt weapon. So the
Well, other things are there. I have in subsequent paragraph.
court held that it is not a weapon of offense, but we can differ from the opinion of
Yes, my
the
lord.
doctors also. It
But
is
my
not
lord, that should
the-
be favorable to accused.
No, no.
Yes,
Question
ma'am.
that favorable or not, that's a different matter.
Ma'am.
But question is that suppose a weapon can be used from both from the blunt side as well as sharp side,
My lord.
right?
My lord.
So the injuries which were noticed by the doctor could not have been possible by the sharp side.
My lord. My lord,
So
in the
can it
evidence.
be a ground to reject that this
The
particular
entire-
Yes, ma'am.
weapon has not been used?
Well, in the evidence, just I have quoted, not discussed. In paragraph 3, the relevant portion I have quoted, in those evidences, even that there is some other weapons involved, that is their manner, which is not in the case. Because it is not only by MO5, the incident has not been caused. And also, my lord, many other things. My lord, my,
Don't be hurried. You are
Ma'am.
missing the case.
Ma'am.
You come to the doctor's evidence. Let us see.
my lord, doctor's evidence,
Who is the doctor?
my lord.
P-double 4,
Yes,
he conducted a PM on Jadu and P-double 7 on Pitai.
ମୁଁ କହିଛି ତାପରେ ଲିଷ୍ଟ ମୁଁ
ନାଇଁ 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 ଠିକ ଅଛି ଆପଣ ଆସନ୍ତୁ PW4 କୁ ଆସନ୍ତୁ
ଠିକ ଅଛି। My lord, P-double 4.
PW4 ର ଯଦି ଏକ୍ସଟର୍ନାଲ ଇଞ୍ଜୁରି ଆମେ ଦେଖିବା ହେଲା
My lord.
page 69 ରେ ଅଛି ପେପର ବୁକ୍
My lord, paper, my lord, reading paper.
ହଁ ତ ପ୍ରଥମ ଇଞ୍ଜୁରିଟା ହଉଛି ଗୋଟେ ଲାସେରେଟେଡ ଇଞ୍ଜୁରି
My lord,
ସେଇଟା ଅଛି ପୋଜିସନଟା ହଉଛି ଲେଫ୍ଟ ଫୋରହେଡ୍ ରେ
my lord,
ହେଲା
my lord.
ତାପରେ ସେକେଣ୍ଡ ଇଞ୍ଜୁରିଟା ହଉଛି ଗୋଟେ ବ୍ରୁଇଜ ଅଛି ତା ପୋଜିସନ ହଉଛି ରାଇଟ ସାଇଡ ଚେଷ୍ଟ ରେ
My lord,
ଏବଂ ତାର ହଉଛି ଫ୍ରାକ୍ଚର ହେଇଛି ଅଣ୍ଡରଲାଇନ ଫ୍ରାକ୍ଚର ଅଛି
my lord,
ସେକେଣ୍ଡ ଟୁ 9th rib ପର୍ଯ୍ୟନ୍ତ ଅଛି
my lord,
ଏତିକି ହେଲା ଦୁଇଟି ମାତ୍ର ଏକ୍ସଟର୍ନାଲ ଇଞ୍ଜୁରି
my lord,
ବାକି ଇଣ୍ଟରନାଲ ଇଞ୍ଜୁରି ଯାହା ହେଇଛି
my lord,
ହେଲା
my lord.
ସୋ ଖଣତିଟା ଜଣା ପଡେ ଯେ ଗୋଟେ ସାଇଡ ସାର୍ପ ଅଛି ତାର
One
ଅନ୍ୟ
side
side ଟା
bent
ହଉଛି ବ୍ଲଣ୍ଟ
My
ସାଇଡ
lord,
ସେ ଯୋଉ ବେଣ୍ଟରେ ଯଦି ମାଡ଼ ହବ ତାହେଲେ ଡକ୍ଟର କହୁଛି ଯେ possibility ତା ସେ ମଧ୍ୟ I think the weapon has been produced before. You come to
Yes.
the next page, that's
Ma'am.
70.
page number 70.
My lord.
My opinion as to.
Yes.
No, the IO has sent so seeking my opinion as to whether Khonati can cause the injury on the deceased by the M1.
My lord.
है ना?
My lord.
এবং
ତା ପୂର୍ବ ପାରା my
ତା
opinion
ପର
to
paragraph ଟା ହଉଛି relevant.
My lord.
IO also sent MO1 along with the requisition. I examined and gave my opinion in 5/1. I
Yes.
find that MO1 can cause the
External-
injury number 1 so and so.
Not all.
ଏଇ ଦିଟା
Minor.
ତ injury
Yes,
ଗୋଟେ
ma'am.
ହଉଛି bruise ଆଉ ଗୋଟେ ଇଏ ଆଉ
ହଁ ସେ
କଣଟା?
ଦି ଜଣଙ୍କ ଉପରେ କଥା ହଉଛି ଗୋଟିଏ ବାହାରିଲା ଖଣିତି
ନା ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା ଗୋଟେ ଥାର୍ଡ ୱେପନ ଆସିବାର
ନାଇଁ ସେଥିରେ ଦେଖ ସେଇଥିରେ ଅଛି ଯେ ଅଲଗା ସେ ଖଣିତିରେ ସବୁ ହେଇନି ଏୟା ହଉଛି କଥା ସେ ଡକ୍ଟର ଏଇଥିରେ ଇଏ କିମ୍ବା ଦି ଜଣ ଡକ୍ଟର ଅଛନ୍ତି ତେଣୁ ସିଏ କହିବା କଥା ମୁଁ କହିବା କଥା ଅନ୍ୟ କିଛି ଥାଇପାରେ ଅଲଗା ଆକ୍ୟୁଟ୍ ବି ଥାଇପାରନ୍ତି ଆଉ ଅଲ୍ ଅଦର ଥିଙ୍ଗସ୍ ହ୍ୟାଭ୍ କମ୍ ମାଇନର ବିକଜ ମାଇନର ଇଭେନ୍ ଦ ସ୍ପଟ ମ୍ୟାପ୍ ଇଜ୍ ଦେୟାର ଇନ୍
ହଉ ଆପଣ
Ma'am,
you
I'll
are
come.
going very fast.
नो ମ୍ୟାମ୍
ଯେତେବେଳେ ଗୋଟେ ପଏଣ୍ଟ କୁ ଆପଣ କ୍ୟାନଭାସ
My
କରୁଛନ୍ତି
lord.
ତା ଉପରେ ଫୋକସ କରନ୍ତୁ ଏବଂ ତାକୁ ଷ୍ଟିକ୍ କରନ୍ତୁ
My
ଏବଂ
lord,
ତାକୁ ଇଲାବୋରେଟ କରନ୍ତୁ
my lord,
ଆପଣ ବହୁତ ଫାଷ୍ଟ ଯାଉଛନ୍ତି
My lord,
ଗୋଟେ
actually-
ପଏଣ୍ଟ ଛାଡି ଆଉ ଗୋଟେ ପଏଣ୍ଟ ଆଉ ଗୋଟେ ଯେମିତି ଜମ୍ପ କଲା ଭଳିଆ
I don't give much emphasis to this MO1 because my
you
lord,
might not be giving much
my lord,
emphasis.
my lord,
Fact that when the IU visited the spot,
my lord,
the body was found.
Found.
One was dead, the other was in a surviving condition. And this particular weapon was found near
Near
the
the-
dead body.
my
So that was a Khonati which has been marked as MO1.
my lord,
Right?
my lord,
ବର୍ତ୍ତମାନ MO1 କୁ ଡାକ୍ତରଙ୍କ ପାଖକୁ ପଠା ହେଲା
ହଁ
ଯୋଉଟା ଅଣ୍ଡିସ୍ପୁଟେଡ ଥିଙ୍ଗ ଆମେ
ହଁ
କହୁଛୁ।
ଠିକ ଠିକ
ସେଇ ଯୋଉ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟରେ ଏଇ ଯୋଉ ଡିସିଜ ଟା ଯାହାକୁ PW4 ପୋଷ୍ଟମର୍ଟମ କରିଛନ୍ତି ଅର୍ଥାତ ତାଙ୍କ ନାଁ ହେଲା ଯଦୁ ସାହୁ ମେଲ ପର୍ସନ ମେଲ ପର୍ସନ ଦୁଇଟି ଇଞ୍ଜୁରୀ ସେ ନୋଟିସ କରିଛନ୍ତି ଗୋଟେ ଇଞ୍ଜୁରୀ ହଉଛି ଫୋର ହେଡ ରେ ଲେଫ୍ଟ ସାଇଡ ଫୋର ହେଡ ରେ ସେଟା ଗୋଟେ ଲାସେରେଟେଡ ଉଣ୍ଡ ଆଉ ଗୋଟେ ହଉଛି ବ୍ରୁଇସ୍ ରାଇଟ ସାଇଡ ଚେଷ୍ଟ ରେ ଯାହାର ଇଣ୍ଟରନାଲି ଫ୍ରାକ୍ଚର ହେଇଛି କେତେ ଗୁଡାକ ସେକେଣ୍ଡ ଟୁ ନାଇନ୍ଥ ଏତିକି ମାତ୍ର ଏକ୍ସଟର୍ନାଲ ଇଞ୍ଜୁରୀ ଏତିକି ବାକି ଯାହା ଇଣ୍ଟରନାଲ ଗଣତିଟାକୁ ତାଙ୍କ ପାଖକୁ ଯେତେବେଳେ ଆଇଓ ପଠେଇଲେ ତାକୁ ଏକ୍ସାମିନ କଲା ପରେ ଆଇଓ କହୁଛନ୍ତି ଇଞ୍ଜୁରୀ ନମ୍ବର 1 ଇଜ ପସିବଲ ବାଇ ଦିସ୍ ଗଣତି ହେଲା ଆପଣ ଯେତେବେଳେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କରିଛନ୍ତି ଆପଣ ତାକୁ ଡିକ୍ଲାଇନ କରିଦେଇଛନ୍ତି
ସେଟା ଭୁଲ ହେଇଛି ହଁ
So the evidence of the doctor PW4 has remained unchallenged.
unchallenged but he
You have not even given one suggestion that the
Your
report
report is
which
not
has
correct.
been given by you is not correct. The opinion which has been given by you is not correct. At least that contention ବର୍ତ୍ତମାନ ମଧ୍ୟ ଦେଇନାହାନ୍ତି
ସେଇଟା ନେଇ
ବର୍ତ୍ତମାନ ଆପଣ ଗୋଟେ ମେକ୍ ଆଉଟ୍ କରୁଛନ୍ତି ଯେ ପସିବିଲିଟି ଅଫ ଅମକ ଅଛି
ନା ସେଇଥିରୁ ଜଣା ପଡୁଛି ଯେ ସେକେଣ୍ଡଟା ହେଇନି ସେଥିରେ ଯଦି କହୁଛି ଫାର୍ଷ୍ଟଟା ହେଇଛି ଫାର୍ଷ୍ଟ ଇଞ୍ଜୁରିଟା ସେକେଣ୍ଡ ଇଞ୍ଜୁରିଟା ହେଇନି ହେଇଥିଲେ ସେ କହିଥାନ୍ତା ସେକେଣ୍ଡ ଇଞ୍ଜୁରି ହେଇଛି ବୋଲି ଇଟ୍ ଇଜ ପ୍ରୋସିକ୍ୟୁସନ ଟୁ ପ୍ରୁଭ୍
ସେକେଣ୍ଡଟା ଯୋଉଟା ବ୍ରୁଇଜ କ୍ୟାନ୍ ବି ପସିବଲ ବାଇ ଏନିଥିଙ୍ଗ
ସେଇଟା ହଉଛି
ଫଲ୍ ଅଲସୋ ଇଟ୍ କ୍ୟାନ୍ ବି ପସିବଲ ଜଣକୁ ଯେତେବେଳେ ମାଡ ହେଲା ଏବଂ somebody falls on a particular object
ଖଟ ଉପରେ ପଡିଗଲେ ମଧ୍ୟ
ସାଇଡରେ ହେଲେ ତାଙ୍କର ଓଲ୍ଡ ଏଜ ର ସେ ଲୋକଙ୍କର ଫ୍ରାକ୍ଚର ହେଇଯିବ ବ୍ରୁଇଜ ଆସିବ ବାହାରେ ଇଣ୍ଟରନାଲି ଫ୍ରାକ୍ଚର ହେଇଯିବ
ମୁଁ ଭାବିଲି ସେଇଟା ହଉଛି ଇମ୍ପୋର୍ଟାଣ୍ଟ କାହିଁକି ନା ଫାର୍ଷ୍ଟଟା ହଉଛି ଗୋଟେ ଇଞ୍ଚରେ ଅଧ ଇଞ୍ଚ ଯୋଉ ପ୍ରଥମ ଯୋଉ
ବ୍ରୁଇଜ ଆବ୍ରେଜନ ଆପଣ କାନ୍ଥରେ କୋଉଠି ଘଷି ହେଇଗଲେ ହେଇଯିବ ଆପଣ ନଖରେ ହେଇଯିବ ବ୍ରୁଇଜ ଆବ୍ରେଜନ ପୁରା
ନାଇଁ
ଏଇଟା କଣ ହେଇଯିବ
ଫୋର ହେଡରେ ଯୋଉଟା ହେଇଛି ଯୋଉଟା କହିଛି
ଫୋର ହେଡଟା ତ ହଉଛି ଖଣତି କଥା
ଖଣତିରେ ଯୋଉଟା କହିଛି ସେଟା ହଉଛି ମାତ୍ର ଇଞ୍ଚରେ ଅଧ ଇଞ୍ଚେ ମାନେ ବେଶୀ ଇଏ ନୁହେଁ ମୋ କହିବା କଥା ସେଇଟା ମେନ୍
ଫାଟାଲ ଇଞ୍ଜୁରୀ ନୁହଁ ଆପଣ
ମୁଁ
କହିବା
ଭାବିବା କଥା ଯେ ଦୁଇଟା ଯୋଉଟା ସେ କହିନି ସେଇଟା ହୁଏ ହେଇପାରେ ଛାତିରେ ଗୋଟେ ବ୍ଲଡ ସାଇଡ୍ ମାନେ ଖଣତିଟା ଗୋଟେ ଏତେ ବଡ ଜିନିଷ ଯୋଉଥିରେ ତାଡ ହୁଏ
ଯେ ଆପଣ ଯୋଉଟା ଖାଲି 1 inch କୁ ଦେଖିଲେ ତାପରେ ଦେଖନ୍ତୁ on dissection there is extra vessation of blood into the tissue spaces without any fracture of the underlying bone ର ଯଦିଓ fracture ନାହିଁ extra vessation of blood ଅଛି so it may not be exactly the extent yes
ସେ କହିବା କଥା ଯେ ଟୋଟାଲ କଣ୍ଟ୍ରିବ୍ୟୁଟରରେ ଦି ଜଣ ଘଟଣା ମୁଁ ଏଇଟାକୁ ଏଇ ଲାଇନରେ ଯେହେତୁ ଟିକେ ସମୟ କିଛି ପାଇଲିନି এই লাইনে কলি যে স্ত্ରୀ ପ୍ରଥମ ଦେଖିଛି ସ୍ୱାମୀ ପ୍ରଥମ ଦେଖିନି ସ୍ତ୍ରୀ ଆକୁଟାଲ ହେଇସାରିଛି ମୁଁ ସେଇ ବେସିସରେ ମୁଁ ଖାଲି ମେନଲି ଦେଖୁଥିଲି ତାଙ୍କର ଭାଇଟାଲ ଜିନିଷ ତାର PW1 ଯାହା ଉପରେ ବେସ୍ କରିକି ସେ କହିଛନ୍ତି ଷ୍ଟ୍ରେନ୍ ରିଲେସନସିପ୍ ସେ ଷ୍ଟ୍ରେନ୍ ବୋଲି କିଛି କହିନି ୱାର୍ଡ ସେ କହି ଦେ ଆର୍ ନଟ୍ ପୁଲିଂ ୱେଲ୍ ତାପରେ ଆଉ ଜଣେ କହିଛି ଦେ ଆର୍ ପୁଲିଂ ୱେଲ୍ ତେଣୁ PW1 ଗୋଟେ ଅଲଗା ଗାଁର ଲୋକ ସିଏ ତାକୁ 1 ନମ୍ବର କରାହେଇଛି ଯଦିଓ ଇନକ୍ୱେଷ୍ଟରେ ସକାଳେ ତାକୁ ତାର ଲୋକାଲ ଦି ପଟର ଯୋଉ ନେବର୍ସ ସେମାନେ ଇନକ୍ୱେଷ୍ଟରେ ଅଛନ୍ତି ସେମାନଙ୍କର ଷ୍ଟେଟମେଣ୍ଟ ନିଆହେଇଛି ତ ସେ ତାଙ୍କୁ ଏକ୍ସାମିନ କରିନି ଆଜ ଏ PW ଆଣିଛି ଜଣେ ବାହାର ଗାଁର ଲୋକକୁ ପ୍ରଥମ PW1 କରିକି ଆଣିଛି ଯାହାର ଟିକେ ଷ୍ଟେଟମେଣ୍ଟ କ'ଣ ନା ଦେ ଆର୍ ନଟ୍ ପୁଲିଂ ୱେଲ୍ ସେଇଟା ପରେ ବେସ୍ କରିଛି କନଭିକ୍ସନ ତେଣୁ ମୋ କହିବା କଥା ଯେ ଭାଇଟାଲ ଏଭିଡେନ୍ସକୁ ସେ ଇଗ୍ନୋର କରିକିନି ଯେ ଯୋଉଟା ଗୋଟେ ନୁହେଁ ବୋଲି ନଟ୍ ପୁଲିଂ ୱେଲ୍ ଷ୍ଟ୍ରେନ୍ ରିଲେସନସିପ୍ ଆଇ ୱାଜ୍ ଗୋଇଂ ଥ୍ରୋ ଅଲ୍ ଡିକ୍ସନାରିଜ୍ ଷ୍ଟ୍ରେନ୍ ରିଲେସନସିପ୍ ନୁହେଁ ନଟ୍ ପୁଲିଂ ୱେଲ୍ ଇଜ୍ ୱାନ୍ ଥିଙ୍ଗ or pulling well is another thing but not pulling well doesn't mean that it is strain relationship se strain relationship unless judgment रे जोटा कि not based on record तेणु मो कहा था जजमेंट रे तीनटा जो जिनिस आनले आ गोटे जिनिस आनले जे हमर जो डाक्टर खार प्रथम गलानी 4:30 रे घटना हला स्त्री देखिला से गला 6:10 मिनिट रे एफआईआर रजिस्ट्रेशन सरीची मात्र 1 घंटा 40 मिनिट ता भीतर से जाईची एफआईआर लिखिची এবং যাকে আয়ো କହିଛନ୍ତି ইন্সপেক্টর আয়ো କହିଛି ତୁ ଚାଲ ଆମେ ଯାଉଛୁ ଆୟୋ ଆସିଛନ୍ତି 10:30 ରେ କ୍ୟାନ୍ ଏ ପର୍ସନ ହୁଜ୍ ଫାଦର ମଦର ଇନ୍ ସଚ୍ କଣ୍ଡିସନ ଆଭଏଡ୍ the direction of IO or IAC without voting you will go anywhere you are voting waited
To see that the mother dies, but the
mother died next mother
he will wait for the inspector.
no my lord what can my lord what happened first time my lord I'll come to those things, but here, my lord, at least on this point, when the police came, police told him to accompany to hospital. He accompanied, and postmortem was there. He's the only son, adopted son maybe. So he had to make the cremation and other things because it is a village. So he had brought back also the dead body, the appellant. So appellant remained there, and at 3:30 or 3:40 p.m. doctor advised to shift, and 3:45 reported that attendant did not. Who was the attendant? Definitely he was not attendant because he was accompanying the postmortem and took back the dead body for his father's cremation. Mother was on coma or unconscious, that is different because he is a man. In the early morning, he might not have money. Who was the attendant? How could he not? It was the duty of the police to send hospital if required. So that is also another point, main point. When I will come to point by point, I will explain two things. On 3 points, the Lord Session just convicted me. First, that there was strain relationship. There was no strain relationship, no have strain. Strain doesn't mean that not pulling well. Pulling well, and there is rather evidence that they were pulling well. जदियो से आजू बाहर जाइथिला तो से घर से रहिथिला जदियो से डरी मरी के रहिथिला किंतु जाऊ से रहिथिला गोटे स्टोर रूम रे तीनटा स्टोर रूम भीतर गोटे स्टोर रूम रे आधार से रहिथिला आ ये रहिथिला छात घरे आ इथरे एंटायर स्पॉट मैप इज एरेनियस बिकॉज़ से जो कोठा घर तीनटा बखरा से कोठा घर बारंडा रुच स्टेयरकेस जोटा देखाई स्पॉट मैप रे से स्पॉट मैप रे देखाई एडजस्टस घर जोटा होची staircase, it is not correct, minor. And the spot map is totally erroneous, north, south, east, west also not correct, minor. I have pointed out in my small notes thereafter, minor, and I will explain. So, my lord, I was just saying about the first thing that the second affair I was giving much emphasis because it's a legal point. And no material evidence came out, no more material evidence. Basing the previous evidence, he called for the opinion. And opinion was already there. So, it cannot be said as a new evidence for which second FIR would be filed. And previous...
out of the data theorem, sample panel. IO किए
आयो होची दी जण आयो ଜଣେ କଲା ଟ୍ରାନ୍ସଫରିଂ
କିଏ ଆମେ ପଚାରୁଛୁ ଆପଣ ଅଧିକା କହିଲେ
ଆଇ ହଉଛି ମୂର୍ତ୍ତି ପ୍ରଥମ ଏକ୍ସାମ୍ କଥା ମୂର୍ତ୍ତି PW 13 PW 14 PW 13 ପ୍ରଫୁଲ୍ଲ ଚନ୍ଦ୍ର ବାରିକ
13-14 evidence can spot map କିଏ ତିଆରି କରିଛି
PW 14 PW 13 the IAC.
where he has stated that I have prepared the spot
My lord, he has signed he has also stated.
come to paragraph number 10 page number 8
Yes, my lord.
page number 88
My lord. Page number 88.
88 88 paragraph 10
My lord. Exhibit 22. I have visited the prepared the.
no, I had prepared the spot map
My lord.
ଆପଣ जो ଆମକୁ ବର୍ତ୍ତମାନ ସବମିଶନ କଲେ ଏ ସ୍ପଟ ମ୍ୟାପ ଟା ଠିକ ସେ ପ୍ରିପେୟାର ହେଇନାହିଁ କୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା ପଚାରିଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନେସନ
ପଚରା ହେଇନି ବା କିନ୍ତୁ ତାର ଦିଗ ବିଗୁଲ ସମ୍ପୂର୍ଣ୍ଣ
ନା ଦିଗ ମଧ୍ୟ
ସେଥିରେ ଅଛି ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ
ଆପଣ ସ୍ପଟ କୁ ଯାଇଛନ୍ତି ନା କଣ
ମୁଁ
ଯେମିତି ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି
ହଁ
ମାନେ ଲାଗୁଛି ଯେମିତି
ସେ
ଆପଣ
ଗତକାଲି ରାତିରେ ମୁଁ ଆଉ ଆମର ପ୍ରିଭିୟସ କାଉନସିଲ ଆମେ ସେ ପ୍ରଥମ ଥର ପାଇଁ ସେ ଆପିଲେଟକୁ ପଚାରିଥିଲୁ ସବୁ ସେ କହିଥିଲେ ଯୋଉଟା ତାପରେ ସେଇଥିରୁ କିଛିଟା ମେଳ ଖାଉଛି ଏଥିରେ ମାନେ ଯେ ଆମର ଆସିଛି କିଛି ଷ୍ଟେଟମେଣ୍ଟରେ ଆସିଛି ୱିଟନେସ୍ କିଏ ତାର ସାଇଡ୍ ନେବ
Mr. Das, the thing is that when the investigating officer who has prepared the spot map, he has not been put a single question
not
that your spot map is not correct. You have not projected the spot in a correct manner. How can you, at the appellate stage, on what basis you say that the spot map has not been prepared correctly?
My lord, one thing.
Are we the persons who are to just go and imagine something?
No, my lord,
which is not on record?
my lord, basic thing. My lord, may kindly see basic thing of the spot map. Spot map re jo 6 rela well, that is surrounded like a boundary, but it is not a boundary. It is open. My lord.
How can we know right now? This spot map basing on which the evidence was laid, that is how evidence has to be brought on record. Basing on that, we can appreciate a fact. But in absence of a particular question brought on record, now if you say that it is not like this, it is not like, how can we appreciate it?
Either IO को पचार था बा कोनोसी जो से घर को जो माने जाइथिले बाबू ये तम ये आईओ को देखलो एमती प्रिपेयर करिछि एक्चुअली से ए पोजीशन एया नाही हमको अछि एटी गुडा हमको देखैछि आपण ना आईओ ना अन्य थ्रुरे किछि आनिचंती वर्तमान आपण सबमिशन करूचंती जे येटा प्रॉपर्ली प्रिपेयर हे नाही
सामान्य अछि एथिरे सामान्य अछि जेथिरे स्टेटमेंट ऑफ PW9 ले जे
ट्रायल कोर्ट रे जे आर्गुमेंट प्रिपेयर करले से कोन क्रॉस एग्जामिनेशन करछंती
बहुत बड़ा वकील किछि कहि ना
हां ताले आपण करबे
अटक जाइथिले
ना नहीं वी आर नॉट ऑन दैट
किछि करना किंतु मु खाली मु देखिली जे सेहिथिरु जे प्रथम कथा हला जे से ये आईओ एविडेंस जणा पड़ुची जे जोटे प्रथम आईओ जे थिला जे PW15 से कहउचंती जे से 10:30 रे पहुंचले सांग होइकि कासतन आईआईसी सहित आईआईसी क्रॉस जॉइन कहछि सांगिक बोथ आईआईसी एवं सब इंस्पेक्टर बोथ अरेव एट 10:30 अच्छा से कहछि ना ये कहछि PW1 कहछि जा पर कहउछि स्टेट रिलेशनशिप से माने पहुंचले 7:30 रे तन हमें विश्वास करबा PW1 को ना आईओ तेणु आईओ कहछि 10:30 रे पहुंचले ये कहछि 7:30 रे एवं ये बाहर गाना लोक तार ऊपर रिलेशन बेस करके ये कहदला तार स्टेट रिलेशनशिप कहदले सेशन जज तेणु एथिरे टू ब्रिंग होम द चार्ज इज द ड्यूटी ऑफ प्रोसिक्यूशन माने एक्चुअली हैव टू टेक ऑल बेनिफिट ऑफ देयर लैचेस I am just pointing out the latches.
How do you say that PW1 is a man from different village?
My lord, may kindly see his
no,
statement.
you see it.
Yes, my lord.
As a neighbor,
No,
went to their
never କହିଛି କିନ୍ତୁ ଅଲଗା ଗାଁ ବୋଲି ତାର ଏଥିରେ ଉପରେ ଲେଖା ହେଇଛି ତାର
statement
statement ତା statement
ଆପଣ ତାକୁ ପଚାରିବେନି ଆଉ
ନାଇଁ ତା statement ସିଏ ନିଜେ କହିଛି my lord, my age is 39, my home is at Mauja, Gauripur, different village. ଏବଂ he is working as a laborer in Jotini. ତାକୁ ବୋଧହୁଏ ସେଇଠି ଖାଲି ଗୋଟେ ରେକର୍ଡିଂ ହେଇଛି ପୁଲିସ ଷ୍ଟେସନରେ
କୋଉଠି ଅଛି ସେ
ମାଇନର ମେକାନିକ
ଜଟଣୀରେ କାମ କରୁଛି ବୋଲି
ରିଟନ୍ ବାଇ ହ୍ୟାଣ୍ଡ ବାଇ ଦ
ଜଟଣୀରେ କାମ କରୁଛି ବୋଲି କଣ
କାମ କରୁଛି ବୋଲି ସେ କହିଛି
କୋଉଠି
ଏଥିରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କହିଛି
କାଇଁ?
police examined me on 14/8/96 and again also 3 to 4 months after police examined me in this case. I work as daily laborer at Jotni. I got visiting right. Visiting terms. See, only that. Visiting terms.
different ଗାଁ ସେଟାକୁ ଆମେ ବର୍ତ୍ତମାନ କହିପାରିବାନି
ଆପଣ କହିବା କଥା ଥିବ ଆମ ପାଖରେ ନାହିଁ କେସ୍
ଆପଣଙ୍କର PW1 ର ଏଭିଡେନ୍ସ କୁ ଆସନ୍ତୁ ସେ କହୁଛି ମୋର ଓରିଜିନାଲ ଘର ହଉଛି ଏଠି କିନ୍ତୁ ମୁଁ ଯୋଉ
ରହୁଛି
ବର୍ତ୍ତମାନ ରହୁଛ କୋଉଠି ସେ କହୁଛି ପଛରା ମାନେ ଯୋଉ ଘର
ଯୋଉ ଗାଁରେ ଇନସିଡେଣ୍ଟ
ସେଇଠି ଇଜ ନେଭର
ଥାନା ହଉଛି ଜଟଣୀ ଖୋର୍ଦ୍ଧା ହୁଏର ଆମର ଲେବର
ସାର୍
ତା ଘରଟା ଓରିଜିନାଲ ଘର ହଉଛି ସେଠି କିନ୍ତୁ ସେ ରହୁଛି ଏଠି
ସେଟା ବେଗୁନିଆ ଥାନା ଅଣ୍ଡରରେ ଏଟା
ମୁଁ ଆଗେ
ଜଟଣୀ ଥାନା ଅଣ୍ଡରରେ
ସେ କିନ୍ତୁ ସେ ରହୁଛି ରହୁନି ସେଠି
My home is at Mauja, Gauripur, police station Begana, Begunia, East Khorda. I reside at present Mauja, Pachara, police station.
ये एड्रेस ଆଉ ମାନେ
ସେଟା ତ ନିଆ
permanent address
ଡିପୋଜିସନ ସିଟ୍
ବାଛରା
ଓରିଜିନାଲ ଘର କୋଉଠି ବର୍ତ୍ତମାନ ରହୁଛି
କିନ୍ତୁ
ଯଦି ସେ କଥା ନା ମୁଁ ସେଇଠି ରହିଛି ତାହେଲେ ଡୁ 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 ମରା ହେଇଥାନ୍ତା ଯେହେତୁ ସେ ଅନ୍ୟ ଇଏରେ ରହୁଛି ତେଣୁ ସେଟା ଲେଖା ହେଇଛି
that's the right way of taking
ହଁ
କିନ୍ତୁ ସେ ଯୋଉଟା ସେ ଯଦି କହୁଛି ଘଟଣା 7:30 ଆସିକି ପହଞ୍ଚିଲା 7 ସେ ଥିଲାବେଳେ ପୋଲିସ ଆସିକି ପହଞ୍ଚିଲା 7:30 କିନ୍ତୁ ପୋଲିସ ନିଜେ କହୁଛନ୍ତି 10:30 ଆସିଲେ ତାମାନେ ତା କଥା ସେ
ପ୍ରଶ୍ନ ପଚାରିଥାନ୍ତେ ୟାକୁ କିମ୍ବା ତାକୁ
ଆଜ୍ଞା
କାହାକୁ ଗୋଟେ କ୍ୱେଶ୍ଚନ ପଚାରିଥିଲେ ଆଣିଥାନ୍ତେ
ଆଇଓ ପରବର୍ତ୍ତୀ ଲାଷ୍ଟରେ ଆସୁଛନ୍ତି ଆଇଓ ହଉଛନ୍ତି ମେନ୍ କେସର ମେନ୍ ସୂତ୍ରଧାର
ନାଇଁ ଯେ PW1 has stated that you have reached arrived at the place of incident or spot at 7:30 what do you say କହିଥାନ୍ତା
6:10 ରେ ଯେହେତୁ FIR ଦେଇଛନ୍ତି 7:30 ରେ ପହଞ୍ଚିବାଟା କିଛି
unusual ନୁହଁ
ନା ଅନୟୁଜୁଆଲ ନୁହେଁ କିନ୍ତୁ ସେ କହୁଛନ୍ତି 10:30 ରେ ପହଞ୍ଚିଲେ ତାପରେ ଟାଇମ ଯୋଉଟା ନ୍ୟାରେଟ୍ କରିଛନ୍ତି ତା ପରର ଏଣ୍ଟାର ଏଭିଡେନ୍ସ ଅଫ ଆଇଓ ବୋଥ ଆଇଓ ସେମାନଙ୍କ ସବୁ ତାପରେ
and one of the patient who was only in the state of unconsciousness could not have been awaited for the treatment and you say
ସେଇଟା ଇଏ ଯଦି ହଠାତ୍ ଘଟଣା ଦେଖିଛି ଇଏ ହଠାତ୍ ଦୌଡ଼ି ଯାଇଛି ଥାନାକୁ କାରଣ ଏ ଥାନାରେ ପହଞ୍ଚିକିନି FIR ସବୁ ସରିଯାଇଛି 6:10 ତେଣୁ ସେଠୁ ଇଏ କେତେବେଳେ ଫେରିଛି ଏବଂ ତାପରେ ଇଏ ୱେଟ୍ କରିଛି ତାଙ୍କୁ ପୋଲିସକୁ
ସେ ସବୁ ସକାଳ ସେ ସବୁ ଜାଣିଛି ସେ ଆଗେ ପଳେଇଗଲା ଥାନାକୁ ସେଟା କାହିଁ ବୁଝିବେନି
ସେଇଟା ହଜର କହୁଥିଲେ ସେଦିନ କିନ୍ତୁ ମୁଁ କହିବା କଥା ଯେ ସିଏ ଗୋଟେ ସାଧାରଣ ଲୋକ ପୋଲିସ ଯେତେବେଳେ ପୋଲିସ ଆସିବା ପୂର୍ବରୁ ତାପରେ ସିଏ ଯୋଉ ଅନକନସିୟସ୍ ଥିଲା ସେ ଅନକନସିୟସ୍ ଯେ ସେ ଡେଥ୍ ହେଇଯିବ ତାପରେ
ଜଣେ ସାଧାରଣ ଲୋକଟା ଗୋଟେ that is how we always put a rational question and a normal human prudence what is normal human prudence that ଯେତେବେଳେ ଗୋଟେ ଜାଗାରେ ଜଣେ ଗୋଟେ କ୍ଷତ ହେଇଯାଏ ତାକୁ ଆଗେ ବଞ୍ଚେଇବା ପାଇଁ ଲୋକଟା ଚେଷ୍ଟା କରିବ ନା 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 ଆଗେ ପନିଶମେଣ୍ଟ କାଳେ ହେଇଯିବ ବୋଲି ଯାଇକି ସେ ଆଗେ FIR ଟାକୁ ଦବ
ସେଠି ଯୋଉ ଲୋକ ସେଠି ଯୋଉ ଗାଁ ଲୋକ ଥିଲେ ତାର ପଡିଶା ଯୋଉମାନେ ଥିଲେ ଯୋଉ ସେମାନେ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି
which hypothesis is more correct the rationality here comes the prudence here comes ଏବଂ ସେଇ
ବାପା ମା ପଢିଛନ୍ତି ଯଦି ଏଇ ଟାଇପ ର କଣ୍ଡିସନ ଆଗେ ପରା ଯାଇ ଧରିବା କଥା
ଟେକିକିରି ଉଠେଇକିରି ଆଗେ ସେ ନିଜେ ଯିବ ଟେକିକିରି ଉଠେଇକିରି
କିଛି ଜାଣିନି ଥାର୍ଡ ପର୍ସନ ଆସିକି
ସେଠି ଆସିଛନ୍ତି ପଡିଶା ଯୋଉମାନେ କି ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି ନା ଅଛି
ଆପଣଙ୍କର ଶରୀରରେ ବ୍ଲଡ ଷ୍ଟେନ୍ ବି ଲାଗିନି ଟିକେ
ସେ ବି ମଧ୍ୟ ଯଦି ଘଟଣା ଘଟିଥାନ୍ତା ତା ଦେହରେ ବି ମଧ୍ୟ ଯଦି 2 ଜଣ ଲୋକଙ୍କୁ ମାରିଦେଇ ଜଣେ ତା ଦେହରେ ବି ସାମାନ୍ୟ ଟିକେ ସ୍କ୍ରାଚ୍ ବା କିଛି ଗୋଟେ ତାର ନାହିଁ ସମସ୍ତେ କହିଛନ୍ତି 2 ଜଣ ଆୟୋ କହିଛନ୍ତି ସମସ୍ତେ କହିଛନ୍ତି
ସ୍କ୍ରାଚ୍ ଦରକାର ନାହିଁ ସ୍କ୍ରାଚ୍ ବି ହେଇ ବି ଥାନ୍ତା ଯାହା ବି ହେଇଥାନ୍ତା କିନ୍ତୁ କୋଉଟାକୁ ଆମେ ରାସନାଲ ବୋଲି କହିବା ଯେ ମୋ ବାପା ମାଟା ପଡିଛି ବାପାକୁ ଦେଖିକିରି ମୋ ପାଖକୁ ସେ ଛୁଇଁ ନାହିଁ ମୋଟେ
ସେ ଛୁଇଁନି ମାନେ
ମାଟା
ସିରିୟସ୍ ଘଟଣା ବୋଲି ହବ
ତାକୁ ସେ ଦେଖୁନି father 75 mother 65 and appellant expecting that they will resist
till the
father said but room ଟା ହଉଛି 8 ଫୁଟ 10 ଫୁଟ 8 ଫୁଟ 10 ଫୁଟ ଭିତରେ ସେ ପଡିଛନ୍ତି ତା ଭିତରେ କଣ ପଡିଛି ତା ଭିତରେ ସବୁ ପଡିଛି ସେ ଡରେ ତାକୁ ସର୍ଚ୍ଚ କରିନେ କାରଣ କାଳେ କଣ ହେଇଯିବ କି କାରଣ ପାଖ ପଡିଶା ଲୋକ ଯୋଉମାନେ ଆସିଛନ୍ତି ଇନକ୍ୱେଷ୍ଟରେ ଅଛନ୍ତି ତାଙ୍କୁ ଏକ୍ସାମିନ
ଡରିଛି ପୋଲିସକୁ ଅଥଚ ଯାଉଛି ପୋଲିସ ପାଖକୁ
ନା ସେ
କାହାକୁ ଡର
ପୋଲିସ
ଲାଗେ?
କହିବା ପାଇଁ ପୋଲିସ କହିବା ପାଇଁ ଘଟଣା ଘଟିଛି ମାନେ
ହଁ,
ପୋଲିସ
ସେ-
କହିବା ପାଇଁ କାରଣ ବାହାର ଲୋକ ସିଏ ଭାବି ନେଇଛି ଯୋଉମାନେ ତା ବଡ ଭାଇକି ମାରିଥିଲେ ସେମାନେ ମାରିଛନ୍ତି ବୋଲି ସେ ଭାବିଛି କାହିଁକି ନା ସେଠି ମଧ୍ୟ ଯୋଉ ସ୍ପଟ ମ୍ୟାପଟା ଯଦି ଆକ୍ଚୁଆଲ ହେଇଥାନ୍ତା ତାର ଗୋଟେ ସାଇଡ୍ ଯୋଉ ସାଇଡରେ ସାଇଡ୍ ଡୋର ଅଛି ସେଇ ସାଇଡ୍ ତାଙ୍କ ନିଜର ବାଡି ସେ ବାଡିରେ ଆମ୍ବ ଗଛ ଲାଗିଛି ଏବଂ ତାପରେ ହଁ ଏଠି ଦେଖେଇଛି ତାର ବାରଣ୍ଡା ଫ୍ରଣ୍ଟ ସାଇଡ୍ ବାରଣ୍ଡା ଯୋଉଟାକି ଦେଖେଇଛି ବନ୍ଦ ହେଇଛି ବନ୍ଦ ନୁହେଁ ଦ୍ୟାଟ୍ ଇଜ ଓପନ୍
ବଡ ଭାଇର ଇଏରେ କେସରେ
ହଁ ଏଗୁଡା ସବୁ କାଲି କଣ ତାର ପଚରା ପଚରି କରିବା କଣ ଗେଟ୍ କଣ ଓପନ କଣ ନୂଆ କଥା କଣ କହୁଛନ୍ତି
ନାଇଁ ସାର୍ ବାରଣ୍ଡା ଘର ଗାଁର ଯୋଉ ବାରଣ୍ଡା
ଏଇ ଯୋଉ ତା ଦେହରେ କବାଟ ନାହିଁ
ନାଇଁ କବାଟ ରୁମରେ ଅଛି
ହେଇ
ରୁମରେ
ସେ
ଅଛି
ଯୋଉ ଘରକୁ ଯୋଉ ଦିଟା ବାଟ ପଶିବା ପାଇଁ ସେ ଦିଟା ବାଟରେ କଣ କବାଟ ନଥିଲା
ନାଇଁ ଦାଣ୍ଡ ପଟରେ ଥିଲା କି ନାହିଁ ସେ କଣ ଆସିଲା ଯେ PW9 ଆସିଥିଲା ରାତିରେ ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କ ଭିତରେ ସେଇଟା ନଟ୍ ଡିସ୍ପ୍ୟୁଟେଡ୍ ଆସିଥିଲା ସିଏ ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କ ଭିତରେ ଘଟଣା ମୀମାଂସା କରିବା ପାଇଁ
PW9 completely hostile.
ହୋଟେଲ
He has not
ସେଇଥିରେ ସେଇଥିରେ
And,
ପର୍ସନ ହୋଟେଲ ପୂର୍ବରୁ ଯାହା କହିଛି
Trial court
ନାଇଁ
discarded
ନାଇଁ
his
ସେ ଘରେ ଆପଣ ସେ ଯୋଉ
ହଁ।
ପର୍ସନ ଦେଖଉଛି ସେ ଘରକୁ ପଶିବାକୁ ଦିଟା ବାଟ ଅଛି
ସାମ୍ନାରେ ଗୋଟେ ଡାନ ପଟେ ଗୋଟେ
ଠିକ ତ
ହଁ
ସେ କବାଟ ଥିଲା ନା ବନ୍ଦ ଥିଲା
ସେଇଟା କିଏ କହିବ ସେଇଟା ପ୍ରୋସିକ୍ୟୁସନ କହିଥାନ୍ତା ସେଇଟା ଜଣା ନାହିଁ କାହିଁକି ଜଣା ନାହିଁ ସିଏ ତ ଉଠିଲା ବେଳକୁ ଯେତେବେଳେ ତା ସ୍ତ୍ରୀ କହିଛି ସେତେବେଳେ ସିଏ କହିଲା ବହୁତ ଲୋକ ତାର ସବୁ ଆସିଛନ୍ତି କେମିତି
ଆଚ୍ଛା, ସେ ଯୋଉ ବାଟ ଯୋଉ ସିଡି ଘର
ଦି ପଟ ହଁ ନାଇଁ ଦି ପଟେ ଏପଟେ ଆରପଟେ ବି ଲୋକ ଅଛନ୍ତି ଲୋକଙ୍କ ଘର
ନାଇଁ 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 ମୁଁ ସେ କଥା କହୁନି ଆଉ ଗୋଟେ ଯୋଉ ସିଡି ହେଇଛି ମଝିରେ ଗୋଟେ ସିଡି ହେଇନି
7 number.
ବାରାଣ୍ଡାରେ ହଁ ବାରାଣ୍ଡାରେ ହଁ
ବାରଣ୍ଡାରେ ଯୋଉ ସିଡି ହେଇଛି ସେଠି ସିଡି ଘର ଥିଲା ନା ସେଟା ଓପନ ଥିଲା
ତା ପାଇଁ ବାଟ ଏଇଟା ଦରକାର ନାହିଁ ହଜୁର କାହିଁକି ନା ଇଣ୍ଟରଟା ଫାଙ୍କା
ଦରକାର କି ନାହିଁ ତ
ହଁ
ଅଲ୍ ରାଇଟ୍ ହଁ କରେକ୍ଟ ସେଟା ପୁରା ଫାଙ୍କା ତ
ପୁରା ଫାଙ୍କା
having access to the veranda
ହଁ
from the room
ହଁ
where the deceased were lying
ହଁ
ଏଇଟା ତ
ହଁ
ହଁ ତାହେଲେ ଆଉ କଣ
ତେଣୁ-
that is accessible to
ତେଣୁ
room number 3 or not
ଯଦି ସେମାନେ ଘରେ
ନାଇଁ
ଶୋଇଥିଲେ
room number 3 କୁ ସେଟା accessible କି ନୁହଁ
ନାଇଁ ଯଦି ଘରେ ଶୋଇଥିଲେ ରୁମ୍ ଟା କିଏ ଭାଙ୍ଗିକି ପଶିଥାନ୍ତା କବାଟ ଭଙ୍ଗା ହେଇଥାନ୍ତା କିଛି ମାରିଥାନ୍ତା କିଛି ସେମିତି କିଛି ଆସିନି ଇନଭେଷ୍ଟିଗେସନରେ
ନାଇଁ ତ 3 ରୁ 10 କୁ ଆସିବାରେ କଣ ଅସୁବିଧା ଅଛି ରୁମ୍ ନମ୍ବର 3 ରୁ 10 କୁ
ନା
ଆସିବା
କିଛି ଅସୁବିଧା ନାହିଁ
ନାଇଁ ତ।
ବୁଲି ଯାଇପାରିବେ ପୁରା ରିଚାର୍ଜ ଫାଙ୍କା କିନ୍ତୁ ଅନ୍ୟମାନେ ବି ଆସିବାର ଚାନ୍ସ ଅଛି
ଅନ୍ୟମାନେ କୋଉ ପଟେ ଆସିବେ କହୁନାହାନ୍ତି
ସେ କହିଛି ନା ପ୍ରକୃତରେ ଡାନ ପଟଟା ହଉଛି ତାର ବଗିଚା ମାନେ
ପ୍ରକୃତରେ
ଯୋଉଟା ଛୋଟ ଜିନିଷ ଥିଲା ନାଇଁ ସେଥିରେ ଅଛି ସ୍ପଟ୍ 14 ମାଇଲର ସ୍ପଟ୍ 14 ଦ ଡୋର
14 door ଗୋଟେ ଅଛି।
14 ଯୋଉ ଡୋର ଅଛି
ହଁ, 14
ସେ ଡୋର ହଁ ସେଇଠି
ସେଟା ଖୋଲା ଥିଲା ବୋଲି କିଛି
ନାଇଁ ସେଟା ଗୋଟେ ଭଙ୍ଗା ଥିଲା ସେ ଲେଖିନି ଭଙ୍ଗା ଥିଲା ଗୋଟେ ଟିଣର କବାଟ ଲାଗିଥିଲା ଆଚ୍ଛା
କୋଉଠି କଣ
କାଲି ଶଶୀ କାଲି ଯାଇଛନ୍ତି ବୋଧେ
ସ୍ପଟ୍ 14 ନାଇଁ ଘଣ୍ଟାଟେ କାଳ ଆମେ ଦି ଜଣ ତାର ବୁଝିଲି ଘଟଣାଟା କଣ ଅତି କମ
ଆପଣ ବୁଝେଇବା କି ନିଜ ହିସାବରେ କଲେ କେମିତି ହବ ଯାହା
ନାଇଁ,
ଅଛି ଡକୁମେଣ୍ଟ ତାକୁ ବେଶ କରିଥାନ୍ତେ
ସେତିକି ଯଦି ଆପଣଙ୍କର ଟ୍ରାଏଲ କୋର୍ଟ ଯଦି ସେଠି ବୁଝିକିନି ଜେରାଟି କରିଥାନ୍ତେ ତାହେଲେ ବହୁତ କିଛି ବେନିଫିଟ
ହଁ ନିଶ୍ଚୟ ଠିକ
ଆପଣ ଯଦି ପଚାରିଛନ୍ତି କହୁଛନ୍ତି ଘଣ୍ଟାଏ କାଳ ଆମେ ପଚାର
ନାଇଁ ସେ ସୁଦର୍ଶନ ବାବୁ ଆଉ ମୁଁ ତାଙ୍କୁ ବୁଝେଇଲା ଆମେ ଏପଟେ ନାଇଁ ସେଥିରେ ନାହିଁ ସେ ଆମ ପିଲା ସେଥିରେ ନାହିଁ ନାହିଁ
କୁହାଯାଏ ଯେ ୱିଟନେସେସ୍ ଆର୍ ଆଇଜ୍ ଆଣ୍ଡ ଇୟର୍ସ ଅଫ୍ ଦି କୋର୍ଟ କାରଣ ଘଟଣା ବେଳେ ଆପଣ ନଥିଲେ କି କୋର୍ଟ ବି ନଥିଲା ଯେ ଟ୍ରାଏଲ କୋର୍ଟ ଯିଏ ବି ଜଜମେଣ୍ଟ ଦେଲେ ସିଏ ବି ନଥିଲେ ତେଣୁ ଏଭିଡେନ୍ସ ଯାହା ରେକର୍ଡରେ ଆସିବ
ମୁଁ କହିଲି କାହିଁକି ନେବର୍ସ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି
neither you can replace nor you can substitute you have to stick to the evidence only
ଏଭିଡେନ୍ସ ଆସିଛି ଦି ପଟ ନେବର ଇନକ୍ୱେଷ୍ଟ ଏଭିଡେନ୍ସ ଦି ପଟ ଯାକ ଡାନ ପଟ ବାଁ ପଟ ଯୋଉଟା କି ଡାନ ପଟେ ଆଙ୍କ ବାଡି ପାଖରେ ତାଙ୍କ ଘର ଏପଟେ କିନ୍ତୁ ତାଙ୍କୁ ଇନକ୍ୱେଷ୍ଟ
ନା ଏବେ ଯୋଉ ଆପଣ କହୁଥିଲେ PW1 ଟା ଅମୁକ ଜାଗାର ଏବେ କଣ ହେଲା
ଆଜ୍ଞା
ଏବେ PW1 ଟା ତ ବଛରାର ନେବର ତ
ମୁଁ ତ ଜାଣିନି ମୁଁ ତ ସେଇଟାକୁ ସେ କହିଲା ବାହାରେ ସେ କହିଲା ତା ଘରଟା ବାହାରେ ସେ ଗାଁରେ କହିଲା କିନ୍ତୁ ଏଥିରେ ଲାଷ୍ଟ ଟିକେ ଲେଖି ଦିଆଯାଇଛି ମୁଁ ଆଉ
ଟିକେ ଲେଖି ଦିଆଯାଇଛି ମାନେ
କିନ୍ତୁ ସେ ହଉଛି ଗୋଟେ ଡେଲି ଲେବର
ତାର ପରମାନେଣ୍ଟ ରେସିଡେଣ୍ଟ ଏବଂ ବର୍ତ୍ତମାନ କୋଉଠି ରୁହା ହଉଛି ତାର ସେକେଣ୍ଡ
ସେ କହୁଛି ଭିଜିଟିଂ ଇଏ ଅଛି
ଶୁଣନ୍ତୁ ଆପଣ ତାମାନେ କହୁଛନ୍ତି ଯେ କଟକରେ ଯିଏ ଅଛି ସେ ଭୁବନେଶ୍ୱରରେ କାମ ଯଦି କରିବ ତାମାନେ ସେ ରହୁଛି ଭୁବନେଶ୍ୱର
ନାଇଁ ସେ 2-4 କିଲୋମିଟର ଦୂରରେ ଯଦି ଅଛି ସେ ହଠାତ୍ ସକାଳୁ ଯୋଉଟା ଆସିଥିବାଟା
ନେବର କହୁଛି ସେ ଏଭିଡେନ୍ସ ଦେଇଛି ମୁଁ ନେବର ବୋଲି
ନେବର ମାନେ ନୁହେଁ ସାର୍
ଆପଣ କହିଲେ ହବ କି ଯାହା ଏଭିଡେନ୍ସ ଅଛି ନା
ସେ କହିଦେଇଛି କିନ୍ତୁ ନେବର ଯିଏ ଲେଖା ହେଇଛି ବିଦ୍ୟାଧର ପାଣ୍ଡବ ଦିପଟ ନେବର ସାକ୍ଷୀରେ ଆସିଛି ସିଏ କିନ୍ତୁ ଏକ୍ସାମିନ ହେଇନାହାନ୍ତି ଯଦିଓ ସେ ଇନକ୍ୱେଷ୍ଟ ଏଭିଡେନ୍ସ ୱିଟନେସ୍ ଇନକ୍ୱେଷ୍ଟ ୱିଟନେସ୍ ଅଛନ୍ତି ପୋଲିସ ପାଖରେ ପୋଲିସ କହୁଛି ତାଙ୍କୁ ଏକ୍ସାମିନ କରିଛି ଦି ଜଣଙ୍କ ଆୟୋଗ କହୁଛନ୍ତି କିନ୍ତୁ ତାଙ୍କୁ ଇଏ ୱିଟନେସ୍ କରାହେଇନି
ଆଉ କଣ କହିବେ ନା କ୍ଲୋଜ କରିବେ?
ନା ଆଉ କହିବି ଆଗକୁ କହିବି ରିଟିନ୍ ସବମିଶନ ଟା କ୍ଲୋଜ କରିବି।
ଦେଲେ ପରା
ଆଉ ଦି ତିନି ପେଜ ଆଉ ଦି ତିନି
ଆଚ୍ଛା ଆଚ୍ଛା ଅଧା ଅଛି।
ହଁ,
ଲଞ୍ଚ
ଟିକେ ଅଧା।
ପରେ ତାହେଲେ ଦେଖିବ ଆଉ କଣ
ସାର୍
କଣ କରିବା ଲଞ୍ଚ ପରେ ଆସିବ।
ଲଞ୍ଚ ପରେ ଆଜି ନା ଆଜି
କଣ ଆଜି ଆଉ କଣ
କରିପାରିବିନି।
ଆଉ ପରା ନାହିଁ ଆପଣ କରିବେ ବୋଲି
ନାଇଁ, ଆଉ ଅନ୍ୟ ଗୋଟେ ଦିନକୁ ହେଲେ କରିଦେଲି କରିଦେଲି।
ସମସ୍ତଙ୍କୁ ଛୁଟି ଦେଇ ସାରିଲୁଣି। ଆମେ ଜାଣିଛୁ ଆପଣ ଆସିବେ ଆର୍ଗୁମେଣ୍ଟ କରିବେ କୋଉଟା, ତେଣୁ ଆମେ ତାକୁ ଅଧା ଆଜି ମଧ୍ୟ ଥିଲା ଯେ ଆଜି କ୍ଲୋଜ କରିବେ, ସିଏ ତାଙ୍କ ଆର୍ଗୁମେଣ୍ଟ କ୍ଲୋଜ କରିସାରିଲେଣି। ତଳ କୋର୍ଟର ଓକିଲଙ୍କର ଯୋଉ ଆର୍ଗୁମେଣ୍ଟ ନୋଟ ଦେଲେ ତାକୁ ବି ଆପଣଙ୍କ ଆବସେନ୍ସ ଆମେ ପଢି ସାରିଲୁ।
ମୁଁ ଦେଖିଲି, ମୁଁ ଦୌଡ଼ିକିନି ଆସିଲା ବେଳକୁ
ଦୌଡ଼ିକିନି ଆସିବାର କିଛି ଜଷ୍ଟିଫିକେସନ ନାହିଁ। ଆମ ନ ଶୁଣିକିନି ଆପଣଙ୍କୁ ଆମେ ଜଜମେଣ୍ଟ କେବେ ରିଜର୍ଭ
ନାଇଁ ସେଟା ମୁଁ ଜାଣୁଛି, ସେଟା କଣ କରିବି କାହିଁକିନା ମୋର ସେ କଣ କି ମୁଁ କିନ୍ତୁ କଥା ହଉଛି ଯେହେତୁ ଆଜି ଜଷ୍ଟ ଯେମିତି ଗୋଟେ ଆମିକସ୍ କରି ଭଳିଆ କିମ୍ବା
ଇଫର୍ଟ କରୁଛନ୍ତି, ଇଟ୍ସ ଏ କମେଣ୍ଡେବଲ ଇଫର୍ଟ, ଦ୍ୟାଟ୍ ଇଜ ଦେयर ଇଜ नो डिस्प्यूट अबाउट, बट द थिंग इज दैट यू हैव टू फिनिश इट।
କିନ୍ତୁ ମୁଁ କହିବା କଥା ଯୋଉ ତିନିଟା ପଏଣ୍ଟ ସେ କହୁଛି
ସେଇଟା ତ ଆମେ ଶୁଣିବୁ। ଆମେ
ଆଚ୍ଛା।
ବର୍ତ୍ତମାନ ଅଛୁ ଯେ ବର୍ତ୍ତମାନ ଯେହେତୁ ଟାଇମ ହେଇଗଲାଣି,
ମୁଁ ସେ ଯୋଉ ସାକ୍ଷୀ ଗୁଡାକୁ କହିବି
ହଁ
ଗୋଟେ ଗୋଟେ କହିବି ସେଟା ଆପଣ ନଚ କହିବି
ଆମେ କଣ୍ଟିନ୍ୟୁ କରିବୁ।
ହଁ କହିବି ହଁ ଠିକ ଅଛି ମୁଁ ଅଛି
କଣ୍ଟିନ୍ୟୁ
ମୁଁ ଅଛି ରିଟିନ୍ ନୋଟ ହଁ ମୁଁ କହିବି।
Item 59. The report also that the applicant is dead.
which one?
Item 59.
59.
50.
At the 50. The JCR Francis Dumbu, the roadway.
And death report is there.
Item number 50, JCR 31 of 2008. The Learning Council for the State has produced the written instructions received from IIC Biro Mitrapur Police Station, which indicates that the appellant is dead. The death certificate has also been annexed to the report, which are taken on record. The criminal appeal is disposed of, or format of selected. Since no 394 provision जाए कि पर एबे BNS रो provision देखी है ना, सिर्फ में abet करी वाला करी जाए तो
16 प्लेट
16 प्लेट
बस
ये इसमें तो बात
Another vital point in this case is the absence of motive for murder, because the sub-register officer the sub-register office staff has proved the adoption deed by which the appellant was the successor, was to be the successor of the deceased persons. And when deceased persons were not burden on appellant, because the deceased Jadu was a pension holder, and their death in no way was helping, or their presence could cause any harm or inconvenience to appellant. Therefore, there is no motive behind this. Only there was ill feeling cannot be said as a motive. Rather, that ill feeling, in spite of ill feeling, they were there and they were having the deceased persons were having good relation with their neighbors. They were staying in a village where nobody having ill feeling with parents can stay inside their house. So, in general, therefore, and when all the neighbors were having good relations and they immediately arrived at the spot as inquest witness or seizure witness, but they have not been named as prosecution witness. They have not been examined as PWC except 1, 2 and 9.
ଆପଣ PW2 କୁ ସେ ଲାଇଟ୍ ଉପରେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ କରିଛନ୍ତି?
ହଁ କରିଛୁ କିନ୍ତୁ ସେ ହଷ୍ଟେଲ ହେଇଯାଇଛି ଡିକ୍ଲାର
ହଷ୍ଟେଲ ହେଲା ପରେ
ହଁ ହଁ
କଣ ହେଇଛି?
PW2 କରିଛୁ ପାଇଲଟ
କରିଛନ୍ତି?
ହଁ କରାଇଥିଲି PW2 କିଛି କହିଛି ଯୋଉଟା କି
ଯଦୁ brought Shanti as his daughter-in-law. Thereafter they all were staying together.
ସେ ନେଇକି ଆସିଥିଲା ତେଣୁ ଗୋଟେ ହୁଏ ପରିବାରରେ ଗୋଟେ ଆଉ ଗୋଟେ ବାହା ଯାଇଛନ୍ତି ପୁଅଟେ ତାକୁ ମଧ୍ୟ ସେ କ୍ଷମା କରିଦିଅନ୍ତି ଏବଂ ସେ ବି ରୁହେ। ତାପରେ ମୋର peculiar is that the brother of previous wife has also been examined here and he did not say anything against this appellant. I think 13, PW 13, I think, my lord. He has been examined here. Brother of previous wife of appellant. His second marriage. Man, PW10 only said, man, I am just reading the evidence of PW10. Though they were hostile to appellant as because appellant married again, but they did not. Man, I am just reading his statement. I know the accused in the dock. He has married to my sister Vijayalakshmi Sahoo in the month of January 1989, and they, my lord, paper book, page 81. I know the accused in the dock. He has married to my daughter Vijayalakshmi Sahoo. My sister Vijayalakshmi Sahoo in the month of January 1989, and they begot a daughter out of the wedlock 5 to 6 years after the marriage. I came to know that the accused again married to another woman, Santilata, during the lifetime of his first wife. The accused and Santilata lived with deceased Jadu and Pitei in village Bachara under RTPS. So he did not whisper anything, even the appellant, though relationship there is reason that this should have been hostile because she has left his sister, because this appellant is a sober, simple man, was living with his tuition. So why he married again, that prosecution has not brought anything, and even he did not whisper, and he had she had a child instead of all these things. So when there is evidence, some evidence that the Jadu had brought back Shanti's second wife and they were staying, so there cannot be any motive for murder from these evidences. Rather, the PW9, though he is a young man of 25 years, he was called by the deceased Jadu yesterday, previous evening, and which learned session that disbelief, but he had called him. He has asked for his father.
Mr. Das, what about the evidence of PW1?
My lord.
He's a neighbor and he has stated.
Neighbor means not immediate neighbors. My lord.
You come to page number 62.
My lord, it is not 60.
62, Basati.
My lord, my lord.
Basati,
in that house, both the deceased, the accused, and his wife were staying. The deceased were issueless, and they adopted this accused, Prasanta, who was the sister's son of Pitei. Santilata is the second wife of this accused. The accused has deserted his first wife, who is staying at Puri in her parents' house. There was no good feeling between the accused and Santilata in one side and the deceased in the other. That is the only sentence. There was no good feeling between the accused and Santilata in one side and the deceased in the other side. As accused Prasanta left his first wife.
এই কারণ ପାଇଁ
କହିଲା।
সম্পর্ক নଥିଲା ତାପରେ
କହିଲା when ଆଉ କିଛି ଅଲଗା କିଛି କାରଣ ନାହିଁ।
ପଢନ୍ତୁ ଆଉ
When the first wife was there, all of them were staying in one mess, and when the second wife was brought and first wife was left at Puri by accused Prasanta, both the deceased were having separate mess from the accused and Santilata. Injured Pitei succumbed to the injuries on the next day, that is on 15th.
ୟା ଉପରେ
ମାନେ ଆ ଉପରେ ସିଏ ଯେମିତି ଗୋଟେ କାଉ ଉଡ଼ିବାକୁ କୁଆ ପଡ଼ିବାକୁ ମାନେ ଗୋଟେ କୁଆ ଉଡ଼ିବାକୁ ତାଳ ପଡ଼ିବାକୁ ସେମିତି ସିଏ ପଳେଇଲା ବୋଲି କହିଛି, କିନ୍ତୁ ନଟ୍ ଦ୍ୟାଟ୍ ସେଇଥିପାଇଁ ତାଙ୍କର ସେ ସେପାରେଟ୍ ରହିଲେ। ସେପାରେଟ୍ ରହିବା ପାଇଁ ଅଲଗା କିଛି କାରଣ ଥାଇପାରେ ଯେ ତୁ ମୋ ପଇସା କାହିଁ ଖର୍ଚ୍ଚ କରିବୁ।
ଏଇ ସାକ୍ଷୀଟା ଯିଏକି ପଡୋଶୀ ଜଣେ ଏଇ ଜିନିଷଟା କହିଲା।
ହଁ ପଡୋଶୀ
ଆପଣ ତାକୁ କଣ ଜେରାରେ
ହଁ ସେ ଜେରାର ବା କିଛି କରିନି, ଜେରାର ଲେଖିଛି ପୋଲିସ ଏକ୍ସାମିନେସନ ଏତେ ଆଣ୍ଡ ଏତେ
ରାଜର ଆପଣ ଆଣିଛନ୍ତି that I have got visiting terms to the house of the ତେଣୁ ଏଇଟା ଉଲ୍ଟା
ଭିଜିଟିଂ ଟର୍ମ ଥିଲା,
ସେଇଥିପାଇଁ ଏସବୁ ବିଷୟରେ ସେ ଜାଣିବାର
କହିଛି
ତାର ସ୍କୋପ ଆସୁଛି ନହେଲେ ସବୁ ନେବର ଆମ ଜଣଙ୍କ ଘରର ମାନେ ତା ଘର ଭିତରେ କଣ ହଉଛି ଇଣ୍ଟରନାଲ ଆଫେୟାର୍ସ ବିଷୟରେ ଜାଣିବା ସମ୍ଭବ ନୁହେଁ, କିନ୍ତୁ ଯୋଉ ପଡୋଶୀଟା ଘରକୁ ଆସୁଛି ଜଣଙ୍କ ଘରକୁ ସବୁବେଳେ ଯିବା ଆସିବା କରୁଛି ତେଣୁ ଜଣଙ୍କ ଘରର ବିଷୟରେ ସେ ଜାଣିବା ସମ୍ଭବ। ତେଣୁ ଆପଣ ଏଇ ଯୋଉ ଲାଇନ ଟା ଆଣିଲେ ତା ଦ୍ଵାରା ଏଇଟା ଆପଣଙ୍କ ଏଗେନଷ୍ଟ ଗଲା।
ସେଇଟା ନିଶ୍ଚୟ ଟିକେ ଗଲା,
ଟିକେ ନୁହେଁ ବହୁତ
କିନ୍ତୁ କଥା ହଉଛି କଣ କି ବହୁତ ନେବର ଥିଲେ,
ଆପଣ ଯୋଉ ମୋଟିଭ ଟା କହୁଛନ୍ତି ତେଣୁ କିଛି ମାତ୍ରାରେ ଏଭିଡେନ୍ସ ରୁ ଆସିବ, ସମ୍ପର୍କଟା
ମନମାଳିନ୍ୟ ଥିଲା, କିନ୍ତୁ ମନମାଳିନ୍ୟଟା ଏମିତି ନଥିଲା ଯେ ଜଣେ ଯୋଉ ମର୍ଡର କେମିତି ଜାଣିବେ। ହଁ ସେଇଟା ସେ ପ୍ରୋସିକ୍ୟୁସନ କହିଥାନ୍ତା
ନା how can you deduce it from this?
ନାଇଁ ତାର ଏମିତି ମନମାଳିନ୍ୟ ଥାନ୍ତା ତାହେଲେ
intention can't be deduced like this.
ସେ ଯଦି ଏମିତି ମନମାଳିନ୍ୟ ସେଇଥିପାଇଁ ଥାନ୍ତା ଯଦୁ ସେ ନିଜେ ତାକୁ ଆଣିନଥାନ୍ତା, ତେଣୁ ସେ କହିଛି ଏଥିରେ ଅଛି PW9 କହିଛି
ସେ ତ ଗୋଟେ ଡିସିଜ ର ଭଉଣୀର ପୁଅ, ସେ ଏ ଆକ୍ୟୁଜ ଟା ପିତେଇ ମାନେ
ନିଜର ଭଉଣୀର ପୁଅ,
ହଁ ପିତେଇ ହଉଛି ତ ସେକେଣ୍ଡ ଡିସିଜ ନା, ତାର ଭଉଣୀର ପୁଅକୁ ପୁଅ କରି ଆଣିଲା, ତ ତାପରେ ସମ୍ପର୍କ ଖରାପ ହଲାରୁ ଅଲଗା ଅଲଗା ରୋଷେଇ କରି ଖାଉଥିଲେ, ଏତିକି ତ। ଆଚ୍ଛା ଇଏ ଲୋକ ଯିଏ ଯାଉଛି ତାଙ୍କ ଘରକୁ ଯିବା ଆସିବା କରୁଛି ସିଏ ବି ଜାଣିଥିଲା ଯେ ୟାଙ୍କର ଅଲଗା ଅଲଗା ଅଛି,
ଅଲଗା ଅଛି ମାନେ ନିଶ୍ଚୟ ପଡୁନି ଟିକେ
ଆଗରୁ ଏକାଠି ହେଇକି ଖାଉଥିଲେ, ଇଏ ଆସିଲା ପରେ ଏଇ ବୋହୂଟି ଆସିଲା ପରେ ଅଲଗା ଅଲଗା ହେଇକି ଖାଉଛନ୍ତି।
ବୋହୂ ହଉଛି ମେନ୍ ଜିନିଷ, ପୁଅ ନୁହେଁ, ଏଇଆ ମୁଁ କହିବା କଥା। ବୋହୂ ହଉଛି ଏଥିରେ ବୋହୂ ମେନ୍, ବୋହୂ ହଉଛି ଫାଷ୍ଟ ଦେଖିଛି ଡିସିଜକୁ ଅକରେନ୍ସକୁ, ପୁଅ ନୁହେଁ। ତେଣୁ ଏଇଥିରେ ମୁଁ ଅଲଗା ଜିନିଷ ଛାଡ଼ିକିନି ଯେତେ ଅଲଗା ଜିନିଷ ଏଥିରେ ମେଟେରିଆଲ ନାହିଁ ଆର ସେସନ ଟ୍ରାଏଲ ଏଭିଡେନ୍ସ, ମୁଁ ସେଇଥିପାଇଁ ଏଥିରେ କହିପାରୁନି, କିନ୍ତୁ ସେଥିରେ ତାର ଜଜମେଣ୍ଟ ବି ମୋର ଅଛି, କିନ୍ତୁ ଯେହେତୁ ଏଥିରେ ମୋର ସ୍କୋପ ନାହିଁ ମୁଁ କହୁନି। କିନ୍ତୁ ବୋହୂ ଯାହା ପାଇଁ ଏତେ କଥା ଏବଂ ଏତେ କଥା ସତ୍ତ୍ୱେ ବି ସେ ପୁଅକୁ ସେ ରଖିଛି, ନଟ୍ ଦ୍ୟାଟ୍ ସେ ହୋଷ୍ଟାଇଲ ରିଲେସନସିପ ନୁହେଁ, କାହିଁକିନା ଗୋଟିଏ ଏଣ୍ଟ୍ରାନ୍ସରେ ଯିବା ଆସିବା କରୁଛନ୍ତି ଦାଣ୍ଡକୁ, ସାଇଡ ଏଣ୍ଟ୍ରାନ୍ସ ହେଉଛି ବାଡ଼ିକୁ, ଦାଣ୍ଡକୁ ଯାଉଛି, ତାପରେ ସେ ଅଛନ୍ତି, ତେଣୁ ଗାଁରେ ସମସ୍ତଙ୍କ ସହିତ ସାଇ ଭାଇରେ ରହିଛନ୍ତି, ନଟ୍ ଦ୍ୟାଟ୍ ଟାଉନ ଯେ କେହି କାହା କଥା ଜାଣିବେନି। ତେଣୁ ଏମିତି ଇଲ୍ ଫିଲିଂ ନଥିଲା, ଇଲ୍ ଫିଲିଂଟା ଏତେ ସିରିୟସ୍ ନଥିଲା, ଯୋଉଟା କି ଗୋଟେ ମାରଧର ଆଗରୁ କିଛି ଇନସିଡେଣ୍ଟ ନାହିଁ ଯେ ମାରଧର ହେଇଛନ୍ତି କି ସୋଦାସୋଦି ହେଇଛନ୍ତି, କିଛି ନାହିଁ। ଆଗରୁ ଯଦି ସେମିତି କିଛି ଥାନ୍ତା ତାହେଲେ ରାଦର ଆଗରୁ ଆଗ ଦିନ ରାତିରେ ତାଙ୍କ ଭିତରେ ଗଣ୍ଡଗୋଳ ହେଇଛି ବୋଲି ନିଜେ ଇଏ କହୁଛି କି ନା PW9 କହୁଛି, ସେ ଖାଲି ଗୋଟେ 24-25 ବର୍ଷ ପିଲା ବୋଲି ତାକୁ ଡିସ୍କାର୍ଡ କରିଛି। ପ୍ରକୃତରେ ତା ବାପା ଖୋଜିବାକୁ ଯାଇଥିଲେ ଯଦୁ, ଯେ ଏମିତି ତାଙ୍କ ଘରେ ଟିକେ ଏଇ ଯୋଉ ଚିତା ଲାଗି ଅମାବାସ୍ୟା ଲାଗି ପିଠା ନ ହେଇଥିବାରୁ ଗଣ୍ଡଗୋଳ ହେଇଛି ବୋଲି। ତେଣୁ ସେଇଥିପାଇଁ ଜଣେ ମର୍ଡର କରିପାରିବ ନିଜ ଭଉଣୀର ପୁଅ, ନିଜ ମାଉସୀ ମର୍ଡର କରିପାରିବ? ଏଇ କଥା କରିଥାଉ ଯଦି 8 ଫୁଟରେ 10 ଫୁଟରେ 8 ଫୁଟ ହଉଛି ରୁମ୍, ତେଣୁ ରୁମ୍ଟା 10 ଫୁଟରେ 10 ଫୁଟ ବା 10 ଫୁଟରେ 8 ଫୁଟ, ଛାତ 10 ଫୁଟ, এইটা হচ্ছে এক্সপেরিমেন্ট ହେଇନି ମଧ୍ୟ। ସେତିକି ବଡ଼ ରୁମ୍ ଭିତରେ ଦି ଜଣ ଲୋକଙ୍କୁ ମାରିବେ ଏବଂ ଖାଲି ଗୋଟେ ପଡ଼ିଥିବ ଗୋଟେ ଇଏ ଖଣନ୍ତି ଯୋଉଥିରେ ମାଟି ତାଡ଼ନ୍ତି ସେଥିରେ ପଡ଼ିଥିବ ଇଏ ନୁହେଁ ଯେ ଶାବଳ ବି ନୁହେଁ ଖଣନ୍ତି ମାନେ କାଠ ବେଟ ଲାଗିଛି ସେଇଥିରେ 2 ଜଣ ଲୋକ ମରିଗଲେ କିଛି ରେଜିଷ୍ଟାନ୍ସ ହେଲାନି ଏ 2 ଜଣ ଭିତରୁ କାଚ ଭାଙ୍ଗିଲା ପିତେଇର କାଚ ଭାଙ୍ଗିଲାନି ଶାନ୍ତିଲତାର ଏବଂ ଇଏ 2 ଜଣ ଭିତରୁ କାହା ଦେହରେ ଗୋଟେ ସ୍ପଟ ରହିଲାନି କିଛି ଗୋଟେ ତାଙ୍କର ୱେରିଂ ଆପିରିଆଲ କିଛି ସିଜ୍ କରିବା ପାଇଁ ଆବଶ୍ୟକତା ବି ପଇଲାନି ଏ ଘଟଣା ଆସିଲା 2 ମାସ 4 ମାସ ପରେ PW1 କହୁଛି 2 ମାସ ନା କେତେ ପରେ କିନ୍ତୁ ସେତିକିବେଳେ ସେ ସେଇଦିନ ଏକ୍ସାମିନ ହେଇନି ତେଣୁ ଏଇ ଯୋଉ ସବସିକ୍ୱେଣ୍ଟ ଆସିଛି ଏଟା ହଉଛି କେବଳ ଯୋଉଟା ସଜେସନରେ ଦିଆହେଇଛି ଆଇଓକୁ ଯେ ଆଇଓ ବ୍ରାଇବ୍ ମାଗିଥିବାରୁ ସଜେସନ କ୍ଲିୟରଲି ଅଛି ଆଇଓ ବ୍ରାଇବ୍ ମାଗିଥିବାରୁ ସେ ନ ଦେଇଥିବାରୁ ଆଇଓ ତାକୁ କେସଟାକୁ 4.5 ମାସ ପରେ 5.5 ମାସ ପରେ କେସଟାକୁ ତାଙ୍କ ନାଁରେ ଦେଇଛି ମଧ୍ୟ ସେଟା ହଉଛି ଇରେଗୁଲାରିଟି ଦେଇଛି କାରଣ ଦେବା କିଛି ନୂଆ ମେଟେରିଆଲ ନଥାଇକି ଦେଇଛି ଖାଲି ଦେଇଛି 2ଟା ଡାକ୍ତରଙ୍କ ଓପିନିଅନ ଯୋଉ ଓପିନିଅନ ଆଗରୁ ଅଲରେଡି ଆଭେଲେବୁଲ ଥିଲା ଯାହାକୁ ମଧ୍ୟ ରାଇଟଲି ଯେ ଲର୍ନେଡ ସେସନ ଜଜ୍ ଡିସକାର୍ଡ କରିଛନ୍ତି ତେଣୁ ଏଇ ସବୁ ଜିନିଷ ଗୁଡ଼ା লিড করুনি সব চেন অফ সর্কমস্টান্সକୁ ସେ লিঙ্ক করুনি সেইଥିପାଇଁ ମୁଁ କହିବା କଥା ଯେ ପ୍ଲସ୍ ଇଟ୍ ଇଜ୍ ଦ ଡ୍ୟୁଟି ଅଫ୍ ଦ ପ୍ରୋସିକ୍ୟୁସନ୍ ଟୁ ପ୍ରୁଭ୍ ଦ୍ୟାଟ୍ ଦେର୍ ଆର୍ ନୋ ସ୍କୋପ୍ ଅଫ୍ କମିଂ ଏନିବଡି ଆଉଟ୍ ଫ୍ରମ୍ ଆଉଟସାଇଡ୍ କାରଣ ଯେତେବେଳେ ଓପନ୍ ଛାତ ରହିଛି ବାରଣ୍ଡାରେ ରହିଛି ଷ୍ଟେୟାର କେସ୍ ଓପନ୍ ତ ଛାତ ରହିଛି ବୋଲି ରହିଛି ତେଣୁ ଛାତ ଉପରୁ ବି ଛାତ ବାଟେ ଦିପଟେ ଚାରିପଟେ ବାଡ଼ି ଅଛି ସେଟା ସେ ଦେଖେଇନି ଘର ମାନେ ସ୍ପଟ୍ ମ୍ୟାପ୍ ମାନେ ଦେଖେଇବା କଥା ସ୍ପଟ୍ର ଚାରିପଟେ ବାଉଣ୍ଡରୀ ସହିତ ସେ ସ୍ପଟ୍ ମାନେ ଦେଖିଛି ସ୍ପଟ୍ ହାଉସ୍ ରଖିଛି 10 ଫୁଟରେ 8 ଫୁଟ 10 ଫୁଟ ଅଥଚ ଦେଖିଛି ସବୁ ଘର ତେଣୁ ସବୁ ଘର ଦେଖେଇଛି ତ ଚାରିପଟ ଦେଖିବା କଥା ସାମ୍ନାରେ ଅଛି 20 ଫୁଟର ରାସ୍ତା ସେ ଦେଖେଇନି 2 ପଟ ଆଗରେ ଗୋଟିଏ ପଟରେ ବାଡ଼ି ଯୋଉ ପଟେ ଲେଖା ହେଇଛି କିଚେନ୍ ପ୍ରକୃତରେ ସେ କିଚେନ୍ରେ ସେ ଠାକୁର ଘର ଯାହା ହଉ କିଚେନ୍ ଲେଖା ହେଇଛି ସେପଟୁ ତାଙ୍କ ନିଜର ବାଡ଼ି ତାପରେ ଇଏ ନିଜର ବାଡ଼ି କୋଉଟା ନା ଡାଣକୁ ଦେଖିଛି ବାଁକୁ ଦେଖିବା କଥା ଯୋଉଥିରେ କି ଛୋଟ ଡୋରଟା ଅଛି ଯୋଉଟା ଟିଣ ଡୋର ଥିଲା କିନ୍ତୁ ଆର ପଟରେ ହଉଛି ଯେ ଏଇ ଯୋଉ ପାଣ୍ଡବ ସାହୁ ଏବଂ ସେ 2 ଭାଇଙ୍କର ପାଣ୍ଡବ ସାହୁ ନାଁଟା ଆସିଛି ସେ ହଉଛି ବିଦ୍ୟାଧର ସାହୁ ସେ ହଉଛନ୍ତି ଯେ ଇନକ୍ୱେଷ୍ଟ ୱିଟନେସେସ୍ ସେମାନଙ୍କର ଘର ସେମାନଙ୍କର ବାଡ଼ି ଗୋଟେ ସାଇଡରେ ସେମାନଙ୍କର ଘର ଗୋଟେ ସାଇଡରେ ଗୋଟେ ବାଡ଼ି ତେଣୁ ଚାରିପଟ ଜିନିଷ ଯଦି ଆସିଥାନ୍ତା ଫାଙ୍କା ଜାଗା ଗୋଟେ ପଟେ ହଉଛି 8 ଫୁଟ ଆର ପଟରେ ମଧ୍ୟ ଯୋଉ ପଟେ ରହିଛି ଡୋରଟା ଛୋଟ ଡୋରଟା ଡାଣ ପଟେ ଯିବା ପାଇଁ ତାର ବାଁ ପଟରେ ମଧ୍ୟ 8 ଫୁଟ ରାସ୍ତା ଛାଡ଼ିକିନି ତାଙ୍କ ଘର ରହିଛି ତେଣୁ ସବୁଆଡ଼େ ବି ଆକ୍ସେସିବଲ ଅଛି ଫାଙ୍କା ସାମ୍ନାଟା ଯୋଉ ବାରଣ୍ଡା ଗାଁ ଗହଳିରେ କାହାରି ଗୋଟେ ବାରଣ୍ଡାରେ ଗୋଟେ ଗ୍ରିଲ୍ ଗେଟ୍ ଦିଆ ହେଇନଥାଏ ଏଠି ବି ନାହିଁ ଗ୍ରିଲ୍ କଥା ଲେଖା ହେଇନି ଅଥଚ ସ୍ପଟ୍ ମ୍ୟାଟରେ ଲେଖା ହେଇଛି ଆଜି ଗୋଟେ ଚାରିପଟରେ ବାଉଣ୍ଡ ହେଇଛି ତ ସେଟା ଓପନ୍ ଥିଲା ତେଣୁ ସେଦିନ ରୁମ୍ ଭିତରେ ସେ ଗଲା PW9 ଗଲା ପରେ ବନ୍ଦ ହେଇଛି କି ନାହିଁ ଯଦି କିଏ ଆସିଛି ବା କିଏ ଉପରେ ଚଢ଼ିକିନି ଆସିଛି ଏ ସବୁ ସ୍କୋପକୁ ପ୍ରୋସିକ୍ୟୁସନ୍ ଆଉଟ୍ କରିବାର ଥିଲା ପ୍ରୋସିକ୍ୟୁସନ୍ ଆଉଟ୍ କରିନାହିଁ ସେଥିପାଇଁ ଦେର ଏ 2 ଜଣ ମାରିପାରିଥାନ୍ତି ସେ ନିଜେ ମରିପାରିଥାନ୍ତି ବା କେହି ଆଉଟସାଇଡର ଏଇଟା ବି କରିଥାଇପାରେ ସେଟା ପ୍ରୋସିକ୍ୟୁସନ୍ ପ୍ରୁଭ୍ କରିବାର ଥିଲା ତେଣୁ କେବଳ ଏଇ ହେଉଛନ୍ତି ଅଥର ଅଫ୍ କ୍ରାଇମ୍ ଏମିତି ପ୍ରୋସିକ୍ୟୁସନ୍ କିଛି କହିନି କୌଣସି ସାକ୍ଷୀ କିଛି କହିନି ଖାଲି କହିଛି ଇଲ୍ ଫିଲିଂ ସେ ଇଲ୍ ଫିଲିଂରେ ଏତେ ବାଟ ପର୍ଯ୍ୟନ୍ତ ଷ୍ଟ୍ରେସ୍ ହେବାଟା ଏଟା ଅନରିଜନେବଲ୍ ତାପରେ ଇଲ୍ ଫିଲିଂ ଯୋଉ ଥିଲା ସେଇଦିନ କେତେବେଳେ ଇଲ୍ ଫିଲିଂ ଥିଲା ଲାଷ୍ଟ ସେମିତି କିଛି ଗୋଟେ ଆସିନି ସେ କହିନି କେବେ ଇଲ୍ ଫିଲିଂ ଥିଲା କୋଉ ଘଟଣା ପାଇଁ ଇଲ୍ ଫିଲିଂ ଥିଲା ଇଟ୍ ହାଜ୍ ଟୁ ବି ଏକ୍ସପ୍ଲେନ୍ ବାଇ ଦ ପ୍ରୋସିକ୍ୟୁସନ୍ ତେଣୁ
ସାକ୍ଷ୍ୟ କହିଲେ ପରା
ଖାଲି ଇଲ୍ ଫିଲିଂ ମାଇନର
ନାଇଁ ସେ କହିଲେ ପରା ସେକେଣ୍ଡ
ସେଟା 6 ବର୍ଷ ସେଟା ହେଲାଣି 6 ବର୍ଷ ହେଲାଣି ଛୋଟ ଛୁଆ ବଡ଼ ହେଇଗଲାଣି କିଏ କହୁଛି ନା ଝିଅର ଭାଇ କହୁଛି ଝିଅର ପ୍ରିଭିୟସ୍ ସ୍ତ୍ରୀର ଭାଇ କହୁଛି ତେଣୁ ସେ ଇଲ୍ ଫିଲିଂଟା ଏତେ ବାଟ ଚାଲିଲା ଯେ ଏତେ ବର୍ଷ ପରେ ମଝିରେ କିଛି ଗୋଟେ ଛୋଟ ମୋଟ ଇନସିଡେଣ୍ଟ ହେଇଥିଲା ପାଟି ଶୁଣ୍ଡ ହେଇଥାନ୍ତା ସେଇଟା ହେଇଥିଲେ ଆଉ ତାଙ୍କର ଲାଗି ରହୁଥିଲା ବା କିଛି ଗୋଟେ ହେଲା ଆଗର ତେଣୁ ବରଂ ବେଟର ଏଟା ହଉଛି ରିଜନେବଲ ଲାଗୁଛି PW9 ଯୋଉ ପିଠା ପାଇଁ ନ ହେଇଥିବାରୁ ସାଧାରଣ ଗାଁ ଗହଳିରେ ବୁଢ଼ାବୁଢ଼ୀ ଛୋଟିଆ କଥାରୁ ଗୋଟେ କ'ଣ ଗୋଟେ କେମିତି ହେଇଯାଇଛି କିମ୍ବା ସେଇଟା ବି ମଧ୍ୟ କମ୍ ଲାଗୁଛି କେହି ଗୋଟେ ଥାର୍ଡ ପର୍ସନ ଯିଏକି ଏଇ ଯୋଉ ଆପିଲେଣ୍ଟକୁ ଯିଏ ସେ କହୁଛି ତା ଭାଇକୁ ଏଟା ଫ୍ୟାକ୍ଟରେ ଆସିଛି ତା ଭାଇ ଗୋଟେ ମର୍ଡର ହେଇଥିଲା 78 ମସିହାରେ ତେଣୁ ଏମିତି ସେ ପ୍ରପର୍ଟି ପାଇଁ ସାହି ଭାଇରେ ଅଛନ୍ତି ଇଏ ମରିଗଲେ ଯେ ଏଇ ଯୋଉ ଆପିଲେଣ୍ଟ ଆକୁ ଚାଲିଯିବ 2 ଜଣ ଚାଲିଯିବେ ଆଙ୍କ ପ୍ରପର୍ଟିଟା ଅନ୍ୟ କିଏ ଭୋଗ ଦଖଲ କରିବ ତେଣୁ ସେମାନେ ବି କେହି କାହାର ଇଣ୍ଟରେଷ୍ଟେଡ୍ ଲୋକ ବି ଥାଇପାରନ୍ତି ସେଇଟା ପ୍ରୋସିକ୍ୟୁସନ୍ କିଛି ମାନେ ସେ କେସ୍ଟାକୁ ଯଦିଓ ଆସିଛି ନିଜେ ଆଇଓକୁ ପଚରା ହେଇଛି ଆଇଓ କହିଛି ସେ କେସ୍କୁ ସଜେସନ୍ ଦିଆହେଇଛି କିନ୍ତୁ ସେଇଟା ସେ ଆଣିବାର ଥିଲା ପ୍ରୋସିକ୍ୟୁସନ୍ ତେଣୁ ସେ ଆଣିନାହାନ୍ତି ସେଥିପାଇଁ ସମସ୍ତ ସବୁ ଜିନିଷ କେବଳ ଆଡକୁ ଇଣ୍ଡିକେଟ୍ କରୁନି ସବୁଥିରେ ରହୁଛି ଫାଙ୍କ ରହୁଛି ୱେପନ୍ ଅଫ୍ ଅଫେନ୍ସରେ ରହୁଛି କିଏ ଅଥର ଅଫ୍ କ୍ରାଇମ୍ ରହୁଛି ଇଏ କିଏ ୱିଟନେସ୍ ହେଲେ ଯଦିଓ 2 ପଟର ଘର ଗଲା ସେମାନଙ୍କୁ ଇନକ୍ୱେଷ୍ଟ କରିଥିଲେ ଅଛନ୍ତି ତାଙ୍କୁ ସାକ୍ଷୀ ନ କରିକିନି ଜଣେ ହେଇପାରେ ସେ ଗାଁ ଲୋକ ଯେ ଜଣେ ଲେବର ଲୋକଙ୍କୁ ଆଣିକି ସାକ୍ଷୀ କରାଯାଇଛି PW1 ଯୋଉଟାକି ଆଗ କେସ୍ରେ ତାକୁ କରାଯାଇଥିଲା 9 ନମ୍ବର ନା 10 ନମ୍ବର ୱିଟନେସ୍ ଆକୁ ଏଥିରେ କରାଯାଇଛି 1 ଯୋଉଥିରେ କି ହେଇପାରେ ସନ୍ତା ସେ ଗାଁର 9 ନମ୍ବର PW ଯିଏକି ଆସିଛି ଆଗ ଦିନ ରାତିରେ ଡକା ହେଇକିନି ସେ ଛୁଆଟେ ହେଲେ ବି ସେ ହେଇଥାନ୍ତା ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍। ତାପରେ ଇଏ କେକୁ ଛାଡ଼ିଦେଲେ 9କୁ ଛାଡ଼ିଦେଲେ ଆଉ କେହି ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ୱିଟନେସ୍ ନାହାନ୍ତି ଏଣ୍ଟାର ସର୍କମଷ୍ଟାନ୍ସ ଉପରେ ସବୁ ସର୍କମଷ୍ଟାନ୍ସ କେବେ ହେଲେ ହଁ। ତାପରେ ଯେତିକି ଯଦି ୟା ଉପରେ ଆସିଲା ସନ୍ଦେହ ସେ କହିଛି ସନ୍ଦେହଟା ସେ କହିଛି 2.5 ମାସ ପରେ ଯଦି ସନ୍ଦେହ ଆସିଲା ସେ ସାଙ୍ଗେ ସାଙ୍ଗେ କହିଥିଲେ ସେଇଠି ପୋଲିସ ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆରେଷ୍ଟ କରିଥାନ୍ତା। ସେ ଯାଇଛି ପୋଲିସ ପାଖରେ ୱେଟ୍ କରିଛି ଇନଭେଷ୍ଟିଗେସନରେ ସାହାଯ୍ୟ କରିଛି ତାପରେ 2.5 ମାସ ପରେ କେସ୍ ଇନଭେଷ୍ଟିଗେସନ ଟେକଅପ୍ କରିଛି IIC ଏବଂ 5 ମାସ 5.5 ମାସ ପରେ ଚାର୍ଜସିଟ୍ ଫାଇଲ୍ କରିଛି। ସେ 2.5 ମାସ ମଧ୍ୟ କ'ଣ କାହିଁକି ଯଦି 5 ମାସରୁ ଆମର ଅଗଷ୍ଟ 14 ତାରିଖରୁ ଚାଲିଗଲା ଫେବୃଆରୀ ପର୍ଯ୍ୟନ୍ତ ଫେବୃଆରୀରେ ସେ 5/2/1997 ସେ ଫାଇଲ୍ କରିଛି ସେକେଣ୍ଡ ଚାର୍ଜସିଟ୍ ତେଣୁ 5.5 ମାସ ଯୋଉ ଗଲା ଯଦି ନଭେମ୍ବରରେ ଜଣା ପଡ଼ିଲା ସେ ଟେକଅପ୍ କଲା ତାହେଲେ ନଭେମ୍ବରରୁ ସେଇଟା ମଧ୍ୟ କିଛି ଏକ୍ସପ୍ଲେନ୍ ହେଲାନି ସେଇଟା ମଧ୍ୟ ଅଣାସ ତେଣୁ ଏଇଥିରେ ଡିଲେ ଇନ୍ FIR ସେକେଣ୍ଡ FIR ତାପରେ ଇଏ ନଟ୍ ପ୍ରେଜେଣ୍ଟିଂ ପ୍ରପର ମାନେ 3 ସାଇଡ୍ ନେବର୍ସ 3 ସାଇଡ୍ ନେବର ଆଗରେ ଅଛନ୍ତି ଘର 20 ଫୁଟ ସାଇଡ୍ ତାକୁ କରାଇନି ସାକ୍ଷୀ ବାଁ ପଟ ନେବରୁ କରାଇନି ସାକ୍ଷୀ ବିଦ୍ୟାଧର ଏବଂ ପାଣ୍ଡବ ଡାଣ ପଟକୁ କରାଇନି ସାକ୍ଷୀ ଏବଂ ଖାଲି ଆଣିଛି ଯିଏକି 6-7 ଘର ଦୂରରେ 6-7ଟା ଘର ପରେ ହେଉଛି PW9 ଆଉ ଇଏ PW1 କେତେ ଘର ଦୂରରେ ଯଦିଓ ଗାଁ ଲେଖା ହେଇଛି এটা କିଛି ଦେଖାଇନି ଯଦିଓ ସେ ଜଟଣୀରେ ସବୁଦିନ ଡେଲି ଲେବର କାମ କରେ ସେ ହୁଏତ ଜଟଣୀରେ ରହେ ଭିଜିଟିଂ ରାଇଟ୍ ମାନେ ମଝିରେ ମଝିରେ ଆସେ ନଟ୍ ଦ୍ୟାଟ୍ ନେବର ଯେମିତି ସମସ୍ତେ ଯାଇକି ଦୁଆର ମୁହଁରେ ବସନ୍ତି ସେ ସେମିତିଆ ହେଇନଥିବ ସେମିତିଆ ହେଇଥିଲେ ସେ ଭିଜିଟିଂ ରାଇଟ୍ କରିନେଥିଲା କହିଥାନ୍ତା ମୁଁ ଡେଲି ମୁଁ ନେବର ମୋର ସବୁବେଳେ ମୁଁ ତାଙ୍କ ଘରକୁ ଯିବା ଆସିବା ଏକଥା ସେ କହିନି କହୁଛି ଭିଜିଟିଂ ମାନେ ଇଏ ଅଛି ତେଣୁ ଏ ସବୁଗୁଡ଼ା ସେଇଥିପାଇଁ ଆମର କେବେ ହେଲେ ତାକୁ ନଉନି ଲିଡ୍ କରୁନି ଟୁ କମ୍ପ୍ଲିଟ୍ ଦ ଚେନ୍ ଅଫ୍ to bring up the charge to indicate that this activity ତାପରେ ପ୍ରଥମ ଏଭିଡେନ୍ସ ଏଟା ମଧ୍ୟ ସେ କହିଲା ଆବସ୍କଣ୍ଡିଂ କଲା ଯେତେବେଳେ ଜଣେ ଲୋକ ପ୍ରଥମେ ସାହାଯ୍ୟ କରୁଛି 2.5 ମାସ କାଳ ସାହାଯ୍ୟ କଲା ପରେ ଜାଣୁଛି ତା ସ୍ତ୍ରୀଟା ଆରେଷ୍ଟ ହେଇଗଲା ସେ ପଦାରେ ଅଛି ଏଟା ରିଜନେବଲ ମଧ୍ୟ ସେ ତା ସ୍ତ୍ରୀର ବେଲ୍ କରିବ ସେ ନିଜେ ଆକ୍ଟିଭେଟ୍ ସେଥିରେ ଆସିଛି ଯେ କେସ୍ ଡାଇରେକ୍ଟର ମଗା ହେଇଛି ଦେଇନି କିନ୍ତୁ ଯଦିଓ ତା ରେକର୍ଡ କିଛି ନାହିଁ କିନ୍ତୁ ଏଟା ମଧ୍ୟ ରିଜନେବଲ 2-3 ମାସ କଥା ତ ହବ 2-3 ମାସ ଆମେ ଏମିତିରେ ବି
ଆଗେ ଦେଖିଲା ବୋଲି କିଏ କହିଛି
ଆଗେ କହିଛି ଇଏ ଆଗେ କହିଛି FIR କହିଛି FIR ଅଛି
ନାଇଁ ଏଭିଡେନ୍ସ ଆସିନି କାହାରି
ଏଭିଡେନ୍ସରେ କିଏ ଆସିନି FIR ଲେଖା ହେଇଛି FIR ସେ ଲେଖିଛି ମୁଁ ମୋ ସ୍ତ୍ରୀ କହିଲା ଶୁଣିକି ନେଇଗଲି ସେଇଟା ମଧ୍ୟ ଡିସ୍ପ୍ୟୁଟେଡ୍ ହେଇନି PW ଆମର ଯୋଉ ଆକ୍ଟିଭିଟିର ଯୋଉ ଓରିଜିନାଲ FIR ଯୋଉଟା ଏଥିରେ ପାର୍ଟ ଅଫ୍ ରେକର୍ଡ ଅଛି ସେଟାକୁ ରିଜେକ୍ଟେଡ୍ ହେଇନି ସେଟା ସିଏ ଆକୁ ସନ୍ଦେହ କରିକିନି ଆଜ ଅଥରିଟି ଟାଇମ୍ ସେକେଣ୍ଡ FIR ହେଇଛି ନଟ୍ ଦ୍ୟାଟ୍ ସେ FIRଟା ପୁରା ଇଏ ହେଇନି ସେଥିରେ ଗୋଟେ କୋଉଠି ଗୋଟେ ଅଛି ବି ମଧ୍ୟ ସେ ଫାଇନାଲ ରିପୋର୍ଟ ପରେ ଏଟା ହେଇଛି 5/2/2097 ତେଣୁ ଗୋଟେ ଥରେ ଗୋଟେ କେସ୍ କ୍ଲୋଜ ହେଲା ପରେ ଆଉ ଥରେ ଓପନ ହବ ଓପନ ଯଦି ହବ ପୁରା ନୂଆ ଏଭିଡେନ୍ସ ସବୁ ନିଆଯାଇଥାନ୍ତା ପୁରୁଣା ଏଭିଡେନ୍ସରୁ କିଛି ନୂଆ ଏଭିଡେନ୍ସରୁ କିଛି ପୁରୁଣା ଏଭିଡେନ୍ସରୁ କେତେ କିଛି ଲୋକଙ୍କୁ ଏକ୍ସାମିନ୍ ମଧ୍ୟ କରାଯାଇଛି ଯାହାକୁ ଏକ୍ସାମିନ୍ କରାଯାଇଛି ତାଙ୍କ ଭିତରୁ ମେନ୍ ଲୋକଙ୍କୁ କାହିଁକି ପ୍ରୋସିକ୍ୟୁସନ କଲାନି ସାକ୍ଷୀ ସେଟା କିଛି ଏକ୍ସପ୍ଲେନେସନ ହେଲାନି ଗୋଟେ ଏତେ ବଡ଼ ଗାଁ ଚାରିପଟେ ବହୁତ ରଖିଛନ୍ତି ପାଖ ଯୋଉମାନେ ସେ ହଁ ଠିକ ଅଛି ଥିଲେ କି ନଥିଲେ ପ୍ରମାଣ ନଥାନ୍ତା ଯେତେବେଳେ ହେଇଛନ୍ତି ସେ ଇନକ୍ୱେଷ୍ଟ ଏଭିଡେନ୍ସ ହେଇଛନ୍ତି ତାମାନେ ସେଠି ଅଛନ୍ତି ତାପରେ ଜଣେ କହୁଛି 7:30 PW1 ନିଜେ ଆୟୋଗ କହୁଛି 10:30 ପହଞ୍ଚିଲା ତେଣୁ ଆମେ ଆୟୋଗ ବିଲିଭ୍ କରିବା ନା ବିଲିଭ୍ କରିବା ସେଇ ଯୋଉ ସାକ୍ଷୀ ଯିଏ 2.5 ମାସ ପରେ ଏକ୍ସାମିନ୍ ହେଲା ଯିଏ କହୁଛି ସେଇଦିନ ସାଙ୍ଗେ ସାଙ୍ଗେ ପହଞ୍ଚି 10:30 ତେଣୁ ଯଦି ସେ 10:30କୁ 7:30 କହୁଛି ତାମାନେ ସେ ଆକ୍ଚୁଆଲ ପହଞ୍ଚିନି ସେ ତ ହେଇପାରେ ଯଦି ଆକ୍ଚୁଆଲି ପହଞ୍ଚିଲା ସେ ତ ହେଇଥାନ୍ତା ଇନକ୍ୱେଷ୍ଟ ୱିଟନେସ୍ ସବୁ ହେଇଥାନ୍ତା ସେ କିନ୍ତୁ ତାକୁ ପ୍ଲାଣ୍ଟ କରାହେଇଛି କେବଳ ଯେହେତୁ ଥରେ IAS ଡିସାଇଡ୍ କରିନେଲା ମୁଁ ଆକୁ କୌଣସି କାରଣବଶତଃ ଯୋଉଟାକି ସଜେସନରେ ଆସିଛି ବ୍ରାଇବ୍ ଦେଇନି କ'ଣ ମୁଁ ଆକୁ ହାରାସ କରିବି ସେଇଥିପାଇଁ ସେ ସେକେଣ୍ଡ FIR ଦେଇଛି ଏବଂ ସେଇ ଅନୁସାରେ ସେ ଲିଡ୍ କରିଛି କିନ୍ତୁ ଲିଡ୍ କରିକି ବି ସକ୍ସେସଫୁଲ ହେଇନି
ଆଉ କ'ଣ ସେତିକି ତ
ସେତିକି ଆଉ ମୁଁ କ'ଣ କହିବି ସାର୍ ମାଇଲର୍ଡ ତାକୁ ଜଷ୍ଟିସ୍ ଦେବା କ'ଣ ମୋର ଦାୟିତ୍ୱ ନୁହେଁ ହଜୁରଙ୍କର ଦାୟିତ୍ୱ ମୁଁ କିନ୍ତୁ ଦେଖିଲି ଏତିକି ଯେ ମୁଁ ସେଟାକୁ କୋଉଠି ଛାଡ଼ି ଯାଇଥିଲି ମୁଁ କାଲି ରାତିରେ ତା କଥା ଅନୁସାରେ ତିଆରି କରିଥିଲି ତାର ଦିଗ ଭୁଲ ତାର ସବୁ କିଛି ସେ ଚାରିପଟା ଦିଆ ସ୍ପଟ୍ ମ୍ୟାପ୍ଟା ପ୍ରକୃତରେ ସ୍ପଟ୍ ମ୍ୟାପ୍ଟା ନୁହେଁ ଏଟା ପୁରା ଏରିନିୟସ୍ ଯଦିଓ ସେଥିରେ କିଛି ଆସିନି କିନ୍ତୁ କୋଉ କେସରେ ବି ମଧ୍ୟ ଆମେ କହୁଛୁ ରିଟ୍ରାଏଲ୍ ପାଇଁ ଯଦିଓ 21 ବର୍ଷ ଯଦିଓ 28 ବର୍ଷ ପରେ ରିଟ୍ରାଏଲ୍ ହେଇପାରିବ ନାହିଁ କିନ୍ତୁ ये जिनस प्रमाणित हजूर केत कथा कहते प्रकृत में ये स्पट मैप ठीक अच्छे कि ना गोटे रिपोर्ट भी मगाई पार हजूर जापर जे यहाँ हूँ केमी केसटा गोटे पूरा एरियस गोटे खाली गोटे हुईजिकाली गोटे आर्बिट्रारी गोटे तेणु ये केस सर्कमस्टांशियल एविडेंस आप जहाँ गत सप्ताह हजूर डिसीजन से जो चेन ऑफ सर्कमस्टांस आसी किसी आदौ सेमता किसी ना तेणु ये केसटा हूँ प्रकृत में यहाँ हूँ आमर जो केस आमर वरुण बेहरा वर्सेस स्टेट ऑफ ओडिशा जेल क्रिमिनल अपील नंबर 20 of 2013 से डिस्कस कर जो शरद केसटा को क्लीयरली अन्य केसेस से समस्त केस आनी कि जेहतु हजूर अलरेडी डिस्कसन कर चाहूनी बेसी खाली देखा मुझे गोटे कहीदे जेहतु बजुन घटनाटा मुझे खाली ये कहूँ चेन ऑफ सर्कमस्टांस हैज नॉट बीन माने कंप्लीटली प्रूफ अदर जो पॉसिबिलिटी प्रोबेबिलिटीज हैव नॉट बीन प्रूव बाय प्रोसिक्यूशन दैट अन्य किसी संभावना नथिला अन्य कई लोक नथिला कि अन्य किसी नहीं कहीं जदि सी तापर किसी सन्देह था तार किसी तार लुगा पटा से दी जनकर स्वामी स्त्री तार आ काच गोटे निहाई पार से काच तार कि ना किसी आड़ किसी काच सीजे जोटा प्रूव होती पितेईर गोटे काच छड़ा आ कि सीझेनी अच्छा भंगा काच छड़ा तेणु दुई जन लोक आसिक मरले गोटे घरे किसी है नहीं टसल है नहीं फाइट है नहीं सिंपली मरिक पड़ी तेणु आउ ये दी जन पड़ी थाना को दौड़ी जाती थाना को कहीं गले डाक्तखाना कहीं न गले गोटे गाँव लोक पुलिस पहुंचीगला बेलू घटना ताकर मर्डर से हो तार माइंडटा केमतिया तेणु पुलिस बाबू कहते अपेक्षा कर मुझे सी पड़ेब साहस अच्छी तार इतना तो मुझे भावनी कारण आमर ये कही नोट मुझे लिखा चाहूँगी आमर जो पुलिस आम सीबीआई अफिसर आम विजिलेंस अफिसर पैसा नहीं ब्राइब नहीं जेल को जाती डिमांड करी कौन ना तुम ना ओमिट कर तुम ना पुरेनु तेणु सी साटिस्फाई करें बोली पुरे जोटा मोर रिजनेबल आउ ये दि अपीलेंट इज कंप्लीटली इनोसेंट एवं जदि दी जन भर चार्जसीट है जड़े देखा कमन इंटेंशन जदि है ताले जदि जड़े आकुटाल है ताने आपाई केमी भला केमी कंट्रीब्यूशन रही है भाइटाल कथा एवं जो केता साइटेशन देती आते हजूर परमिट करेंगे मुझे देवी गोटे आ गए बेटर ये कर दुई तीन दिन भर भी पारि सब साइटेशन गुड़ा मुझे सब रखी के बाहरी आते बाहर पारानी के मिल पारानी सब नानावती केस आरंभ कर समस्त केस को मुझे करी हजूर को पॉइंट क्लारिफाई चाहिए मुझे
All right, Mr. Mohan's answer. The first point which he has raised that this PW1, though has stated that there was no good feeling between the deceased and his wife on the one side and the appellant and his
wife
on the other side, particularly after marriage. But what he submits that this cannot be said that it is that ill feeling was of such a nature that one would commit the murder of the two persons. So that is his first point. And second point is that some of the witnesses have stated that there was a good relationship between the two deceased and these two accused. So this was his first point. So what is your answer to that?
My answer is the first motive, my lord. The motive built the house inside the mind. What is going on inside mind of the accused, nobody can say. But in this case, the evidence of PW1 clearly says that there was no good feeling between the accused and the deceased person. I also rely the evidence of PW2, who after getting the information about death of a person reached at the spot and asked the deceased, asked the accused as to how Jadu died. He replied that I did not know.
No, that's a different, that is the conduct. We are asking about this motive part and good feeling part. So 2 to 3 witnesses have stated that relationship was good. Only one has stated that there was some ill feeling because they were in separate ways.
Yes.
According to, so the prosecution But he said that the prosecution has not established a clear motive that it would be, and what further is wants to say that perhaps that it's a circumstantial evidence, and in the such type of cases, motive assumes also some importance. So if you are not, they were residing in that very house after this, and this Shantilata, that second wife, was brought into the house since 6 years back. It's not that instantly. So
No.
for 6 years they were there, and what further he would have got? Suppose you may say that after killing those two persons, they might get the property. That may be one of the, otherwise, what further benefit would get?
In this case, my lord, even after the occurrence, the accused posed a story that both the deceased, they quarreled, assaulted each other, they died.
সেটা হচ্ছে previous রাত্রিরে ଗୋଟେ ঘটଣା ହେଇଛି।
ସେ ଯୋଉ ଏଫଆଇଆର ଟା ଦେଲା ସେଠି ସେ ଗୋଟେ ଷ୍ଟୋରି ଦେଲେ ଯେ ସେମାନେ ନିଜେ ନିଜେ ବାଡାବାଡି ହେଇକି
ମରି ନାହାନ୍ତି,
ସେମାନେ ବାଡାବାଡି
ହେଇଥିଲା ବୋଲି ଗତ ରାତିରେ ତାଙ୍କ ଭିତରେ, ତେଣୁ ମୁଁ ଏହା ହିଁ ତାର ରିପୋର୍ଟ ହଉଛି ଏଫଆଇଆର ରେ।
ବଟ୍ ଇନ୍ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ
ଯୋଉଥିରେ କି PW9 ଆସିକିରି ତାଙ୍କୁ ଡିସ୍ଟ୍ରଏଡ୍ କରିଥିଲେ।
whereas in accused statement he put a different story. ଯେ ମୋ ଭାଇ କି ମାରି ଦେଇଥିଲେ।
ଏଇଟା ଦେଖନ୍ତୁ
13/8/96 ରାତି 8:30 ସମୟରେ ଚିତା ଓ ଅମାବାସ୍ୟା ପର୍ବରେ ପିଠାପଣା ନ ହେବାରୁ ସେମାନେ ସେଇ ଘଟଣାକୁ କେନ୍ଦ୍ର କରି ରାତି 8:30 ଝଗଡା କରୁଥିଲେ।
ଝଗଡା କରିଥିଲେ ମାନେ ଦି ଜଣ ଡିସିଜ୍ ଝଗଡା କରିଥିଲେ।
ସେମାନେ କରିଥିଲେ। ପାଟି ଶୁଣି ନୀଲୁ କିଶୋର ମହାନ୍ତି ଘଟଣାସ୍ଥଳକୁ ଆସି ସେ ମଧ୍ୟ ମୋ ବାପା ମାଙ୍କୁ ଝଗଡା ବନ୍ଦ କରିବାକୁ ବୁଝାଇଥିଲେ। ଝଗଡା ସମୟରେ PW9 ଝଗଡା ସମୟରେ ମୋ ବାପା ଯଦୁ ସାହୁ ମୋର ମା ପିତେଇ ସାହୁକୁ ଗାଳି ଦେଇ କହୁଥାନ୍ତି ଆଜି ରାତିରେ ତତେ ଜୀବନରେ
ସିଏ ବି କହୁଥାଏ, ମା ବି କହୁଥାଏ।
ଆଚ୍ଛା,
ସେହିପରି
what about this PW9?
PW9 was turned hostile.
But what was actually his previous statement before for this? He has been 161 ଟା କଣ ଥିଲା?
PW9 କଣ ତା ନାମ?
କିଶୋର ମହାନ୍ତି।
ସେ ବୋଧେ କହିଥିଲା ଯେ ଆକ୍ୟୁଜ୍ଡ ଆଉ ଡିସିଜ୍ଡ ଭିତରେ ଝଗଡା ହଉଥିଲା। ଇଟ୍ ଇଜ ନଟ୍ ଦ୍ୟାଟ୍ ଦିଟା ଡିସିଜ୍ ଭିତରେ ଝଗଡା ହଉଥିଲା, କାରଣ ସେଇ ଲାଇଟ୍ରେ ସରକାରୀ ଓକିଲ ପଚାରିଛନ୍ତି, ତାଙ୍କୁ କନଫ୍ରଣ୍ଟ କରିଛନ୍ତି ଏବଂ ବାହାରିଲା କି ସେ ଷ୍ଟେଟମେଣ୍ଟ ଯୋଉ 9 ନମ୍ବର ସାକ୍ଷୀର କିଶୋର କୁମାର ମହାନ୍ତର ଷ୍ଟେଟମେଣ୍ଟ ଆବାର ପାଇଲେ କେତେ ନମ୍ବର ପେ
କେତେ ଉପରେ 18
ହଁ କିଶୋର କେତେ ପେଜ? 101 ଗତ 13/8/96 ଚିତ୍ତ ଅମାବାସ୍ୟା ଦିନ ଯଦୁ ସାହୁ ଓ ପ୍ରଶାନ୍ତ ସାହୁ ମଧ୍ୟରେ ଝଗଡା ହେଲା। ତେଣୁ ରାତି 8:30ରେ ଯଦୁ ସାହୁ ମତେ ଡାକିଲା। ମୁଁ ଯଦୁ ସାହୁ ଘରକୁ ଯାଇଥିଲି। ସେମାନଙ୍କୁ ଝଗଡା ନ ହେବାକୁ କହି ଫେରି ଆସିଲି। ତା ପରଦିନ ଦେଖିଲି ଯେ ଯଦୁ ସାହୁ ମରି ପଡିଛି, ଶୁଣିବାକୁ ପାଇଲି ଏବଂ ତାପରେ ଘରକୁ ଯାଇଥିଲି, ଦେଖିଲି ଯଦୁ ସାହୁ ଶୋଇବାର ଘରେ ମରି ପଡିଛି। ମୁଣ୍ଡ ଛାତିରେ ମାଡ଼ ଚିହ୍ନ ହେଇଛି, ପାଟି ଓ କାନରୁ ରକ୍ତ ବାହାରୁଛି। ପିତେଇ ସାହୁ ଜ୍ଞାନ ଶୂନ୍ୟ ହୋଇ ତଳେ ପଡି ଛଟପଟ ହେଉଥିଲା। ତାର ଛାତି ଓ ପାଟିରେ ମାଡ଼ ଚିହ୍ନ ଥିଲା, ପାଟିରୁ ରକ୍ତ ବାହାରୁଥିଲା। ଘଟଣା ଦିନ ରାତିରେ ଘର
ଘର ଛିକିରେ ଯଦୁ ସାହୁ
ପିତେଇ ସାହୁ ଘର ଭିତରେ ଯଦୁ ସାହୁ, ପିତେଇ ସାହୁ, ପ୍ରଶାନ୍ତ ସାହୁ ଓ ଶାନ୍ତିଲତା ରହୁଥିଲେ। ପ୍ରଶାନ୍ତ ଓ ଶାନ୍ତିଲତା ସାହୁ ଯଦୁ ସାହୁ ମାରିଥିବା ସନ୍ଦେହ କରାଯାଉଛି। So that is the statement.
Yes, another witness, Pitbull 2, Surendra Nath Subudhi. He also stated that they were good term, but he also turned hostile.
Okay, now what the second point which has been raised by Mr. Das is that the conduct of the appellant in reporting the police and also accompanying, I think, deceased and the one of the injured mother to the hospital, and also cooperating with the police after the not fleeing away.
No, immediately
He fled away when the FIR was lost,
registered against him.
registered against him. But prior to that, he was cooperating with the police. There is nothing that so that shows his that bona fide conduct. What you say that he should have first taken the mother to the hospital, and he should not have gone to the police station to report. So
Not only that, my lord, it is the reasonable behavior.
how one can behave, you cannot be, there cannot be any.
Yes, my lord.
Straight
But second, my lord, at Jatani hospital, doctor referred the injured Pitei to SCB. But instead of taking to SCB, the accused taken her to Jatani PS. That is also they have
PS.
माने रेलवे हॉस्पिटल रो ताको रेफर कले एससीबी की से एससीबी की न नहीं की जटनी हॉस्पिटल को.
Somebody may think that Kotak ku jane it is not that easy. So आपन ପାଇଁ easy लाଗୁଥିବ, you are staying in Kotak. जटनी रू घरे बापा मरी किनी पड़ीची, स्त्री रो अवस्था या घरे आउ केही नाहांती, कटक चली आसिले से घरे अवस्था कौन थी, ये सब बंधु ता मुंडरे पशिवार स्कोप रही। तेणु से कटक को आनिले जे न आनिला बेली माने होल जिंस होसी जे इट कैन बी अनदर थिंग, इट कैन बी एक्सप्लेन्ड. It is not that अपन कौन से ये टाउची this conduct cannot be explainable under Indian or hypothesis. तेणु ये जोटा अपन कहउछंदी एटा को ए टाइप रो हेई पारे, तो जोठी पॉसिबिलिटी अच्छी, पॉसिबिलिटी कैनॉट बी रूल्ड आउट. तेणु सेठी अपन कहि परिबेनी जे सेटा that can be a strong circumstances which is to be utilized because the accused could not explain. It can be explained. Have you put any question? The court has put any question that tadi tamuku doctor कहिथिला हमको जगह को नबा को एससीबी मेडिकल कॉलेज को तमे ताकू नहीं कि एठी कि नाही इस क्वेश्चन पचारथिले से तो एक्सप्लेनेशन देई था. आपण जदी प्रश्न न पचारले उत्तर कोड ताटू पाइले.
Rather the accused statement.
1 minute, my lord. 1 minute, I take a question. ସେଥିରେ ଡକ୍ଟର କହିନି ଯେ ଆପିଲେଟ୍ କହିଲା ସେ ମନା କଲା, କହିଛି ଆଟେଣ୍ଡାଣ୍ଟ. ଡକ୍ଟର କହିଛି ତା ଷ୍ଟେଟମେଣ୍ଟରେ ଏବଂ ବେଡ୍ ଟିକେଟ୍ ଲେଖିଛି ଯେ ଆଟେଣ୍ଡାଣ୍ଟ ୱାଜ୍ ଆଡଭାଇଜ୍. ସେଇଆ ପ୍ରୋସିକ୍ୟୁସନ କହିନି, ଆଟେଣ୍ଡାଣ୍ଟ ମଷ୍ଟ ବି ସମବଡି ଏଲ୍ସ. ଇଏ ରହିଲାନି ଇଏ ଖୋର୍ଦ୍ଧାରେ ପୋଷ୍ଟମର୍ଟମ ପାଖରେ ମାଇ ଲର୍ଡ, ସିଏ ହଉଛି ଜଟଣୀରେ ରେଲୱେ ହସ୍ପିଟାଲରେ. ସେଇଥିପାଇଁ ସେଠି କୋଉଠି नो यार प्रोसिक्यूशन स्टेटेड दैट ही वाज अटेंडिंग द मदर, ही वाज विथ द फादर. पुलिस कहला ताको नेक जिया पई कॉन्स्टेबल संगे এবং সে কনস্টেবল তাও ডেড বডি হ্যান্ড ওভার কলা, সে ক্রিমেশন যাইছি, সে ডাক্তারখানা যাইনি মোটে জাননি.
Where from you got it?
My lord, it is from the statement of PW 15, the IO who investigated first.
No, PW 15, PW 14.
14, 15 যেটা না 14, 14. My lord, 14. P-double 14 से narrate करती घटनाटा जे प्रथम आयो
just a minute. You see, come to paragraph number 8. Paragraph 8, page number 93.
My lord, at 2 p.m. on the very day, I dispatched the dead body of deceased Jadu Sahu through constable number so and so and grammar Rakhi so and so to SDMO Khorda for PM examination. The accused and two other relation of the deceased accompanied the said constable. I issued dead body challan.
So that is why the IO sent him to another place.
Yes.
So he was not there at all near the mother. Well, the question of fixing the responsibility on him, that in spite of the doctor's advice, he did not took the deceased mother to the Cuttack hospital.
Well, at the evidence of P-double-4 and P-double-7, the doctor, it is quite clear that the cause of death is homicidal. It is not disputed.
Just a minute. Yes, come on, Kudile.
The death of the deceased person is homicidal. It is not.
There is no problem.
The accused person and the deceased all are staying in one house where there is access to reach.
Where from you got it?
From the accused person?
No, where from you got that there cannot be any access from the outside. That is the evidence which you are required to prove. That no one can enter inside the house except these two accused persons.
Yes, that is from the spot map.
Spot map,
Spot map, there is two doors.
Two doors achi.
If the door is there in night,
No,
obvious
door ta achi, but there is also a staircase. There is no evidence. It should have been positive evidence should have come that no third person
Would have
entered the house. So no possibility of third person entering into the house through that staircase. It cannot be ruled out. Suppose CD ghar nahi, ame jota discussion korthulu. CD ghar nahi ki CD ghar thibo CD ghare obato nahi. Tenu ei circumstance re je kotha upurku jibo jane loko se steps deikini CD deikini asibo tare gharuku access asigala. Tenu apanku evidence aniyaku padibo je se gharuku bahar loko posibara bato nahi.
It was having door lips.
ଆପଣ ତା ଉପରକୁ ସିଫ୍ଟ କରିପାରିବେନି ଆପଣ ଏଇଟା ଆଣିଥାନ୍ତେ ତାପରେ ତାକୁ ଏକ୍ସପ୍ଲେନ କ୍ୱେଶ୍ଚିନ୍ ପଚରାଇଥାନ୍ତା.
But the appellant, he lost the affair that they both accused both the deceased quarrel and in the accused statement
ତାର FIR ରେ ଅଛି ଯେ ସେ ଘରେ 4 ଜଣ ଥିଲେ ମାନେ ଯୋଉ ସେ ରାତିରେ.
Yes.
But ଆପଣଙ୍କୁ ରୁଲ୍ ଆଉଟ୍ କରିବାକୁ ପଡିବ ଯେ ଏ 4 ଜଣଙ୍କ ଛଡା ପଞ୍ଚମ ଲୋକ ଆସିବାର ସ୍କୋପ ନାହିଁ.
My submission is the present appellant first put a story that both the deceased have quarreled with each other and both
accused
in accused statement
accused can take number of plea. Defense plea ଆପଣଙ୍କର defense plea ରେ ଆପଣଙ୍କର case ପ୍ରମାଣ କରିବେନି. Let us say that would be an additional circumstance.
Yes.
Suppose falsity of defense plea may be an additional circumstance, but you are to prove your own case. Let us say he has given a false plea, taken a false plea. Suppose he has taken a false plea, even if you do not prove your case, the accused will be convicted. No. Is it your contention?
These are the circumstances, even if combinedly.
Upon circumstance number 1, ପାଞ୍ଚଟା ଚାରିଟା ସାକ୍ଷୀ କହୁଛନ୍ତି ଭଲ ସମ୍ପର୍କ ଥିଲା, ଗୋଟିଏ ସାକ୍ଷୀ କହୁଛି ତାଙ୍କ ଭିତରେ ତିକ୍ତ ମନୋଭାବ
No,
ଥିଲା
all
ଏବଂ ସେମାନେ ଅଲଗା ଅଲଗା ରୋଷେଇ କରି ଖାଉଥିଲେ। ପର୍ଟିକୁଲାରଲି ଯେବେଠୁ ଏଇ ଯୋଉ ସେକେଣ୍ଡ ସ୍ତ୍ରୀ ଲୋକଟା ଆସିଲା ସେଇଟା ହଉଛି ପୁଣି 6 ବର୍ଷ ଧରି।
my lord, two and 9, they have stated that they have good relation, but they turn hostile as because in one
No,
they are 160.
ପଜିଟିଭ ଏଭିଡେନ୍ସ ଆସିଛି,
Two ର ତ ନାହିଁ, two is a
ପଜିଟିଭ ଏଭିଡେନ୍ସ ଆସିଛି
two is
ଯେ-
not hostile.
No, 2 is hostile.
no, ପଜିଟିଭ ଏଭିଡେନ୍ସ ଆସିଛି ଯେ they were having good relationship. You can see
My lord, 2
There was
hostile.
good feeling between this accused and
there
the
are-
deceased.
Ah.
No, no, is it in his 161? It is different.
Yes, that's why we trial learn and trial court declare him hostile, my lord. Yogeshwar Sahu.
no, I think
No,
ଦି
sorry.
ଜଣ ସାକ୍ଷୀ
ଏ-
କହିଛନ୍ତି ଯୋଉମାନେ
ସୁରେନ୍ଦ୍ର ନାଥ ସୁବୁଦ୍ଧି।
ସେମାନେ କହିଛନ୍ତି ଭଲ ସମ୍ପର୍କ ଥିଲା।
ନା ଟୋଟାଲ ଭଲ ସମ୍ପର୍କ ଥିଲା 2 ଜଣ କହିଛନ୍ତି,
ହଁ, ସେଇଟା-
2 ଆଉ 9,
ହଁ
2 turn
ଆଉ
hostile, 9 also turn hostile.
ନାଇଁ ହୋଷ୍ଟାଇଲ କୋଉ ପାର୍ଟଟା ହୋଷ୍ଟାଇଲ ହେଇଛି ସେଇଟା ଦାଟି ଦେଖିବାକୁ ପଡିବ। ହୋଷ୍ଟାଇଲ ହେଇଗଲା ମାନେ କଣ ଏଣ୍ଟାୟାର ଏଭିଡେନ୍ସ ତାକୁ ଇଏ କରିଦବ ନା କଣ?
PW2, my lord, I am placing page 64, cross examination. It is not a fact that I have stated before the IO that the day when accused Prashanta brought Santilata to the house of Jadu did not allow them to enter inside. That both this accused and his wife forcibly enter inside the house and stay in one room. That accused Prashanta was maintaining his family by doing tuition in separate mess. That accused Prashanta was often asking Jadu to adopt him as his son, but Jadu was all along refusing. That accused Prashanta wanted that Jadu should adopt him and gift all his properties in his
No,
name.
it is not a fact. No, no,
It is
it is not a fact.
161 ଥିଲା।
161 ଥିଲା, yes.
161 को ଆମେ ସବଷ୍ଟାନ୍ଟିଭ ଏଭିଡେନ୍ସ ହିସାବରେ ଧରିକି କନଭିକ୍ସନ କରିବୁ ନା କଣ?
No, that is not.
That is there. Even Surendra was there.
Therefore, the evidence of PW2 learn and
He
trial.
was insisting then that the property be also transferred to his.
Therefore, learn and trial court also at paragraph 15 discarded the evidence of PW9.
And had it not been taken as it is not a fact, had there been an independent cross-examination by the prosecution, things would have been different.
ଖାଲି confront
It is not a fact as a confront for this.
confront करले ଆପଣଙ୍କର ଡ୍ୟୁଟି ସରି ଯାଏନି prosecutor ର many things positive ଯଦି ବାହାର କରି ପାରିବେ
ପାରିବେ।
ସେଇଟାକୁ ମଧ୍ୟ ୟୁଟିଲାଇଜ କରିପାରିବ। so that is why it is always said that hostile witness ମାନେ ନୁହେଁ ଯେ ତାର entire evidence prosecution ବି advantage ନେଇ ପାରିବ, ତା ଦେହରୁ defense ବି ତାକୁ ଯୋଉଟାକ ସୁହାଇବ ତାକୁ ନେଇ ପାରିବ।
Whereas invariably it is a notion that once a witness get hostile, he is to be confronted only with the 161. It is not expected. Because it will go, it is not a fact. And suppose it goes also, it is a fact. What is its evidentiary value? It is not at par with the substantive evidence. So it's a kind
It
of
is not a reliable evidence.
But
so
where
it's
is
a
that
kind of
material that
162.
this lady was brought 6 years back? ये जो evidence है
Keep it all.
6 years तो
6 years
मैं
ଆସିଛି।
କୋଉଟା ଆସିଛି
6 years ଆସିଛି କୋଉଠି ଗୋଟେ।
ମାନେ ଗୋଟେ ପଢିଲା ଭଳିଆ ଲାଗୁଛି
ଇଏ ସେଇ ବୋଧେ PW1 ହିଁ କରିଥିବ।
କିଏ ଗୋଟେ କହିଛି 6 ବର୍ଷ।
ସେଟାକୁ ତା ଭାଇ କହିଛି ବୋଧେ।
ହଁ ସେ ତା ଭାଇ ଏଇ ଯୋଉ ତାର PW କେତେ ଯୋଉ ଆଣିଥିଲେ
14 ନା ସରି
ନାଇଁ ନାଇଁ 10
PW10
on of promotion
PW10
3 to 5 to 6 years after the marriage I came to know.
ନା ନା ସିଏ କହୁଛନ୍ତି 5-6 ବର୍ଷ ହେଲା ବାହା ହେଇନାହାନ୍ତି। ସିଏ କହୁଛନ୍ତି I know the accused in the dock. He has married to my sister Bijal, first wife, in the month of January 1989, and they got a daughter out of wedlock.
ହଁ
5 to 6 years after marriage. After
हाँ.
marriage, Vijay Lakshmi said the marriage.
ହଁ ପରା ଆରେ
That is what?
I
No,
came.
not Santilata, I meant to say.
ବିଜୟ
ନା
ଲକ୍ଷ୍ମୀର
ସେ ବିଜୟ ଲକ୍ଷ୍ମୀର ମ୍ୟାରେଜ ର 5-6 ବର୍ଷ ପରେ ସେ ଜାଣି ଆଇ କେମ୍ ଟୁ ନୋ ଦ୍ୟାଟ୍
ହଁ
ଆକ୍ୟୁଜ୍ଡ ଏଗେନ୍ ମ୍ୟାରେଡ୍ ଟୁ
ହେଲାନି ତାହେଲେ
Yes,
ମାନେ
Santilata.
ବିଜୟ ଲକ୍ଷ୍ମୀର ବାହାଘରର 5-6 ବର୍ଷ ପରେ
ହଁ।
ସେ ଜାଣିବାକୁ ପାଇଲା ଯେ ଶାନ୍ତିଲତା
ଆରେ
This marriage took place when?
ଏ ଘଟଣା କେବେ ହେଲା?
ଏ ଘଟଣା 96 ରେ
ତାମାନେ
89 ରେ ବାହା ହେଇଥିଲା ବିଜୟ ଲକ୍ଷ୍ମୀ
89
ବିଜୟ ଲକ୍ଷ୍ମୀ ର ବାହାଘର 5-6 ବର୍ଷ ପରେ
ଆଚ୍ଛା.
ଆକୁ ବାହା ହେଇଛି ତାମାନେ ଜଷ୍ଟ ବିଫୋର ଦି
ନାଇଁ ନା ସିଏ ଜାଣିଲା ଯେ 5-6 ବର୍ଷ ପରେ ସିଏ ଜାଣିଲା
ଯେତେବେଳେ
ବଟ୍ ଏକ୍ଜାକ୍ଟଲି ସେମିତି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ କେତେ
ଇଏ
ବର୍ଷ
5-6 ବର୍ଷ ପୂର୍ବରୁ ବାହା ହେଇଯାଇଛି ବୋଲି ସେମିତି କିଛି ଏଭିଡେନ୍ସ ନାହିଁ।
But some evidence was required that immediately after this dissension between the commencement of the marriage,
ସେଇଟା ଅଛି
nahi, this dissension was to the extent separate mess ହେଇଗଲା. Yes, that is one aspect. Because of the dissension, she used to stay or the family used to stay in separate mess. Earlier, they used to stay in one mess. So that is a dissension which is proved. But beyond that, consistently this dissension continued. Some more evidence was required to say that there was the dissension continued between the deceased family, the husband and wife Jadu and this and Santilata. If not with the accused,
yes.
at least with Santilata. And the property part bhi asi parlani. Had the property part would have come, probably yes, it could have triggered. Property part
magnitude of
rather property adoption he jaitla evidence as jait
but it is I think other way around. He was insisting to adopt him and to get the property in his name.
କାରଣ ଏଇ ଯୋଉ 12 ନମ୍ବର ସାକ୍ଷୀ କହୁଛି deed was executed.
Yes.
ସେ deed number ଟା ମଧ୍ୟ ସେ ସବ୍ ରେଜିଷ୍ଟର ଅଫିସ ର deed ଟାର ନମ୍ବର କହୁଛନ୍ତି ଏବଂ 93 ରେ ମଧ୍ୟ ସେ deed ହେଇଛି ଡେଟ୍ ମଧ୍ୟ ହଉଛି 1/2/93। ତେଣୁ deed ଟା ଅଲରେଡି ହେଇଯାଇଛି ଇଏ ତାକୁ ପୋଷ୍ୟପୁତ୍ର ହିସାବରେ ରହିଛନ୍ତି ଏ ସବୁ ହେଇଯାଇଛି ତ ବର୍ତ୍ତମାନ ସେ ଯେ ନୁହେଁ ଯେ କିଛି ତାର ପ୍ରପର୍ଟି ପାଇବାର ଯୋଉ ଆଶଙ୍କା
ନାଇଁ ଏଟା ବି ଡେଥ୍ ହେଇଗଲେ ଦି ଜଣଙ୍କ ସେ ସେଲ୍ କରିପାରିବ
ନା ସେ ସବୁ
this has also another aspect my lord. Deed already executed unless and until ପୁଅ ହେଇଗଲା କେତେବେଳେ ବିକ୍ରି କରିବ after death of their father.
କେମିତି ହେଲେ can you say that the murderer cannot get the property Hindu marriage act provision? So ବହୁତ ଜିନିଷ ସେମିତି
that's why they gave a color.
He might not be knowing the consequence of this, that in the event he get involved in the case of murder, he will not be entitled.
That's why they gave color that both quarrel with each other, both killed. He attempted to evade that part.
So baki another thing that what he says that this point you have already said that the not shifting the injured mother to the that SCB medical college.
First instant to hospital, nearest hospital.
He had been
deceased is a railway employee. He is a railway employee. The railway hospital is there at Jatni.
No, railway employee je the pension tonga ye pai par thanda ki jodi ye question arise koruni
only property
jaha property paibo gift deed already you adoption deed already sub register office re sar jayi to ethi apon se ju कहउछन जदे एटा एमपी जो तिक्तता थिला एटा गोटे मैग्नीट्यूड नुहे जोति पई जणे दीटा लोक को मारिबो that was his contention. बाकी आपण जोटा कहउचंती जे से ମା ବାପା ସିନା ମରିଯାଇଥିଲା, ମା ଯୋଉ ଛଟପଟ ହଉଥିଲା
ତାକୁ ହସ୍ପିଟାଲ
ତାକୁ
ଶିଫ୍ଟ କଲେ।
ହସ୍ପିଟାଲ କୁ ନ ନେଇ ସେ ପ୍ରଥମେ କାହିଁକି ପୋଲିସ ପାଖକୁ ଗଲା। ତେଣୁ
It is a natural behavior. One person first shift
but
the
That is
again,
prudence also.
again say that how he will, why he has decided, upon question ही आना थी, प्रश्न पचारना थी, how could he explain it, where from he got this quote? आपण यदि प्रश्न पचारिवे accused statement प्रश्न न पचारे से केमती उनसे तो जनरल कह देला ना इज एनी हम जो दीटा प्रश्न आपण पचारलु ताको पचराई छी बापा तमे माँ को देखिलो सेठी मरिथिबा ए जो छटपट होउथिला मुमूर्ष अवस्था रे ताकू हॉस्पिटल को न नेई किनी तमे पुलिस पाखु केमती थाना को रिपोर्ट दबा
no specific question.
सी हुए तो कही पारि था आज्ञा मु देखिली दी जन जाक पढ़ी भाविली माँ भी मरी जाइए बापा भी मरी जाइए से मु थाना को पड़ेली कि कौन गोटे कही था अपन प्रश्न ही पचारना हाँ तेणु यू सी दी इन दी FIR.
And if you believe the plea taken by the accused that husband and wife by themselves inflicting injuries have died, yes, one thing is also very thing to be taken, that the proximate place of their residence, both the rooms
Particular
are stored, and when two persons are
quarreling
in their death, struggling for death, it's bound to be there is noise between them. So he could not hear it. And it was so silently happened, and two persons are going to die.
And my lord, if my lord see the injury
In
of
the same house, nobody can know. The assailant was so, what kind of appliance has been used or weapon has been used, that he could make them silent fast and kill them. If at all if it is said that a third party intervention is there. Could it be, Mr. Das? Could it be? Two persons are dying, see, and if it is an infliction of injuries between them, yes, so there will not be any sound.
हाँ नहीं तीनटा कथा कही सेटा से लिखि देछि से कहिछि गोटे कथा तांके भितरे क्वालिटी हेछि से एक कथा भी कहिछि जे तो आस्तेन गां लोक जे मु जानने से केमि मरचंती से
ना आमे कहूछु आपण सेटा प्रुडेंस
से भितरे गोटे
केते तार
एको घर पूरा कवाट अछि तांको घर कवाट अछि मझिरे अछि गोटे येटा जोटा
बारंडाटे
नहीं केस पर बारंडा तेणु तांको घर पक्का घर बारंडारे तांकर साइलेंट जो स्टेयर केसटा तांको पई टी ऑडियो एटा गोटे ऑब्स्ट्रक्शन सेकंड होची रास्ताटा थर्ड होची आंकर डोर
गोटे घरे गोटे बारंडार केते थाए जे हम तो कहबे एते
इजे गोटे किछि लेखिनी जे केते प्रकृतर सेटा माने खाली गोटे रूम हाउस
if anything happens in a house, it is under a very close proximity, and when two persons are dying, there will not be any noise at all,
and
which could not be audible to a person who is even a neighborhood. That is no, a person who is living close to the room. It is a living in the room close to the room, not out.
एना प्रकृतरे ताकू से ताकू आक्यू स्टेटमेंट पचराइनी कि प्रोसेस सिंपली कहिबी
other things, suppose what we are discussing, let us say all these things raises a grave suspicion.
Yes.
भाईर मर्डर हितला सेटा भी से कहूची
Can it be grave suspicion? Can it be?
There is grave suspicion, and the defense of the accused is leading towards him, because first he stated that they both quarrel, and if my lord will see the evidence of the postmortem doctor, जनक देहरे इंजुरी यदि आमे यदि जदुर इंजुरी की देखिबा पितेर इंजुरी संभव नुहे यदि पितेर इंजुरी की देखिबा जदुर इंजुरी
if you are thinking that both of them have assaulted each other, that is all right, but if the third person comes and commit the
third person, if third person come and commit the offense, it must be audible to the accused.
No,
one will come out. Scope, there is no scope that both of them, in if the intervention is not by many again 2 or 3,
Yes.
Outsiders means not one.
ସେ ବି ହେଇପାରେ।
And it
ତାହେଲେ ଇଏ
must be.
ମଧ୍ୟ
ଗ୍ରହଣ
If-
କରିପାରିବ
if there will be-
ପାଖ ଲୋକ ତ
No, no.
ପଇସା ଆସିଛନ୍ତି ସେ କହିଛି ମୁଁ କହିପାରିବିନି।
No, no.
ନା ପଡ଼ିଶା କେମିତି ଜାଣିବ ଏଟା ରୁମ୍
ନାଇଁ ସେ କହିଛି ଆକ୍ୟୁଜ କହିଛି
accused is in a room
ରୁମ୍ ନାଇଁ ସେ ଆକ୍ୟୁଜ
is not
କହିଛି
ପଡ଼ିଶା
ତାକୁ ତ ତା ପାଖ ପଡ଼ିଶା ଆସିଛନ୍ତି ସେ କହୁଛି ଇନକ୍ୱେଷ୍ଟ
and there is every possibility of suppressing the fact only by accused. None else.
ଆକ୍ୟୁଜ ଜାଣିପାରିନି ସେ କହୁଛି ମୁଁ ଜାଣିନି
It is
ସେମିତି
how-
କହି ପଡ଼ିଥିବ
if
କଣ
there will
ହେଇଥିବ
be
ଏମିତି
third person
That is how the
intervention.
plea has been taken right from the beginning that the inflicted injuries in
ନାଇଁ
themselves.
ସେମିତି ତାଙ୍କୁ କହିଛି କହିଛି ସେଟା ଏଫଆଇଆର ରେ 6:10 ବେଳକୁ ପୁଣି ତ ତା ପୂର୍ବରୁ ତ ଲୋକ ଆସିଛନ୍ତି ପ୍ରଥମେ ତାଙ୍କୁ କହିଛି ମୁଁ ଜାଣିନି କାରଣ ସେ ଲୋକ ଇନକ୍ୱେଷ୍ଟ କହିଛନ୍ତି ତାପରେ ଆକ୍ୟୁ ଷ୍ଟେଟମେଣ୍ଟ କହିଛି ଯେ ତାର ତାକୁ ଯେ ମର୍ଡର କରିଥିଲା ତା ବଡ ଭାଇ ସେ ବି ହେଇପାରେ କିନ୍ତୁ ତା କଥା ସେ କେମିତି ଜାଣିବ ସେ ତ ଜାଣିନି ବୋଲି କଥା ପଡିଛି ନା ସେ ଯାଇକି ଏଫଆଇଆର ଦେଇଛି
My humble submission is, if
ତିନିଟା
there will
probability
be
ଅଛି
third person intervention, if more than one,
Hmm.
if more than one, it must be audible to the accused.
ନାଇଁ ସେଇଟା ଯୋଉଟା କଥା ଯେ ସେଇଟା ହେଲାନି ତାପରେ ସେଠି ବି ମଧ୍ୟ ଦି ପଟରେ ଗୋଟେ ପଟରେ ଦି ପଟରେ ମଧ୍ୟ ଅଛନ୍ତି ଖାଲି ଆକ୍ୟୁଜ ହେଲାନି ସେପଟେ ତ ଝରକା ଅଛି ସେ ଘରରେ ସେପଟରେ ମଧ୍ୟ ପାଖ ଘର ବି
No, no,
accused
don't
was
go to never.
Very much.
ଇଏ ତ ଏତେ ବାଟରେ ଅଛି ଇଏ ରହିଛି ପୁରା ଗୋଟେ କମ୍ପାଉଣ୍ଡ ଏଇ ଯୋଉ ଆଙ୍କର ସେପଟେ
Accused.
ପୁରା ବିଗିନିଂ ର କର୍ଣ୍ଣର
Accused
ରୁମରେ
compound.
ହଁ କମ୍ପାଉଣ୍ଡ ବା
Right.
ସାର୍
Accused
ସେଟା
front door room,
ଫ୍ରଣ୍ଟ ନୁହେଁ ମଝିରେ ଅଛି
veranda.
ନାଇଁ ନାଇଁ ବାରଟା ଖାଲି ନୁହେଁ ଆଜବେଷ୍ଟ ଘର ପକ୍କା ଘର ମଝିରେ ହଉଛି ଯୋଉ ପୁଅ ଯୋଉ ରହିଲା ଫାଙ୍କା ରହିଲା
ନା 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 ଆପଣ କୁଆଡେ ଦେଖିଛନ୍ତି
ନା,
ଆପଣ
ମୁଁ ଦେଖିଛି
ଦେଖନ୍ତୁ।
ମ୍ୟାଡ଼ାମ,
ନା, ନା, ସେଟା କୋର୍ଟୟାର୍ଡ ଟା ଅନ୍ୟ ଆଡକୁ ଅଛି କୋର୍ଟୟାର୍ଡ is
ସେଇଥିରେ
not-
ଅଛି ପ୍ୟାସେଜ ଅଛି
ନା ନା it has nothing to do with it. It's a just face to face.
Minor.
Rooms are face to face.
ନାଇଁ, କିଛି ମଝିରେ
ଦେଖନ୍ତୁ ଆପଣ ରୁମ୍ ଟା ହେଲା ଏକଦମ face to
ନାଇଁ,
face
ସେ ଯୋଉ
only veranda.
ଗୋଟେ ଚିହ୍ନ ଦିଆହେଇନି ବାଉଣ୍ଡରୀ ଆମର ସାଧାରଣ
ସେ ବାରାଣ୍ଡା ସେ ବାଉଣ୍ଡରୀ
ସେଇଟା
ନାହିଁ
ଗୋଟେ ବାହାରକୁ ବାରାଣ୍ଡା ହେଇଥାଏ
ହୁଁ।
ବାରାଣ୍ଡା ଯୋଉଟାକୁ ଆମେ ବାହାର କହନ୍ତି
ଅବଶ୍ୟ
ମଝିରେ
we
କୋଟା
cannot
ଅଛି।
ନାଇଁ,
cross
ସେ-
the
ସେପଟେ
no.
କଣ ହେଇଛି?
ବାଉଣ୍ଡରୀ ୱାଲ ନଥାଏ
But
ନାଇଁ,
ସେ
ସେଠି-
ଯୋଉ ଏଭିଡେନ୍ସ ରୁ ଆମେ ଦେଖୁଛୁ ଯେ ଯିବା ଆସିବାକୁ ରାସ୍ତା ଅଛି।
ରାସ୍ତା।
କିନ୍ତୁ ସେଟା କ୍ଲୋଜ
My
ସେଟା
third
ଓପନ ଆମେ
person intervention is not believable because if
But
any
you
there will be
believe
any third person
ସେଇ
intervention
ନିଜ ନିଜ ଭିତରେ ହେଇପାରେ
then it must be
ଆପଣ ଯଦି ଏଇଟାକୁ ସ୍ପଟ ମ୍ୟାପ ଧରିଲେ
ହୁଁ।
ବଟ୍ ମାଇ ବ୍ରଦର ଇଜ ପଏଣ୍ଟିଂ ଆଉଟ୍ ଏଇଟା କ୍ଲୋଜ କଲେ କଣ ପାଇଁ କଲେ
କୋଉଟା ଏଇ ଯୋଉ ପୁଅ ସେଣ୍ଟରରେ ପୁଅ
ଏଇଠି ଜଣା ପଡୁଛି ଏଠି ଆଜି ଆଉ କିଛି ଉପାୟ ଯୋଉଟା କି ମିଷ୍ଟର ଦାସର ଆର୍ଗୁମେଣ୍ଟ ହଉଛି ଏପଟକୁ ହଁ ଆପଣ କହୁଛନ୍ତି ଏପଟୁ ସେପଟକୁ ଯିବାକୁ ବାଟଟା ଅଛି
ହୁଁ।
ବଟ୍ ବାଟଟା ଅଛି ଯେ ଏଠି ଯୋଉ ବନ୍ଦ କରିଦେଲେ ଆପଣ ବାଟଟା ମାନେ କୋଉ ପଟେ ତାହେଲେ ବାଟ ରହିବ ଏଗୁଡା ସବୁ ବନ୍ଦ କରିଛନ୍ତି ମାନେ ଇଟ୍ ସପୋଜେସ୍ ଦ୍ୟାଟ୍ ଆଜି ଗୋଟେ ୱାଲ୍ ଟାଇପ ର ଗୋଟେ କଣ ରହିଛି
ରହିଛି ଡାଣ ପଟରେ ପାସେଜ ରହିଛି ସେଇଠି।
ଆମର
14ଟା ଗୋଟେ ଆଉଟଲେଟ ଅଛି।
ହଁ ସେ 14
ଚଉଦଟା
ବାଟେ
ଗୋଟେ-
ଯିବା ଆସିବା କରୁଛି
14ଟା ଗୋଟେ ଆଉଟଲେଟ ଅଛି 6 ନମ୍ବର ଯୋଉ ସ୍ପେସ ଟା
ଟୁ ବ୍ୟାକୟାର୍ଡ
6
ବ୍ୟାକୱାର୍ଡ ନୁହେଁ ସେ ସାମ୍ନାକୁ ବି ସେ ଯୋଉ ଚାରି ଆଡକୁ ସେ ସେଠି ରହିଛି ରାସ୍ତା
ହଁ ଏଇଟା ରାସ୍ତା
ମାଇଲଟ କାଇଣ୍ଡଲି 6 ନମ୍ବର ଟା ହଉଛି କୂଅ ସେଇ ଯୋଉ ଚାରିକଣିଆ ଯୋଉ ସ୍ପେସ ଟା ରହିଲା ସେଟା ଅଗଣା
ହଁ ଏଟା କୋଟିଆଟ
କୋଟିଆଟ।
ମଝିରେ କୋଟିଆଟ ହଁ
କୋଟିଆଡରେ ସିଧା ଏପଟରୁ ସେପଟକୁ ମଝିରେ ସେଇ ଯୋଉ କୋଟିଆଡ ଚଢିକି ସେଠିକି ଯାଇପାରିବ ଘର ଗୁଡା ସବୁ ଫେସ୍ ଟୁ ଫେସ୍
ହୁଁ
ଆମ ସାଧାରଣତଃ ଗାଁ ଭିତରେ ଯେମିତି ହୁଏ ମଝିରେ
ନାଇଁ ସେଠି ବା କାନ୍ଥ ଅଛି
ନା କାନ୍ଥ ନୁହେଁ ସେ ଚିତ୍ର ଦେଖେଇଛନ୍ତି ଦିସ୍ ଇଜ ଦ କୋଟିଆଡ
ଏଠି ରୁମ୍ ଦେଖେଇଛି
ସେଇଠି କେବେ କାନ୍ଥ ହବାର ନାହିଁ ଯେ ମ୍ୟାଟେରିଆଲ ଇଜ ନଟ୍
ମୁଁ ଯାହା ଜାଣିଲି
କାନ୍ଥ ହେଇପାରିବ ନାହିଁ
ନାଇଁ ସେ ମୁଁ ଯାହା
କୋଟିଆଟରେ
ଜାଣିଲି
କାନ୍ଥ-
ହଜୁର ମୁଁ ଯାହା ଜାଣିଲି ଏଇ ଯୋଉ 13ଟା ହଉଛି ଠାକୁର ଘର ଏଇ 14 ପାଖରେ ଅଛି ରୋଷେଇ ଘର 14 ପାଖରେ ରୋଷେଇ ଘର ବୋଲି ଆକ୍ଚୁଆଲ ଫ୍ୟାକ୍ଟ ସେମିତି
ନା, ନା,
କହିଲା।
ରୋଷେଇ
ନା,
ଘର ତ ଦେଖା
ତେର ନମ୍ବର
ଏଇ ନକ୍ସାରେ ପା ହେଇନି ସ୍ପଟ ମ୍ୟାପରେ ହେଇନି
ନକ୍ସାରେ 13 ନମ୍ବରଟା କିଚେନ
ହଁ ନାଇଁ ସେ
13
କହିଲା
ହେଇଛି ଆଉ
ନକ୍ସାରେ 13 ନମ୍ବରଟା କିଚେନ ଅଛି
କିନ୍ତୁ ସେ 14 ନମ୍ବର ପାଖରେ ଗୋଟେ
ଯୋଉ
ରାସ୍ତା
ଜାଗାରେ
ଅଛି
କିଚେନ normally that is the place where kitchen is available in a nearby courtyard in villages and that is the place
ଯେହେତୁ
and that is
head of the
also to
family
the east
yes
ନାଇଁ ସେ କହିଲା ଯେହେତୁ ଯଦୁ ଇଜ ହେଡ୍ ଅଫ ଦ ସେ
ପୂର୍ବ
ପଛପଟେ ଯିବା ପାଇଁ ଏ ଡାଣ ପଟ ରାସ୍ତାରେ ସେଇ ଡାଣ ପଟ ପ୍ୟାସେଜରେ ସେ ପଦାକୁ ଯାଆନ୍ତି ପଦାଟା ହଉଛି 4 ତେଣୁ ମେନ୍ ଗେଟ୍ ଟା ସେଟା ହଉଛି ଆର କଣ୍ଟ୍ରୋଲରେ କାର ନା ଡିସିଜର କଣ୍ଟ୍ରୋଲରେ ଏଇ ଯୋଉଟା ରୁମ୍ ନମ୍ବର 1 ର ଗେଟ୍
ସେମାନେ କାହିଁ ସେ ରହୁଛି କେତେ ନମ୍ବରରେ
10 ନମ୍ବରରେ
10 ରୁ ସେ 4 କୁ ଯିବ 1 ନମ୍ବର ହେଇକିରି
ନାଇଁ ନାଇଁ 4ଟା ହଉଛି ଫ୍ରଣ୍ଟ ଟା
ହଁ
4ଟା
Yes.
ସେ ସେବାଟେ ନ ଯାଇକିନି
ହୁଁ।
ସେ ଯୋଉ 14 ବାଟେ
ହୁଁ।
ଯୋଉ ପ୍ୟାସେଜ ବାଟେ ଯୋଉ ଫାଙ୍କା ଅଛି ବାଡି ସେ
ନା,
ବାଡିରେ
ତାମାନେ
ସେ
4 କୁ
ଯାଆନ୍ତି
ଯିବାକୁ ତାର ସ୍କୋପ ନାହିଁ
କପ ଅଛି ଯେମିତି ଭଲ ପଡୁନି ସେ ସେପଟେ
ତା ମାନେ ସ୍କୋପ ଅଛି ଆଉ ଅଛି ଯଦି କୋଉଟା ନା ସେଇ ବାରାଣ୍ଡା କାହାଟା ନା 3 ସାମ୍ନା
ନାଇଁ, ସେ କଣ ମତେ ଆକ୍ଚୁଆଲି ଯୋଉ ଘର ବୁଝିଲି ସେ ଯୋଉ ଗୋଟେ ଘର ପକ୍କା ଘର ତାର ବାରାଣ୍ଡାରେ ଅଛି ଷ୍ଟେୟାର କେସ୍ ସେବାଟେ ରାସ୍ତା ନାହିଁ ରାସ୍ତା ମାନେ ସେବାଟେ ବ୍ଲକ ଲାଗିବ ସେଥିପାଇଁ ଫାଙ୍କା ରାସ୍ତା ଅଛି ଡାନ ପଟରେ ଯୋଉଥିରେ କି ସେ ଇଜି ଆକ୍ସେସ ସେମାନେ କରିବା ପାଇଁ
ନାଇଁ,
ସ୍ୱାମୀଟିଏ ସ୍ତ୍ରୀଟିଏ
spot
ପୁଣି
map ଟା ଏକଦମ clear ଅଛି।
ତିନିଟା ଘର ଷ୍ଟୋର ରୁମ୍
ଟିକେ ମୁଁ
ଗୋଟେ
କହିବି
ଭିତରେ ସେ ଅଧା ରହୁଛନ୍ତି।
ସ୍ପଟ୍ ମ୍ୟାପ୍ ଟା ଏକଦମ କ୍ଲିୟର ଅଛି କାହିଁକି ଗୋଟେ ଗୋଟେ କରି
ନାଇଁ,
ଦେଖିଲେ
ନାଇଁ,
ଆମେ
spare
ଟିକେ କହିଦେ
କୁହନ୍ତୁ ହେଲା
1 ନମ୍ବର ଏଣ୍ଟ୍ରାନ୍ସ
ହଁ
ମାଇ ଲର୍ଡ କାଇଣ୍ଡଲି ହାଭ୍ ଗ୍ଲାନ୍ସ 4 ନମ୍ବର 1 ନମ୍ବର ରୁମ୍ ରେ ଏଣ୍ଟ୍ରାନ୍ସ ଚିହ୍ନ ଅଛି 2 ନମ୍ବର ଷ୍ଟୋର ରୁମ୍
ହୁଁ
3 ବେଡରୁମ୍ ଅଫ ଦି ଡିସିସ୍ଡ
Right.
3 ନମ୍ବର
ଓ 3 ବେଡରୁମ୍ ଅଫ ଦି
ଡିସିସ୍ଡ
ଡିସିଜ୍ ଆଚ୍ଛା ହଁ
यस ଇଜ ଦ ସ୍ପଟ୍ ସେଇଟା ହଉଛି
ଓ
ସ୍ପଟ୍
3 ହଉଛି ଡିସିଜ୍ ର
ଡିସିସ୍ଡ ର
10 ନୁହଁ
ନା
ନାଇଁ, ଦଶ
ଚାରି
ବି accused।
ଚାରି
ରାଇଟ୍
4 ନମ୍ବର ଫ୍ରଣ୍ଟାଲ ବାରଣ୍ଡା ଆମ ଗାଁ ରେ ଦାଣ୍ଡରେ ଯୋଉ ଗୋଟେ ବାରଣ୍ଡାଟା ଥାଏ
ମୁଁ ତ ସେଟା କହୁଛି କିନ୍ତୁ ଆପଣ ନକ୍ସା ଯଦି ସ୍ପଟ୍ ମ୍ୟାପ୍ ଠିକ ଅଛି
ଟିକେ-
ତାହେଲେ ଚାରିପଟ କଭର
ମୁଁ ଟିକେ
କରିଦିନ।
କହିଦେଇ ସାର୍ 4 ନମ୍ବରଟା ବାରଣ୍ଡା
ରାଇଟ୍
5 ନମ୍ବର ଇନର ବାରଣ୍ଡା
ହୁଁ
ସେ ଘର ଦୁଆର ମୁହଁକୁ ଆଉ ଗୋଟେ ବାରଣ୍ଡା ଅଛି 6 ନମ୍ବର ୱେଲ୍
ହୁଁ
ଆଉ ସେଇ ଯୋଉ ସ୍ପେସ ଟା ରହିଲା ସେ ଦ୍ୟାଟ ଇଜ କୋର୍ଟୟାର୍ଡ ସେଇଭଳି 7 ନମ୍ବର ଷ୍ଟେୟାର କେସ୍
ହୁଁ
ଉପରକୁ ଯିବା ପାଇଁ 8 ନମ୍ବର ସାଇଡ ବାରଣ୍ଡା
ହୁଁ
ଏଠି କିଛି ୱାଲ୍ ନାହିଁ ବାରଣ୍ଡା ଲେଫ୍ଟ ସାଇଡ ରେ କିଛି ୱାଲ୍ ନାହିଁ
ନାହିଁ ପରା ସେଟା ନାହିଁ ହେଇପାରିବନି
ହେଇପାରିବନି
ଏଇଠି
ନ
ଟିକେ
ଯଦି
ମୁଁ କହିଦିଏ
ଟିକେ
ଟିକେ
ମୁଁ ଟିକେ ସାରି ଦେଇ ସାରେ
ସେଇଥିପାଇଁ
9
ସେ
ନମ୍ବର
ଗୋଟେ ଇଏ
ଇଣ୍ଟରନାଲ ବାରଣ୍ଡା 9 ନମ୍ବର
ହୁଁ
ଯୋଉଠି 10 ନମ୍ବର ରୁମ୍ ଯୋଉଠି ଆକ୍ୟୁଜ୍ଡ ରହୁଛି
ଏମିତି ଚାରିଆଡୁ ଆସିଛି ଏଲସେପ
ବାସ୍ ଯୋଉ 10 ରୁମ୍ ନମ୍ବର 10 ଦି ରୁମ୍ ଅଫ ଦି ଆକ୍ୟୁଜ୍ଡ ତା ସାମ୍ନାରେ ମଧ୍ୟ ଗୋଟେ ବାରଣ୍ଡା
स्टोर रूम कम बेडरूम
ଷ୍ଟୋର ରୁମ୍ କମ୍ ବେଡରୁମ୍ ସେଟା ତା ସାମ୍ନାଟା ରହିଲା 9 ନମ୍ବର ସେଟା ଗୋଟେ ବାରଣ୍ଡା 11 ଷ୍ଟୋର ରୁମ୍
12 भी स्टोर रूम
12 ଷ୍ଟୋର ରୁମ୍ 13 କିଚେନ୍
ତାମାନେ 10 ରୁ କୋଟିଆଡ ହେଇକରି ବି ସେ
ସବୁଆଡେ ଯାଇ ହବ।
ନାଇଁ
ସବୁଆଡେ
ନାଇଁ ସେ
ମାନେ
କହିକି ମୁଁ କହୁଛି
ଗୋଟିଏ
ଗୋଟେ
ଦେଇକି
reasonable
ସେ-
କଥା ଗୋଟେ ରହିଯାଉଛି ଯୋଉଟା ସ୍ପଟ୍ ମ୍ୟାପ୍ ଭୁଲ ଥିବାରୁ ଯୋଉ 7 ଲେଖା ହେଇଛି ଷ୍ଟେୟାର କେସ୍ଟା ପ୍ରକୃତରେ ଏଟା ଆଜବେଷ୍ଟସ୍ ଘର ଷ୍ଟେୟାର କେସ୍ ନୁହେଁ ଏଟା ସେଇଟା ହଉଛି ତା ଆର ପଟକୁ ସେ ଭୁଲରେ କରିଛି ଷ୍ଟେୟାର କେସ୍ଟା ଏପଟକୁ ଯୋଉଥିପାଇଁ କି ଏଇ ଯୋଉ ସନ୍ଦେହଟା ଆସୁଛି କାରଣ ସେ ପକ୍କା ଘର ଯୋଉଟା ଯୋଉଟା ହଉଛି 3 ନମ୍ବର ରୁମ୍ ଇଏ ଇନର ବାରଣ୍ଡା ଆଉଟର ବାରଣ୍ଡା ସେଇଟା ହଉଛି ପ୍ରକୃତରେ ପକ୍କା ଘର ସେ ପକ୍କା ଘର ବାରଣ୍ଡାରେ ଷ୍ଟେୟାର କେସ୍ଟା ଆର ପଟକୁ ସେ ଏପଟକୁ ଦେଖେଇଥିବା ଦ୍ୱାରା ଘର କଲାବେଳେ ବାରଣ୍ଡା ଉପରେ ଷ୍ଟେୟାର କେସ୍ ଉଠେ ନଟ୍ ଦ୍ୟାଟ୍ ସେ ଗୋଟେ ଆଜବେଷ୍ଟସ୍ ଘରୁ ବାହାରିବ ଷ୍ଟେୟାର କେସ୍ ଯୋଉଟା ହେଇଛି ସେଟା ହଉଛି ପ୍ରକୃତରେ ରଙ୍ଗ ହେଇଯାଇଛି ଖାଲି ସେତିକି ନୁହେଁ ମୁଁ ଯାହା ଜାଣିଛି ଏ ଦିଗ ଗୁଡ଼ା ବି ପୁରା ଭୁଲ ଭାଲ ହେଇଛି ସେଇଥିପାଇଁ ଏଇଟା ସବୁ କନଫ୍ୟୁଜିଂ ହଉଛି ସ୍ପଟ୍ ମ୍ୟାପ୍ଟା ଏବଂ ରାଧା ମୁଁ ଯୋଉଟା କହୁଛି ଯେ ଯେହେତୁ 14 ପାଖରେ ଅଛି ଗୋଟେ ରୋଷେଇ ଘର ଏବଂ ଏଟା ହଉଛି ଠାକୁର ଘରଟା ହଉଛି 13 ସେ ଯୋଉଟା କହୁଛି ସେଇ ବାଟେ ସେ ଯେହେତୁ ତାଙ୍କର ଇଜି ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଟିକେ ମାନେ ଶାଶୁ ଶ୍ୱଶୁର ଆକ୍ସେପ୍ଟ କରୁନାହାନ୍ତି ବୋଲି ସେ ସାଇଡ୍ ରାସ୍ତା ଯେହେତୁ ଅଛି ଏଇ ରାସ୍ତା ମଧ୍ୟ କନେକ୍ଟ କରିଛି ସାମ୍ନା 4 ର ଯୋଉ ମେନ୍ ରାସ୍ତାକୁ 4 ପାଖଟା ଯୋଉଟା ସେଟା ମେନ୍ ରାସ୍ତା ଗାଁର 4 ପାଖ ବାରଣ୍ଡାରେ
ହଁ।
ସେ ସେଇ ବାଟେ ଆପ୍ରୋଚ କରନ୍ତି ଏବଂ ଏ ବାଟେ ସେ ଯେହେତୁ ଯେତେ ହେଲେ ବି ବୟସ ହେଇଥିଲେ ଯାହା ହେଇଥିଲେ ବି ଭଲ ପଡୁଥିଲା ପରେ ଯେହେତୁ ମାଲିକ ଯଦୁ ସାହୁ ବାପା ମା ସେମାନେ କଣ ନା ତାଙ୍କୁ କିଛି ଡିଷ୍ଟର୍ବ କରନ୍ତି ନାହିଁ ଆଉ ତାଙ୍କର ସବୁ ଜିନିଷ ସିଏ ରଖନ୍ତି ଇଏ ଖାଲି ଟ୍ୟୁସନ କରି ଚଳେ ଏଟା ବି ଆସିଛି ଏଭିଡେନ୍ସରେ ଏତେ ବଡ ଘର ସବୁଟା ଖାଲି ଷ୍ଟୋର ରୁମ୍ ଇଏ ଗୋଟେ ଷ୍ଟୋର ରୁମ୍ର ଅଧା ରହୁଛି ସେଥିରେ ଯୋଉ ଜାଣୁଥିବେ ସେ ଆଡଜଷ୍ଟ କରିକି ରହୁଛି କାରଣ ତା ବାପା ମାଙ୍କୁ ସେ କିଛି ଚାହିଁନି ଟେଷ୍ଟ କରିବି ସେ ଯେହେତୁ ଗୋଟେ ଆଉ ଗୋଟେ ଝିଅକୁ ନେଇ ଆସିଛି ସେ କିନ୍ତୁ ଆଣିଛନ୍ତି ସେ ରଖିଛନ୍ତି କିନ୍ତୁ ସେ ରହିଛି ପୁରା ଗୋଟେ ମାନେ लो प्रोफाइल मेंटेन करके से रही
एयर केस विषय कौन अपन
एयर केसटा जो 7टा एपटको ହେଇଛି ଆଜବେଷ୍ଟସ୍ ଘରକୁ ଦେଖେଇଛି ସ୍ପଟ୍ ମ୍ୟାପରେ କିନ୍ତୁ ପ୍ରକୃତରେ ସେଟା ଆର ପଟକୁ ଯୋଉଟା କି ବାରଣ୍ଡା ଉପରେ ଆର ପଟ ବାରଣ୍ଡାଟା ସଇଲା ଯୋଉ 5 ସେ 5 ରେ ସେଟା ଯୋଉଟା କି ଏଟା ଭୁଲ ହେଇଥିବାରୁ ଏତେ କନଫ୍ୟୁଜନ ହଉଛି
କିଛି ଏତେ
କାରଣ ପକ୍କା ଘର ହେଲା ବେଳେ ଏୟାର କେସଟା ବାରଣ୍ଡାରେ ଯିବାଟା ରିଜନେବଲ ସେ ଗୋଟେ ଏୟାର କେସଟା କରିବେ ଆଜବେଷ୍ଟସ୍ ଘରେ ଛାତକୁ କେମିତି ଯିବ ସେଟା
ସେ ଆଜବେଷ୍ଟସ୍ ଘର 10 11 12
ନୁହେଁ ସେଟା ନୁହେଁ ବୋଲି କାହିଁ କହୁଛି ମୁଁ ଯଦି ପୋଲିସ ପଚାରିବା ହଜୁର ଯେ ପ୍ରକୃତରେ କୋଉଠି ଅଛି ତାହେଲେ ଘଣ୍ଟା ଭିତରେ ବି ପୋଲିସ କହିବ ତା ଘରଟା କୋଉଠି ଅଛି କାରଣ ସେଟା ହେଇଯାଇଛି ମିଷ୍ଟେକ୍ ମାନେ ସେ ମିଷ୍ଟେକ୍ ପାଇଁ ଗୋଟେ ଆକ୍ୟୁଜ ପାଇବ ଫାଶୀ ପାଇବ 302 ରେ ବା ଆଜୀବନ କାରାଦଣ୍ଡ ହେବ ସେଟା ମିଷ୍ଟେକ୍ ପ୍ରୋସିକ୍ୟୁସନ ଏଭିଡେନ୍ସ ଭୁଲ ପାଇଁ ସେଟା ସେ ଏକ୍ସପ୍ଲେନ୍ କରିବାର ଥିଲା ପକ୍କା ଘର ଯେତେବେଳେ ହଉଛି ଷ୍ଟେୟାର କେସଟା କାହିଁ ଯିବ ଏଥିରୁ ଯିବ ଆଜବେଷ୍ଟସ୍ ଘରୁ ପକ୍କା ଘର ନିଶ୍ଚୟ ପକ୍କା ଘରଟା ହଉଛି ଏ ବାଁ ପଟେ ଲେଖିଲା 10 ଫୁଟ ଇଣ୍ଟୁ 8 ଫୁଟ ଇଣ୍ଟୁ 10 ଫୁଟ ହଉଛି 3 ନମ୍ବର ରୁମ୍ଟା ତାମାନେ 10 ଫୁଟରେ 8 ଫୁଟ ଦେଖା ହଉଛି ଓସାରଟା ତେଣୁ 10 ଫୁଟ ହଉଛି ଉଞ୍ଚା
ନାଇଁ ଯେ ଗାଁରେ ଆଉ କାହା ସହିତ ତାଙ୍କର ଝଗଡା ଥିଲା ବୋଲି କୋଉଠୁ ଏଭିଡେନ୍ସ ଅଛି ଆପଣ କହୁଛନ୍ତି ଥାର୍ଡ ପର୍ସନ ଆସିବ ବୋଲି
ସେଇପା ଯେ ତାଙ୍କର ଯୋଉ କଥା ହଉଛି ସେ କହୁଛି ଯେ ମୋ ଭାଇକି ମାଇଲା ସେମାନେ ତାଙ୍କର ଯୋଉ ପ୍ରପର୍ଟି
ଏଭିଡେନ୍ସ ଟା କଣ ଭାଇକୁ କିଏ ମାରିଥିଲା ବୋଲି ଏଭିଡେନ୍ସ କୋଉଠି
ସେଟା ହଉଛି ଆକ୍ୟୁ ଷ୍ଟେଟମେଣ୍ଟ ରହିଛି ଆଉ ଗୋଟେ ଇଏ ବି ମଧ୍ୟ ଜଣେ ୱିଟନେସ୍ କହିଛି କି ମୁସଲିମ ଲୋକ ଜଣେ ତାକୁ ମାରିଛି ବୋଲି ସେ କହିଛି ଅଛି ସାର୍
ମୋଟିଭ ସେଥିରେ କଣ ଦିଏ
ମୋଟିଭ ହଉଛି ଏଇ ଯୋଉ ପ୍ରପର୍ଟି ଇଏ ନେଇଯିବେ ବୋଲି
ଓ ଇଏ ନେଇଯିବ ବୋଲି
ଏଇ ଯୋଉ ପୁଅ କରିକି ଆଣିଲା ପୋଷି ପତ୍ର ଦଲିଲ କରିକିନି ତା ପୂର୍ବରୁ ବଡ ଭାଇକି ମାରିଥିଲା
आउटसाइडर केमती नहीं जानते
नहीं नहीं साहिरे ये दिन आकर कहीं नरे इश्यूलेस
हाँ,
नहीं जिवे
हाँ
तार से प्रॉपर्टी तार भाई आले नहीं
आर आपनकर क्वेश्चन नंबर 29 आंसर होची मो आगुरु मोर बड़ भाई
हाँ से गुड
ଯାହାର ପୁଅ-
ଜଡୁର
ଯଦୁର ପୁଅ ହୋଇ ଥିଲେ
ହଁ
1978 ମସିହାରେ ତାଙ୍କୁ
ହତ୍ୟା
ହତ୍ୟା
କରାଗଲା
କରାଗଲା ତାପରେ ଯଦୁ ଓ ପିତେଇ ମତେ ପୁଅ କଲେ ଯେଉଁମାନେ ମୋ ଭାଇକୁ ମାରିଥିଲେ ସେମାନେ ଷଡ଼ଯନ୍ତ୍ର କରି
ସନ୍ଦେହ କରୁଛି
ସୁଆଂଶୁ ପିତେଇକୁ ମାରି
this fact he should have lost at the first instance this fact he should have lost at the first instance
ତା ମାଇଣ୍ଡ ସେ ଗୋଟେ ବାପା ମରି ଯାଇଛି ମା ମରି ଯାଇଛି ଗୋଟେ କୋଉ ମାଇଣ୍ଡରେ ଅଛି ଯାଇକିନି ଦୌଡ଼ିକିନି ଏଫଆଇଆର ଯଦି 6ଟା 10 ରେ ଏଫଆଇଆର ରେଜିଷ୍ଟର୍ଡ ହେଇଛି ମାନେ ସକାଳ 5ଟା ବେଳେ ସେ ପହଞ୍ଚି
ଟିକେ ମୁଁ ଖାଲି କହିଦେ my whole submission is the defense in the accused statement why the accused has taken the defense plea he should have he should have taken this plea at the first instance that apart the spot map it is a compact house two doors are there to ingress and outgress apart from that there is no other way there is very much easy access from the room number 10 to room number 3 there is no barrier so if any intervention of any third person is there it must be within the knowledge of the
other inmates in the house
other inmates in the house madam so the present appellant the sole accused who has committed the double murder
why the wife has been left out
क्षेत्र कौन एविडेंस आसिला
भाई तो एविडेंस तो या दी जन
एई साक्षी माने कौन कहिले
is self some evidence है
नहीं खाली साक्षी नंबर एक सब होती एविडेंस इज दी
सेठी PW1 कौन कहिला
नहीं नहीं चार्जशीट इज सेम
से यस
चार्जशीट इज सेम विटनेसेस मदर्स ऑब्वियसली खाली ये फेरा रही गला बोली ये स्त्री रो आगुरु ट्रायल फेस हे गला
ना ताते से केस रे अछि ना प्रथम कथा होची स्त्री किछि कहि नथला डिफेंस रे किंतु स्त्री एफआईआर देई नथिला जे से माने स्वामी स्त्री झगड़ा लगी मले
जियो रे जणे एफआईआर
ना फास्ट संदेहटा सेकंड का
स्त्री का स्वामी कहला
सेकंड रे से जो डिफेंस प्ली नैची इन दिस केस अक्यूज्ड जे मो भाई की जो माने मारथिले से माने
এটা 99 দেই সেটা 2000 সেম কি শেষ হয়ে লেভেল করতে করতে দামজি কি বলতে সেটা সাবস্টান্সিয়াল লোন এর সাথে না ফরওয়ার্ড সাইড টাইম পেলে তো বড় প্লেসমেন্ট রেগিং দিও সেটা আর জজমেন্টটা কাই আর ওইটা
সেটা আছে তার
আচ্ছা হ্যাঁ জাস্ট হ্যাঁ এটা তো খালি ইয়েটা দাও
evidence
এভিডেন্স না জজমেন্ট আছে
ସବୁ ସାଥିରେ ଅଛି।
ଜଜমেন্ট আছে
जोगेश्वर साहू PW1 whether he is a witness
ହଁ,
that
ଅଛି 9 ନା 10 ଅଛି
So finding ultimately what has been held in that case, that thus it is clear from the evidence of so and so that there was ill feeling between the accused means you lady
Yes.
absconding accused person means this appellant and Jaddu and Pite, and it is also crystal clear that both the accused persons were present at the relevant time. And when they were in the same house, they were the only persons to know about the occurrence, and none of the neighbors was present at the time when both the deceased persons sustained injury. But accepting that accused Shantilata was present at the relevant time and there was ill feeling between the deceased persons and the accused, there is no other circumstance to connect this accused to the commission of the alleged crime. The prosecution has not been able to prove its case beyond all reasonable doubt.
But this
Since
case
the
is
item
something different.
witnesses strong
Any.
hosted.
But this case, I am placing the manual finding of the London trial court. Paragraph 18, page 32.
Paragraph
18. The prosecution has not spelled out the motive.
Just a minute.
Para 18.
My lord. Page 32. The prosecution has not spelled out the motive of the accused in so many words, but PW1 has categorically stated that the relationship between the deceased couple and the accused became strained.
Strain बोले किसी word नहीं.
Ticket होता है
हम
मुझे
बोलते हैं, strain बोले
as
कोई word
he
नहीं.
deserted his first wife and brought home the second wife Shantilata at the teeth of their opposition. No doubt, PW9 in para 5 of his cross-examination has stated that there was no ill feeling between the adoptive parents and the accused and his second wife. But his statement before the IO was otherwise, which has been discussed at length in para 15 supra. I therefore accept the version of PW1 that there was strained relationship between the deceased couple and the accused and his second wife Shantilata, and doing away with the adoptive parents is a shortcut point to get immediate access to their properties. 9. The essential ingredient to prove the guilty of the accused where there is no direct evidence are number 1. Next, my lord, the following circumstance point under the conclusion that the murder of the deceased couple was committed by the accused. Number 1. The deceased couple and the accused and his second wife, Shantilata, were the 4 persons present in the house in the fateful night. Number 2, the earlier plea of the accused as stated in the FIR, Exhibit 14, that the deceased couple fought and inflicted fatal injury on each other has not been substantiated as per the reason stated in paragraph 14 and 15, supra. Third, the second inconsistent plea of the accused that the person who has murdered his brother Prabhat have murdered the deceased couple has been discarded as per the reason given in paragraph 16 supra. There was strained relationship between the deceased couple and the accused after he brought home the second wife Shantilata.
এটা রিপিট হলা কি
রিপিট হলা
হ্যাঁ
The accused did not show any concern to ship the deceased Pitei to SC Medical College Cuttack for special treatment in spite of fact that she was referred to SC Medical College Hospital Cuttack by medical officer of Railway Hospital Jotani and
পোস্টমর্টম বেড়ে ছিল
the false and inconsistent plea taken by the accused and his absconding after the IO PW13 lost FIR.
So mainly, if we see that the main thing has been stated that it is a false plea, inconsistent plea, a type of
Yes.
So if you see the proposition of law, then that would be an additional circumstance. But এই যে ଆପଣ ବର୍ତ୍ତମାନ ଏକ୍ସକ୍ଲୁଡ୍ କରିଦିଅନ୍ତୁ ଏଇ ଯୋଉ ଫଲ୍ସ ପ୍ଲି ଆଉ ଇନକନସିଷ୍ଟେଣ୍ଟ ପ୍ଲିରେ କେତେଟା ଗ୍ରାଉଣ୍ଡ ସେ ନେଇଛନ୍ତି ଦେଖନ୍ତୁ 6 ନମ୍ବର ଗ୍ରାଉଣ୍ଡ ତାପରେ
Section 18 of the Evidence Act.
ସେଇଟା
Conduct.
6 ନମ୍ବର
Section 8.
ହଁ
Conduct.
absconding ଗଲା ତା ଛଡା ଏଇ ଯୋଉ ଇଏ ଇନକନସିଷ୍ଟେଣ୍ଟ ପ୍ଲି ଏଠି ମଧ୍ୟ ନିଆଯାଇଛି 3 ନମ୍ବର ଇନକନସିଷ୍ଟେଣ୍ଟ ପ୍ଲି ନେଇଛି आउ बाजी स्ट्रेन रिलेशनशिप गोटे एठी रहिला ताकू भी आउ गोटे नै आइछन्ती एठी
Paragraph 1.
आउ गोटे कोठी गोटे नै आइछि
No, no, paragraph 1 होची staying
Paragraph
together.
1 is the only circumstance
हां
Yes,
that they were in the same.
same house.
So the cause of death should have been known to them.
Yes.
same thing is also applicable wife fine
Wife ର defense plea କିଛି ନଥିଲା, inconsistent
defense
defense plea
ନଥିଲା।
ନଥିଲା।
Inconsistent not our defense that has not been put. କିନ୍ତୁ କଥା ହେଲା same house ରେ ତ ଥିଲେ।
Yes, same house ରେ ଥିଲେ।
question
ତାହେଲେ 106 ଟା କୁ ଯୋଉ ସେ
wife ମଧ୍ୟ absconding ହେଇ ନଥିଲା section 18 ନା section 8 ରେ ଯୋଉଟା ଧରିଛନ୍ତି ତାକୁ।
ପର ସବୁ all subsequent
106 ର discussion ही नाही
ହୁଁ।
106 एविडेंस आनिया को हेले जो आपण एक्सेस
Initial.
एटा को यदि रूल आउट कर दी
ताले yes।
ताले आसीयो आ किछि ये नै 106 रो ना वाइफ रो जजमेंट रे डिस्कशन हिछि ना आकु दिखे तेनु बाकी इनकंसिस्टेंटली लेट अस सी इट इज एक्सेप्टेड स्ट्रेन रिलेशनशिप इट इज एक्सेप्टेड तेनु इनकंसिस्टेंटली हेले आपण जो एडिशनल सर्कमस्टेंस हिसाब रे नेबे आउ स्ट्रेन रिलेशनशिप केते दूर हबो माने घर रोसई करी कि नहीं रहउछंती अलगा अलगा रोसई करी खाउछंती जोटा को से हाईलाइट करछंती कैन इट बी सच ए स्ट्रांग मोटिव टू कमिट द मर्डर but every
To get the property immediately.
cannot be considered as a motive for commission of murder of two persons both are elderly couple
Only motive is to get the property immediately. Only motive.
very that it's just
ନା ଆଉ ଗୋଟେ ବି ଡକ୍ଟର କୁ ବି ପଚରା ହେଲାନି ଯଦି ଇଣ୍ଟ୍ରା ଫାଇଟିଂ ହେଇ ହୁଏ ତାହେଲେ ଇଜ ଇଟ୍ ଦି ମ୍ୟାନର ଇନ ହ୍ୱିଚ୍ ଦି ଇଞ୍ଜୁରିଜ would be possible ଇଣ୍ଟ୍ରା ଫାଇଟିଂ ହେଲେ କଣ ଏତିକି ହବ ଏଇ କ୍ୱେଶ୍ଚନ ତ ଆସିନି ଏଟା ବି ତାଙ୍କୁ ପଚରା ହେଇନି ଆଉ ଧସ୍ତାଧସ୍ତି ବିନା ତ ହେଇପାରିବନି one will just stand and other one will stick it's not like that and as it appears the wife who is comparatively weaker than the husband seems to have inflicted injury on the husband who died first and that assault is brutal eta kemti hala
Husband is a strong person,
yes
person,
yes
but his age is 75.
maybe but he died first
He died first.
so question is you ifs and buts
But
ଭିତରେ
all the
surmise,
evidence is not
surmise, supposition ଏ ସବୁ ଜିନିଷ ଭିତରେ strong suspicion ତେଣୁ ତାକୁ evoke କୁ ଆମକୁ ଯାଇକି
But it is a case of double murder. Therefore,
number of murders is not a thing which can be even if suppose आपण चारटा मर्डर भी हेची circumstantial evidence होची lacking करची so that is not a ground that चारटा लोक मरजंदी आउ जा कले नाही ताकू आपणकर जेतिकी ड्यूटी अछि ताकू डिस्चार्ज करिवे तनु something whether it is lacking or chain टा कंप्लीट होची हमर दरकार चेन टा कंप्लीट होची आउ चेन टा एभली कंप्लीट होची जोठी there is no escape from the conflict.
and in this case, what happened in this case particularly, the accused first lodged an affair. The investigation proceeded in that light. So that's why there was
why there was sudden change आपण कहू नादी कोनटा आसिला हठात तानरे एफआईआर देला
say IO CW13 कहिसेंती during investigation it was written
आपण जेते वर्ष पर्यंत साक्षी नहीं आइले एग्जामिन करले
पोस्टमार्टम रिपोर्ट आसी कि ताकू एनालिसिस होला को जाना पड़तिबो
एनालिसिस आपण आनिबे ना हठात किमती आपण
से एई गुडाक जे अदर देन दिस आउ केही नो एटा सेठी भी आसीबार थिला that is how the turning point would have come in the investigation that having conducted the investigation in various angles nothing could be brought out that there is a chance of any third party intervention and that whereas the accused admitted that he was very much present at the scene of occurrence in the very spot house
स्विच ओवर करछन ना 4 मास पर हठात स्विच ओवर आपण सेमती कोजेंट रीजन आज माय एस्टीम ब्रदर इज पॉइंट आउट कोजेंट रीजन तो पुनी देबे कोन फाय आपण स्विच ओवर करले से लोकटा तो ऑल अलोंग प्रेजेंट अछि आपण पारे हॉस्पिटल को जाउची बापा को पोस्टमार्टम नेइकिनी माँ पाखु को भी आसुची घरे रहउची रिपोर्ट दउची कुआडे फेरा
खाली
जाउन
देखते
जो मोमेंट रे आपण एतला लेले जे नाही से पळिबो स्त्री टाको अरेस्ट कले ताकू तानारे एतला हेला जानला माने नॉर्मल पर्सन वुड abscond and absconding as you know it's a very weak piece of order तापरे एविडेंस आछि एंटीसिपेटरी वेल मूव होछि तापरे ये किनी से
खाली एति कथा ये कहले ऑन द बेसिस ऑफ इन्वेस्टिगेशन मेड बाय मी and the previous IO TSK Murthy and came to conclusion that the incident did not happen as reported by accused in his FIR Exhibit 14 but accused himself was the author of the crime for which I law FIR.
just a thing
से भी देला बेलको various circumstances could have come there.
हाँ से आनिबा कथा
Right,
डॉक्टर थारु आनिबा
yes,
कथा एटलिस्ट
Yes.
जे एई इंजुरीटा दी जन भितर माड लागले हबो नाही तेणु करी कि एटा केसटा जो अनुसार एफआईआर हेची आनिबा कथा cause of death homicidal and accused person and deceased were residing in the
same
in compact house.
there
If
was
this-
strained relationship
Yes,
also.
strained
So
relationship.
let us say that there was strained relationship
This part
how kon अछि
एतिकी तो
homicidal death number 1 they were staying together
And,
in two separate
strained
rooms.
relation.
And
Strained relationship,
strained relationship
inconsistent,
particular after this lady was brought they were in separate mess
and inconsistent
Please.
the
View.
plea which has
Okay.
been taken is inconsistent so FIR plea ku go by koruchi
Accused
how would a
statement.
plea type ro nouchi accused statement these are the things
yes.
yes so
से जेटा गोटे जेटा मैं कहूଥିଲି से कहले कंप्लीट करा भाई
hmm.
ट्रेन गोटे वार्ड एथे नाही
माने से आपण कहले
गोटे
Ill feeling अछि।
हाँ इल फीलिंग अछि अब जजमेंट रे बारंबार जो यूज होइछि जो स्ट्रेन रिलेशनशिप नाही रादर स्ट्रेन रिलेशनशिप यदि थांदा कोनसे ना कोनसे कहते जे दुईटा इंडिपेंडेंट विटनेस गोटे जदि सो कॉल्ड PW1 आ गोटे होछि से झियर भाई सेथरे से गोटे सेंटेंस छडा अन्य कार आनी प्रोसिक्यूशन इट इज द ड्यूटी ऑफ द प्रोसिक्यूशन टू एस्टैब्लिश दैट द्वितीय कथा हला ए जो रहिछि इनकन्सिस्टेंट इन प्ली प्रथमे से जो घटना घटी तार स्टेट ऑफ माइंड जहाँ ता माइंड जहाँ से लिखि दीछि एफआईआर सकाल सकाल भोर 4:05 बेले द्वितीय जेतबेले हेछि
कोन
Second-
ब्रह्म मुहूर्त
से खाली सब
नहीं नहीं से 4:30 रे घटना घटित
ब्रह्म मुहूर्त जहाँ ଆସିଲା ସେଟା ହଉଛି
ते गोटे साक्षी राति
ଈଶ୍ୱର ବାଣୀ ନା କଣ
गोटे राति गोटे साक्षी कही 4:30 रे उठिला बेलू जब ता स्त्री देखिछि से ता कही ये देखि कि दौड़ पुलिस स्टेशन
नहीं ता स्त्री उठिला क्षणी यांकु काहे देखिवाली आसिला
एफआईआर लिखाई सेति आ किछि त ना
हां सही प्रॉब्लम
हां तेणु से तार करथा
सबटा हाफ
से करथा से तो पछर भाबिछि हुए तो स्त्री तो आकुटाल ହେଇଛି से भाबि जेतले सेतल से भाबिछि स्त्री तो आकुटाल ହେଇଛି आ जहाँ ହେଇଛି ता मन आछि गोटे हुए तो मत भाई जे भाई तो मर्डर ହେଇଛି इट इज ए फैक्ट पछर ହେଇଛି ମଧ୍ୟ इन्वेस्टिगेटिव अफिसर को भाई जे मर्डर से भी मारि थाई पार से जानने किए मारिछि सेति भाई से कहिछि इनक्वेस्ट विटनेस पछर दिन केमिति घटना घटला से कहि मु कहि पारे से कथा कहिछि हेई पारे ताकु भीतर मरामरी हेई पारे अन्य केस लोक मारिछि किंतु अल्टीमेटली से मु जानि नै जानिथिले से अटकी थांदा कि कोन करथांदा ତେଣୁ ସେଇ ଯୋଉଟା କୁହାହଉଛି ଯୋଉଟା ଲର୍ଡ ସେସନ ଜଜ୍ ତାପରେ ଆଣି ଦେଲେ ଓନର୍ସ ପ୍ରୁଭ୍ କରିବାକୁ ଦେଲେ ସିଏ ତାର ଇନକ୍ୱେଷ୍ଟ ରହିଲା ସିଏ ପ୍ରୁଭ୍ କରିଥାନ୍ତା ପ୍ରୋସିକ୍ୟୁଟର ପ୍ରୁଭ୍ କରିଥାନ୍ତା। ଆଚ୍ଛା ଦ୍ୱିତୀୟ କଥା ହେଲା ଏ ଯୋଉ ଷ୍ଟ୍ରେନ୍ ଇଲ୍ ଫିଲିଂ ଗୋଟେ ତା ସ୍ତ୍ରୀ ଦ୍ୱିତୀୟ ସ୍ତ୍ରୀ ବାହାରିଲା ବୋଲି ସେଥିରେ କୋଉଠି କହିଲେନି ଯେ ଇଲ୍ ଫିଲିଂଟା କେବେ ହେଲା କୋଉଠି ହେଲା କଣ୍ଟିନ୍ୟୁ କରୁଥିଲା। ଯଦି ସ୍ତ୍ରୀ ଯଦି ଯାଇକିନି ସେ ରହିଛି ବହୁତ ଦିନ ଯେତେ ଦିନ ରହିଛି ସେ ଜାଣୁଛନ୍ତି 6-7 ବର୍ଷ ପରେ ତାହେଲେ ଇଏ ତା ମଝିରେ କଣ ଇଲ୍ ଫିଲିଂ ହେଲା କୋଉଠି ପାଟିତୁଣ୍ଡ ହେଇଥିଲା କି ଝଗଡ଼ା ହେଇଥିଲା ସେମିତି କୌଣସି ଜିନିଷ କୌଣସି ପ୍ରୋସିକ୍ୟୁସନ ଏଭିଡେନ୍ସ ଆଣିନି। ତେଣୁ ସେ ଇଲ୍ ଫିଲିଂଟା ଏମିତିଆ ଇଲ୍ ଫିଲିଂ ନୁହେଁ ଯୋଉଟା କି ମାନେ ଗୋଟେ ନେଇପାରେ ଗୋଟେ ହିନିୟସ୍ କ୍ରାଇମ୍ ଗୋଟେ ମର୍ଡର ଭଳିଆ ସେ ହେଇପାରେ ଯଦି ହେଇପାରେ
No, not because of that. This ill feeling could have also been proved through PW10.
ହଁ
There is nothing.
ସେଇଟା କରିନି ପିଡବ୍ଲ୍ୟୁ ତ ତା ଭାଇ ଯାହାର ଭାଇ
Why he has been brought in this evidence, we don't know.
ତେଣୁ ଇଟ୍ ଇଜ୍ ଦେୟାର ଡ୍ୟୁଟି ପ୍ରୋସିକ୍ୟୁସନ ଶିଫ୍ଟ କରୁଛି ଟୁ ପ୍ରୁଭ୍ ଯେ ମୁଁ ଆମେ ଆକ୍ୟୁଜ ପ୍ରୁଭ୍ କରିବା ଯେ ଆଇ ଏମ୍ ଇନୋସେଣ୍ଟ।
କାହିଁକି ଜାଣିଲେ କି PW10 ଟାକୁ purpose କଣ ଥିଲା PW10 କରିବାର? If to prove that there was a second marriage was there and there was ill feeling, strained relations, it was. Didn't come.
ସେ ଚାହୁଁଛନ୍ତି ମାନେ ଆକ୍ୟୁଜ ଡିଫେନ୍ସ ସିଏ ପ୍ରୁଭ୍ କରିଥାନ୍ତା ଯେ ସେ ଇନୋସେଣ୍ଟ ଏଟା କେମିତି ହବ ତେଣୁ ପ୍ରୋସିକ୍ୟୁସନ ପ୍ରୁଭ୍ କରିଥାନ୍ତା ତାପରେ ସେ ଘରକୁ ଯେତେବେଳେ ବାରବାର ଷ୍ଟେୟାର କେସ୍ର ଉପରେ ଛାତ ଅଛି କି ନାହିଁ ସେ କିଛି କ୍ୱେଶ୍ଚିନ୍ ନାହିଁ ଇଏ କଣ କରିବ ଆକ୍ୟୁଜ ଭିତରେ ଆକ୍ୟୁଜ ଯାହା ଆସିଲା ଏଭିଡେନ୍ସରେ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ସେଇଆ ପଚରା ହେଲା ସେ ସେଇଥିରୁ କହିଲା ତେଣୁ ତାକୁ ଦେବା ପାଇଁ ଡିଫେନ୍ସ ପ୍ଲି ଦେଇଦେବ କଣ ସେ ନିଜେ ଦବ ନିଜେ ଦେଲେ କଣ ତାର ବାହାରିବ କଥା ଡିଫେନ୍ସ ପ୍ଲି କହୁଛେ ଜେନେରାଲ ଦିଆ ହୁଏ।
Appellant was 40 years when you preferred the appeal. Now he's must be 65.
65 years, 66 years.
Where he is now staying?
He's there in that house.
Oh,
In that house.
He
Say room.
has been released on bail.
हाँ रेल हाई कोर्ट ऑनरेबल कोर्ट बेल चल गई से ट्रायल भीतर थिला ट्रायल पर ताको बेल देथिले
କେତେ ବର୍ଷ ରହିବ?
ଆଜ୍ଞା ସେ ହେଲାଣି 26 ବର୍ଷ ହେଲା 25 ବର୍ଷ ହେଲା ସେ ବେଲ
When the bail was granted?
throughout the trial he was inside.
Just a minute.
At the stage of admission, what I
No, at the very stage of admission.
admission पर
23/4/2001. अच्छा ଆପଣ ତା ସାଙ୍ଗେ କେମିତି କଥା ହେଲେ?
ସେ ସୁଦର୍ଶନ ତା ନମ୍ବରଟା ହେଲେ ମୁଁ କହିଲି ସେ କଥା ହେଲେ ଗୋଟେ ଘଣ୍ଟା ଭିତରେ ମୁଁ ତାପରେ ତାକୁ ଏତିକି ଖାଲି ପଚାରି
ସୁଦର୍ଶନ
ଗୋଟେ ସ୍ପଟ ମ୍ୟାପ ଆମେ ତିଆରି କଲୁ ଯେ ସେଇଥିରୁ ଜାଣିଲୁ ସେ ଦିଗ ଗୁଡା ଭୁଲ ହେଇଛି ଆଉ ପାଖ ଗୁଡା ନାହିଁ ଆମେ ଜାଣିଲୁ ସେ ବି ଏଠି ଅଛନ୍ତି ସୁଦର୍ଶନ ବାବୁ ବହୁତ ସମୟ ଦୀର୍ଘ ସମୟ
ନା ଠିକ ଅଛି। ତ
23/4/2021 ନା 1 କାରଣ କଷ୍ଟଡି
ଗୋଟେ ସେକେଣ୍ଡ ଏଥିରେ ଓରିଜିନାଲ ଏମିତି ଓକିଲ ନଥିଲୁ ଓରିଜିନାଲ ଓକିଲ
3/11/98 3/11/1998 to 2002 3 ବର୍ଷ
3 ବର୍ଷ ମାତ୍ର।
The person, the counsel who was conducting the case of this petition is A.
ମହାପାତ୍ର
No, A. Swine. ଲେଖା ହେଇଛି ନା ଆମେ ଏସଟି କେସଟା ଦେଖୁଛୁ ଏ ସ୍ୱାଇଁ ଲେଖା ହେଇଛି
ଏସଟି କେସଟା
ଏସଟି କେସଟା
ଏ ସ୍ୱାଇଁ ଲେଖା ହେଇଛି
ହାଇକୋର୍ଟରେ ଏମଆର
ଯାଇଥିଲେ ହାଇକୋର୍ଟରୁ ନାଁଟା ଲେଖା ହେଇଛି
ହଁ the
ଏମଆର ମହାପାତ୍ର
ଏଠି ୱାଇଫ ର କେସଟାକୁ ଆଇ ଥିଙ୍କ ଏସି ମହାପାତ୍ର ୱାଜ କଣ୍ଡକ୍ଟିଂ
ଏଠି ବି ଯାଇଥିଲେ argument contact.
I do not know, but the name has been contacted as A. Swai Advocate Associates. But both the public prosecutor is same and ये मध्य trial court मध्य same दीटा जाको judgment एका देइछन ये एटा हिची January 99 रे सीटा हिची August 2000
केवल 2 माइंड दुई जण माइंड सेट केवल
लेकिन अच्छी देखना ये स्वयं देखा है
yes ఇది కదా
नहीं इट मुझे हस्बैंड
ସେଟା ସବୁ କରିଦେବି ଏଠି ନିଶ୍ଚୟ ଏଭିଡେନ୍ସ ଏଠି ଏଭିଡେନ୍ସ ନିଶ୍ଚୟ ମେଥଡ ଆସିଛି ସେ ଭାବନା ଏଟା ତ ଦେଖିକି କରିଦେବି ଦେଖିଲେ captured and captured. My court is as far as court imagine the way कि भी सेट एक्सेस कर देंगे
ये जो ओवर मैटर
Did Mr. Sudarshan Behra, I am not available. Man. ମୁଁ କିନ୍ତୁ ପ୍ରକୃତରେ କୋଅର୍ଡିନେଟର କରିପାରିଲି ଏତିକି ଆଣିଥିଲି କରିପାରିଲି ତାକୁ ଆଣିପାରିଲି ଦେଇପାରିଲି ଠିକ ଅଛି ଥିବ ସବୁ ତ ଆଜିକାଲି ସବୁ ତ ଅଛି ତଥାପି ଦେଇଦେବି ତାର ଅଛି ସବୁ ଜଜମେଣ୍ଟ ଗୁଡା ସେଇ ଯୋଉ ପୁରା ନାନାବତୀ କେସ୍ ପାଖରୁ ଆରମ୍ଭ କରି ହାଉସିଂ କେସ୍ ସେଇ ଯୋଉ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ତାର ଯୋଉ ଲ୍ୟାଚେସ୍ ଯୋଉଟା ହଉଛି ସବୁ ଡିସ୍କସନ କରିଛି ସେଇ ଜିନିଷ ହଁ ସେଇଟା ହଁ ସେଥିପାଇଁ ମୁଁ ତଥାପି ହଁ ସେ ଶରତ କେସ୍ ସେଇ ହଁ ସେ ହଁ ଦେଖାଯାଉ ଭଲ କଥା